ಒಳ್ಳೆ ಇದು ಹಾಕೋದೇ ಇಲ್ಲ ಅಲ್ವಾ? ಬೇರೆ ಜಾಸ್ತಿ ಇದನ್ನ ಮಾಡೋದು ಫ್ರೀಕ್ವೆನ್ಸಿ ಅದು ಮಾಡೋದೇ ಇಲ್ಲ ಇದು. ಅಷ್ಟೇ 10:45 ಇಟ್ಬಿಟ್ಟಿದ್ರೆ ಸರಿಯಾಗಿದೆ. ಅದಕ್ಕೆ ನಾ ಏನಾಯ್ತು ಅಂತ ಡ್ರೈವರ್ ಅನೌನ್ಸ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ಅದೇ ಟ್ರೈನ್ ನಾನು ಇದ್ದಿದ್ದು.
ಪ್ಯಾಸೆಂಜರ್ಸ್ ಹೇಳಿ ಏನಾಗ್ತದೆ ಹೇಳಿ ಅಂತ ಅಂತವ್ರೆ. ಈಗ ನಾವು ಬೇರೆ ಹೋಗಿದ್ದೀವಿ ಸುಮ್ಮನೆ ಮಿಸ್ಲೀಡ್ ಮಾಡೋದಂತ ನಮ್ಮ ಸೆಕ್ಯೂರಿಟಿ ಹೇಳ್ಬಿಟ್ಟು ನಂಗೆ ಒಂಥರ ಕೇಳ್ಬೇಕಂತಾರ.
ಅದಕ್ಕೆ ನಾನು
ಇಂಟರ್ನಲ್ ಏನ್ ಗೊತ್ತಿಲ್ಲ, ಜಸ್ಟ್ ಒಂದು ಇಮ್ಯಾಜಿನ್ ಮಾಡ್ಕೊಂಡು ಲೈಫ್ ಹೋಗ್ತಾ
ಹಾಕ್ಕೊಡ್ತೀನಿ ಇರಿ. ಈಗ ಅರ್ಜೆಂಟಾ? ಇಲ್ಲ ನಂಗೆ ಗೊತ್ತಾಯ್ತು ನೀವು ರಜಾ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. ಯಾರನ್ನ ಒಳ್ಳೆ ಹಾಕ್ಸ್ಬಿಟ್ಟು 23rd ನಾನು ಸ್ವಲ್ಪ ಬೇಗ ಹೋಗ್ಬೇಕು. ಅದೇನ್ ಮಾಡ್ತೀನಿ ನೋಡ್ತೀನಿ. ಬೇಗ ಇದ್ರೆ ನಿನ್ ಕತೆ ಇಲ್ಲ ಅಂದ್ರೆ ನೀನ್ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗ್ತೀನಿ. ಇಲ್ಲ CL ಇದೆ ಅಲ್ಲ, CL ಇದೆ ನೆಕ್ಸ್ಟ್ ಮಂತು. ಇಲ್ಲ ಅದೇ 3 ದಿನ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಮಂತ್ ನನ್ನ ತಂಗಿ ಮಗ ಬರ್ತಾನೆ ಫಾರಿನ್. ಬಿಡಲ್ಲ ಅಯ್ಯಪ್ಪ ಖಂಡಿತ ಬಿಡಲ್ಲ. ಬಿಡಲ್ಲ ಏನಾರು ಮಾಡ್ಕೊಳ್ಳಿ, ನಾನು ಎಲ್ಲ ಎಲ್ರಿಗೂ ಹಂಗೆ. ಮಂಡೆ ಯಾರು ಇಲ್ವಲ್ಲ ಸಿಟ್ಟಿಂಗ್. ಕಥೆಗಳು ಬರ್ತಾರೆ. ಈ ಕಥೆ ಓದೋಷ್ಟೊತ್ತಿಗೆ
My lord, one matter for tomorrow. Trial court, please, my lord, I had filed 2 applications before the trial court, but the trial court passes on the one application, IA number 1, without looking into the IA number 2. Respondents, please, my lord, they have taken the bulldozers, have taken a photographs today, please, my lord, they are trying to change the nature of the property, please, my lord.
Yes, tomorrow.
Tomorrow, please.
Tomorrow.
ನಾಳೆ
Whereas RFA your honors. It's from 2011. Finally.
mentioning from page number 12, 33, 34 to 39, 40 to 45.
Serial number 30, my lords. We are for the appellate, my lords. My lords, the OS suit is posted for
Serial
judge.
number
30, my lords.
30.
Yes.
30 ಎಲ್ಲ ಆಮೇಲೆ ಈಗ ಯಾವ್ದು ಕೇಳಲ್ಲ.
40 to 45, 46 to 51.
That's serial number 49.
49 ಹೇಳಿ ಏನು?
I'm for the respondent in 49 and appellant in 49.1. So maybe listed next week. my lord. I've informed the other side.
ಅದರ್ ಸೈಡ್ ನರಸಿಂಹರಾಜುಗೆ ಹೇಳಿದಿರಾ?
I've informed him.
ಮಾಡಿದಿರಿ?
I've informed him. Yesterday itself I informed him.
Already informed or going to
Already
inform?
informed, my lords.
Already
Already
informed.
informed.
ನೋಡಿ, appellant counsel in MFA 4693 of 24 seeks time and also submit that already informed the other side counsel who appears in other appeal and list this matter. ಹಿಂದೆ ಎಲ್ಲ ಬಂದು 2 ಸರಿ ಟೈಮ್ ತಗೊಂಡಂಗಿದೆ, ಅವಾಗ ಯಾರು ತಗೊಂಡಿದಿರೋ ಗೊತ್ತಿಲ್ಲ.
Please, ma'am.
ನಾನು ಬರಲಿಲ್ಲ. ಪುಟಿಂಗ್ ಅಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತಿದೆ. ಆಯ್ತು, ಕೊಡಿ ಡೇಟ್ ಕೊಡಿ. 10-12.
Please, ma'am.
52 to 57, 58 and 59.
50? ಹೇಳಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 to 6 ಯಾರ ಗೌತಮ್ ಎಂ ಏನೋ ಶಶಾಂತ್ ಅಂತ ಏನೋ ಇದಾರೆ. ಎನ್ಒಸಿಗೆ ಯಾವಾಗ ಹಾಕಿದಿರಿ? ಏನೇ?
I am for the appellant. Urgency there. I request my lord, my learned friend, have it on 28th of this month. ಇಲ್ಲಾಂದ್ರೆ ಅವರು
ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಹರಿನಾ ಏನು?
Kesri.
K. Srihari submits that Wakalat is filed on behalf of R3 to 6 with NOC. And then today na yesterday. And then registry is directed to put up and show the name of the counsel and delete the name of Gautam M and Shashant Naik for R3 to 6. And the counsel for the appellant also present list this matter on 28/11.
problem.
60, 61. 62 to 65. 66 to 68. 69. List 1. Non-compliance for first time. Vivek Holla.
On behalf of the appellants, my lord, I seek for 2 weeks' time, my lord. I'll comply with the
And
officer.
counsel seeks 2 weeks' time to comply with office objections and hence 2 weeks' time granted as sought. What's the matter after compliance?
2.
Same order, my lord. It's,
Soon same, same. madam.
please, my lord.
Orders matter 3. PV Badrinath. Respondent.
Respondent.
Application.
BB Shivkumar.
ಹೇಳಿ ಏನು?
ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್
ಅವರು
sole
ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದಾರ ಇಲ್ಲ?
ಹಾಕಿದ್ದಾರೆ.
ಹಾ?
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದಾರೆ.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ಡ್ ಬೈ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದೆಯಲ್ಲ, ಏನ್ ಅವ್ರ ತಕರಾರೇನು?
ಅವ್ರ ತಕರಾರು ಏನಂದ್ರೆ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಫಾರ್ ಮಿಸ್ಲೇನಿಯಸ್ ಪಿಟಿಷನ್ Rule 13 ಇಲ್ಲ. Decree is in respect of first floor and second floor, not ground floor. Therefore, cause of action does not serve.
ಬ್ರಿಂಗಿಂಗ್ ಎಲ್ಲಾರ್ಸ್ ಏನ್ರಿ?
ಅದೇ ಅದನ್ನೆಲ್ಲ that is the objection.
ಏನಂತ?
ಅದೇ objection ಇನ್ನೇನಿಲ್ಲ.
Cause of action.
Cause of action ಇಲ್ಲ.
Whether it disputes the relationship.
ಇಲ್ಲ, totally
Pass over ಮಾಡಿ ನೋಡೋಣ, ಬರ್ಲಿ ಅವ್ರು ಬರ್ಲಿ ನೋಡೋಣ.
next week ಹಾಕ್ಬಿಡಿ. Next week.
So appellant counsel seeks time and counsel for the respondent is absent. If respondent counsel doesn't appear in the next date of hearing, IAS will be considered in his absence. First, appellant counsel seeks time, madam. Appellant counsel present ಅಂತ ಹಾಕಿ. Respondent counsel absent, will be heard in his presence. If list this matter on ಯಾವ ಕೊಡ್ತೀರಾ madam date?
2/12.
2/12.
4. Unikrishnan M.
Permission to post this appeal before division bench. Post the matter before the division bench
Please.
as sought. Permission ಅಂದ್ರೆ ಯಾರು ಆಫೀಸರ್ ಕೇಳಿದ್ರು? ಆಯ್ತು.
5. Chandana Tariga.
ತಾರೀಗ maintain out
Below 10
this appeal
lakhs.
since value of subject matter is below 10 lakh.
To be presented before the senior division, my lords. May be
Right.
permitted to withdraw and
Appellant
Liberty
counsel
to-
is permitted to withdraw the appeal and present the same before the appropriate forum.
the limitation aspect, my lord.
Yeah?
Limitation aspect, my
ಯಾವ
lord.
ವರ್ಷದ್ದು? 2020ದು.
2020.
ಇಷ್ಟು ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? 4 ವರ್ಷ. Maintainability office objections ಹಾಕ್ತಾಗ 4 years, why you kept the matter pending? And if appellant pleads regarding the delay is concerned to the and respond and the trial court has to consider the same. ಏನಾಯ್ತು madam? petition order filed under order 9 rule is allowed in view of 43 rule 1 of CPC.
But
Not yet recalled.
dismiss or non-prosecution ಆಗಿತ್ತು ಸ್ವಾಮಿ. Thereafter we filed an application for recall.
ಆ court ಅಲ್ಲೇನಾ?
ಆ court ಅಲ್ಲ ಈ court ಅಲ್ಲಿ.
ಅಲ್ಲ,
Huh?
ಇಲ್ಲಿ
In the original suit Malaz, it was dismissed on non-prosecution. Thereafter it was recalled.
Recall ಆಗ್ಬೇಕು.
And thereafter Malaz, we filed an application for LR.
Dismissal ಆಗಿದೆ already.
ಅಲ್ಲ appeal dismiss ಆಗಿದೆ, ಅದಕ್ಕೆ recall application ಹಾಕಿದೆ ಸ್ವಾಮಿ.
ಯಾವಾಗ ಅದು?
Malaz,
ಅದಕ್ಕಾಗಿ ಹಾಕಿದಾರ? ಹಾ. ಆಯ್ತು, ಅವಾಗ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರ? ಹಾ. Liability ಆಮೇಲೆ ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ಸ್. ಇದು ಮೋರ್ ದೆನ್ 10 lakhs ಅಂತ ಹೆಂಗ್ ಬರುತ್ತೆ ಮೇಡಮ್ ಇದು? ಮಿಸ್ಲೇನಿಯಸ್ ಮೇಲೆ ಡಿಸ್ಮಿಸಲ್ ಬಂದಿರೋದೇನ? ಮಿಸ್ಲೇನಿಯಸ್ ಮೇಲೆ ಬಂದಿರೋದೇನ್ರಿ?
ಹೌದು ಸ್ವಾಮಿ.
ಆರ್ಡರ್ 9
My application for bringing the legal representatives on record was dismissed. Thereafter I filed miscellaneous.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಆಗಿದೆ. ಇದೇನು ಬರೋದಿಲ್ಲ ಮೇಡಮ್. ಆರ್ಡರ್ 9 ರೂಲ್ 13 ಹಾಕಿದ್. ಆರ್ಡರ್ 9 ರೂಲ್ ಏನ್ರಿ ಇದು? ನೀವು ಪಿಟಿಷನ್ ಹಾಕಿದ್ದೇನ್ ಮಿಸ್ಲೇನಿಯಸ್?
Miscellaneous ಮೇಲೆ
ಯಾವ
order
ಪ್ರಾವಿಷನ್
43
ಹಾಕಿದಿರಿ?
Malaz,
ಯಾವ ಪ್ರಾವಿಷನ್ ರೀ?
order 43 Malaz.
ಇಲ್ಲಿ ಹೋದ್ರಿ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಹೇಳ್ರಿ ಅಂದ್ರೆ ನೀವು
ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ order 9 rule Malaz.
ಇಲ್ಲೆಲ್ಲ ರೆಫರೆನ್ಸೇ ಇಲ್ಲ ಅದಕ್ಕೆ. ಹ್ಮ್ ಅದ್ ಹೇಳ್ತಾರೆ ಬಿಡಿ, ಅದಾಗ್ತದೆ. ಇಲ್ಲಿ 10 ಲಕ್ಷ ಅಂತ ಹೆಂಗ್ ಬರ್ತದೆ? ಬಿಲೋ 10 lakhs ಆದ್ರೂ ಇಲ್ಲೇ ಬರ್ಬೇಕು. ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿರೋದು ಎಲ್ಲಿ ಇದು? ಇದಲ್ವಾ ಮಿಸ್ಲೇನಿಯಸ್ ಕೇಸ್ ನಂಬರ್ 2 of 2017. ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಏನ್ರಿ?
Malaz?
ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್?
ಹೌದು ಸರ್.
Order.
ಅಲ್ಲ ಜೂನಿಯರ್ ಡಿವಿಷನ್ Malaz.
ಸಿವಿಲ್ ಜಡ್ಜ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್
I have filed an
ಫಸ್ಟ್ ಕ್ಲಾಸ್.
ಹೌದು.
ಇದ್ರ ಮೋಸ್ಟ್ಲಿ ಇದ್ರ ಮೇಲೆ MA ಬರುತ್ತೆ ಅನ್ಸುತ್ರಿ.
ಹೌದು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಾನು
ಹಾ?
ಸೀನಿಯರ್ ಡಿವಿಷನ್ಗೆ ಬರುತ್ತೆ ಸ್ವಾಮಿ.
ಅಲೋ ಆಗಿದೆಯಾ ಮಿಸ್ಲೇನಿಯಸ್?
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಅಲೋ ಆಗಿದೆ. ಮಿಸ್ಲೇನಿಯಸ್ ಅಲೋ ಆಗಿ
ಮಿಸ್ಲಿನಿಯಸ್ ಅಲೌ ಆಗಿ ಮತ್ತೆ ನನ್ನ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್
ರಿಸ್ಟೋರ್ ಆಗಿದೆ.
OS ರಿಸ್ಟೋರ್ ಆಯ್ತು. ರಿಸ್ಟೋರ್ ಆದ್ಮೇಲೆ I file an application seeking to bring the legal representatives on record. That is dismissed.
ಅಲ್ರಿ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ರ ಆರ್ಡರ್ ಮಿಸ್ಲೇನಿಯಸ್ ಆರ್ಡರ್ ಅಲ್ವಾ? ಅಲೋಯಿಂಗ್ ದಿ
ಹೌದು ಸ್ವಾಮಿ.
ಅಲೋಯಿಂಗ್ ದಿ ಅಪೀಲ್ ರೀ.
ಹೌದು ಸ್ವಾಮಿ.
ನಾಟ್ LRs.
ಸಾರಿ. ಸೆಟ್ ಅಸೈಡ್ ಕರೆಕ್ಟ್. ಅಪಾಲಜೀಸ್ ಮ್ಯಾಮ್.
ನೀವು ಲಾಯರ್ ಕೆಲಸ ಮಾಡ್ಬೇಕ್ರಿ.
ಇಲ್ಲ
ಹಾ, ಕೋರ್ಟ್ನವರೆಲ್ಲ ಓದ್ಕೊಂಡು ಆರ್ಡರ್ ಬರೆಯೋದಲ್ಲ. ಯು ಹ್ಯಾವ್ ಟು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್.
ಮೈ ಅಪಾಲಜೀಸ್ ಮ್ಯಾಮ್.
ಯು ಹ್ಯಾವ್ ಬೀನ್ ಎಂಗೇಜ್ಡ್ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಯುವರ್
ಇಲ್ಲ,
ಮಿಸ್ಲೀಡಿಂಗ್ ದಿ
there is
ಕೋರ್ಟ್.
another matter Malaj, I got confused with that.
ನೋಡಿ ಮೋಸ್ಟ್ಲಿ ಮೇಡಮ್ ಇದು ಅಲ್ಲೇ MA ಬರುತ್ತೆ, ಅದಕ್ಕೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದಾರ ನೋಡಿ. ಏನ್ ಹೇಳಿ ವೆರಿಫೈ ಮಾಡಿದಿರಾ? MA ಬರುತ್ತಾ ಏನು?
ಎಮ್ಮೆನೆ ಬರೋದು ಸ್ವಾಮಿ.
ಆಯ್ತು, ಏನಾಯ್ತ್ರಿ? ಹಾಗಾದ್ರೆ ಮೊದ್ಲು ರಿಕಾಲ್ ಆಗ್ಬೇಕಾ?
ಹೌದು ಸ್ವಾಮಿ.
IS ರಿಕಾಲ್ ಆಗ್ಬೇಕು. ಹಾ ತಗೊಳ್ಳಿ. IS ಇಲ್ಲ ತೋರ್ಸೇ ಇಲ್ವಲ್ಲ ಯಾವ್ದು IS? ಅಪೀಲ್ ನಾಟ್ ಎಟ್ ರಿಕಾಲ್ಡ್ ಅಂತ ಹಾಕ್ಬಿಟ್ರು, ಬಟ್ IA ಪೆಂಡಿಂಗ್ ಅಂದ್ರು. ಯಾವ IS ಅಂತ ತೋರಿಸ್ಲಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿತ್ತಲ್ವಾ, ಆ IS ತೋರ್ಸ್ಬೇಕಲ್ಲ. ಇಲ್ಲೇನು ಡಿಸ್ಮಿಸಲ್ ತೋರ್ಸೇ ಇಲ್ಲ, ಅಲೌಡ್. ರಿಕಾಲ್ ಅಂಡ್ ಎರಡು ಇದೆಯಾ? ಡಿಲೇ ಇಲ್ವಾ? ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಹಾಕಿದಾರ ನೋಡಿ. ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಹಾಕಿದ್ರೆ ಡಿಲೇ ಬರಲ್ಲ. ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವಾಗ ಕೊಡಿ ನೀವು ನೋಡಿ. 1828 ನೆಕ್ಸ್ಟ್ ಏನ್ ಹಾಕೋರ? Heard the appellant counsel on IA 1 of 22, wherein prayer is sought to recall the order dated 1/8/22 and restore the appeal. And reason assigned that counsel was held up in another court and hence he could not appear on 1/8/22 and immediately on the very next day, this application is filed. And also this court given an opportunity to comply with office objections pending consideration of IA and the office objections are complied and hence IA is allowed and order has been recalled and restored the appeal. Now, ನೋಡಿ. ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ, ನಿಮ್ ಇನ್ನು maintainability permission ಕೊಡ್ಬೇಕು ಬೇಡ್ವಾ? The office has raised the objection regarding maintainability of this appeal as against the order dated 25/11/2019 passed by the Civil Judge Senior Junior Division and Judicial Magistrate First Class. And petition is also filed under Order 9 Rules 9 and the same was allowed. And appellant counsel also seeks permission of this court to withdraw this appeal and file a fresh appeal before the competent forum. And also request for the delay may be taken note of while filing the same before the trial court. And hence, if any such application is filed by the appellant before the trial court and consider the same, and with this observation, permission is granted to file the appeal before the appropriate forum.
Grateful.
6,
And full stop.
Prakash MH,
Non-compliance of office objection raised on process memo.
For the appellant, Lordship,
ಹೇಳಿ.
sets of ಇದು ಕೊಡ್ಬೇಕು sir.
5 sets ಏನ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಲ್ಲ.
I'll give it to your Lordship. Your Lordship, I may be permit to take notice on respondent number 1 to 3, your Lordship,
Counsel for the appellant
on the trial court advocate.
that going to pay the deficit copies. We issue notice to R 1 to 5 and also seeks permission of this court to serve the copy of this appeal memo on the counsel who appears on behalf of respondent number 1 to 5 before the trial court.
Your Lordship, 1 to 3, your Lordship, 4 to 5 were placed ex parte. In the next date, I'll file dispensation.
1 to 3 madri, 1 to 3 ಮಾಡಿ. The counsel also submits that R 4 and 5 are ex parte and going to file dispensation notice against them.
Lordship, our date may be fixed, your Lordship.
ಅಲ್ಲ ರೀ PFA ಕೊಡಲ್ಲ ಡೆಫಿಸಿಟ್ urgency
Within 3 days, I will
ಹಾ.
finish it.
and list this matter on 2/12. ಸರ್ವ್ ಮಾಡ್ಕೊ ಬನ್ನಿ.
Please, oblige, your Lordship.
And if deficit copies furnished, issue notice to R 1 to 5. R
Oblige.
to 3 ಮಾಡಿ ಸಾಕು.
Oblige, your Lordship.
7, Punit C,
Issue notice to respondent for third time.
May be permitted to take notice to the respondents,
ಹಾ.
paper publication.
3 times ಹೋಗ್ ಬಂದಿದ್ಯಾ?
ಎರಡು
ಸರಿ
ಸತಿ
ಆಗ್ತಾ
ಹೋಗ್
ಇದ್ರಾ?
ಬಂದಿದೆ, ಇನ್ಸಫಿಶಿಯಂಟ್ ಅಡ್ರೆಸ್ ಅಂತಾನೆ ಬರ್ತಾ ಇದೆ.
ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ. ವೆರಿಫೈ ಮಾಡ್ಬೇಕಲ್ಲ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಸರಿ ಇದೆಯಾ ಇಲ್ಲ ಅಂತ.
ಫುಲ್ ಕಾಸ್ಟ್ ಐಟ್ಲಿ.
ಬರ್ದವ್ರ ಯಾವ್ದೋ ಪೇಪರ್ ತಗೊಳ್ಳಿ. Appellant counsel files an application under Order 5 Rule 21A, praying this court to permit the appellant to take notice to the respondent by way of paper publication in Vishwavani, Bangalore edition. And for the reasons stated in the accompanying application and affidavit, IA is allowed and permitted to take out the notice against the respondent on or before
4/12.
4/12. And date of appearance of the respondent is fixed on
6/1/25.
6/1/2025. Please.
8, Shilpa Shah,
ಅಲ್ಲ ರೀ ಇಲ್ಲಿ ನಿಮ್ಗೆ ಆರ್ಡರ್ ಇತ್ತಲ್ವಾ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಲಾಸ್ಟ್ ಒಕೇಶನ್ 16/10 ಗಿತ್ತು, ಅವತ್ತು ಬರ್ಲಿಲ್ಲ ಅವರು, ಬರ್ತಾನೆ ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್.
ನೋಟಿಸ್ ಆನ್ ಕೌನ್ಸಿಲ್ ರೆಪ್ರೆಸೆಂಟೆಡ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾ ಇಲ್ಲ, ಇಂಜಂಕ್ಷನ್ ತಗೊಂಡ್ಮೇಲೆ ಫೋನ್ ಮಾಡಿದ್ರೆ ರೆಸ್ಪಾನ್ಸ್ ಇಲ್ಲ.
ಆಯ್ತು, ಹೋಗಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕು ಆಫೀಸಲ್ಲಿ. ಈಗ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಹಾಕಕ್ ದುಡ್ಡು ಎಷ್ಟಾಗ್ತದೆ? ಆಯ್ತು ಬಿಡಿ, ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು. ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF ಹೇಳಿ ಮೇಡಮ್.
I appear for the appellant.
Ah.
My lord, in this matter, my lord, respondent number 1 is served and
Madam, why you are not paid the PF and correct
my lord,
address?
2 and 3, my lord, we have served, my lord, to government advocate already.
And we have filed the memo to that effect, my lord. That we have
That
served
memo.
copy to
Memo
government.
ಹಾಕಿ ತಕ್ಲಾಂಡ್ for having served copy and learned AG on behalf of R2 and R3. ಏನ್ರಿ?
Please.
ಹಾ. AG ಅಂತ ನಾವ್ ಹೇಳಿದ್ಮೇಲೆ ನೆನಪಾಗದ ನಿಮಗೆ? ಯಾರ್ಯಾರದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್?
2 and 3, my lord.
2 and 3, arbitrator and special deputy commissioner 1. Assistant commissioner and competent authority, NHA. NHA ಈಗ ನೀವೇನ್ ಅಪಿಯರ್ ಆಗ್ತೀರೇನ್ರಿ?
ನಾವಲ್ಲ.
ಮತ್ತೆ assistant commissioner and competent authority ಅಂತ ಇದೆ.
ಅದಕ್ಕೆ
My lord, we will, my lord,
ಕಮಿಷನ್ ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿಗೆ ಅಪೇರ್ ಆಗ್ತದೆ.
my lord, that can be, my lord, dispensed with also because it's a formal party SLO.
You file a memo to dispense the notice.
Yes, my lord, I will file memo.
Sorry. The AGA takes notice for respond number 2. ಹೌದಾ?
Please.
And appellant counsel files memo to dispense the notice against R3.
Yes,
And hence notice against R3 is dispensed. ಏನಾಗಬೇಕು next? ಬರೀ steps ಗೆ ಇದ್ದಿದ್ದಲ್ಲ?
Notice.
my lord,
Post the matter for admission.
my lord, stay, my lord, may be granted.
Memo ಬರ್ದ್ ಕೊಡಿ. Admission ಗೆ ಬರ್ಬೇಕು matter.
Please.
List
Lord,
this
date
matter
will be
on
given.
2/12.
Memo I will give.
2/12.
Hmm.
9.
Awaiting service of notice to respondents. Non-filing of acknowledgement for having served copy on.
14/11.
File it today, my lord. We have served it to mail, my lord.
14/11.
We have paid the process,
Right,
upon the council, we have mailed it. my lord.
Notice. List this matter 14/11 ಅಂದ್ರೆ next 15/12. 15/12, 16/12.
Okay.
16. 10.
Issue emergent notice to R3, R5, R8, R10. Chetan Jadhav, ಹೇಳ್ರಿ.
But may I not make this submission?
Hmm?
So far as not these respondents, unserved respondents are concerned, they may be deleted.
ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ ಯಾರ್ಯಾರು ಡಿಲೀಟ್ ಮಾಡೋದು. ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡೋದ ಡಿಲೀಟ್ ಮಾಡೋದು?
ಎರಡು ಮಾಡು.
ಹಾ?
ಎರಡರಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಮಾಡ್ಬೋದು.
ಎರಡರ ಹಂಗ್ ಮಾಡಕ್ಕಲ್ಲ. Deleted from the list of respondents.
R3,
Appellant does
R5,
not wish
R8.
to press any action against them. ತಗೊಳ್ಳಿ. The appellant counsel files memo to delete the respond number 3, 5, 8, 10, 13, 15, 18, 27 and 39. Since they are not pressing any relief against them. And hence memo is accepted and deleted the above respondents in the appeal. The appellant counsel is directed to amend the same in terms of this memo. File amended cast title.
But for admission, my lord, may I request you lot to kindly have it day after tomorrow.
No,
There is some urgency in the matter.
list this matter next week alaglar kodri.
Monday, my lord.
Monday no sitting.
27.
27/11. So meanwhile, first you amend the cast title and file amended.
Today
cast
only
title.
will do it.
Huh?
Today only will do it.
11. Rakesh King.
Counsel submission with regard to office subsection violations they filed before trial court to be filed for the verification of jurisdiction as per 19.
No violation slip before trial court was, before the trial court violation slip was not filed, my lord. This is a petition for guardianship of a minor child. So in that there was no violation slip that was needed. That has not been filed. So
The
office has-
counsel submits that this appeal is filed against the order of. ಏನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರ್ರಿ?
Order 9, Rule 9 application reject.
Order 9, Rule 9.
ಹೌದು.
ಮತ್ ಗಾರ್ಡಿಯನ್ಶಿಪ್ ಅಂತ ಏನ್ ಹೇಳ್ತೀರಿ?
Main petition guardianship, ಅದರಲ್ಲಿ violation slip ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿ office objections ಇರೋದು. ಅದು petition was dismissed for non-prosecution. I filed application under Order 9, Rule 9. That was rejected. That is why I filed MFA.
ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಯಾರು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋದು ಯಾವ್ದು? ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್.
Family court passed.
ಈಗಲೇ ಬರುತ್ತೆ. ಇಸ್ಲೇನೇಸ್ JNWC 7/23. ಇಲ್ಲೇ ಬರುತ್ತೆ. ಮೇಂಟೈನಬಿಲಿಟಿ ಏನ್ ಬರುತ್ತೆ ಮೇಡಮ್? ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದಾರೆ, ಅದೇನ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಲ್ಲೇನ್ರಿ?
ಹೌದು, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಅದಕ್ಕೆ ನಾನು Order 9, Rule 9 application ಹಾಕಿದೆ. ಅದು ರಿಜೆಕ್ಟ್ ಆಯ್ತು. ಸೇಮ್ ಡೇ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
Dismissed for non-prosecution.
ಹೌದು.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ರಿ, ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರೆ, ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರೆ.
ಹೌದು.
ಹಾ,
ಅದಕ್ಕೆ ಆರ್ಡರ್ 9 ರೂಲ್ 9 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು.
ಅಲ್ಲಿ ಹಾಕಿದ್ರಾ?
ಹೌದು.
ಅದ್
ಅದು
number-
ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
ಅದೇನಾಯ್ತು?
ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
ನೀವು ಈಗ ಇಂಪ್ಯೂಂಟ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಯಾವ್ದು ನೀವು?
ಆರ್ಡರ್ 9 ರೂಲ್ 9 ಅಪ್ಲಿಕೇಶನ್.
ಆರ್ಡರ್ 9 ರೂಲ್ 9?
ಹೌದು.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್? ಇಲ್ಲ ಅದು ಸೇಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರಾ?
ಸೇಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್.
ಅದೆಲ್ಲಿದೆ ಆರ್ಡರ್? ಆರ್ಡರ್ 9 ರೂಲ್ 9
ಪೇಜ್ ನಂಬರ್ 14.
ಅಪ್ಲಿಕೇಶನ್ ಮಾತ್ರ ಹಾಕಿದಿರಿ, ಆರ್ಡರ್ ಕಾಪಿ ಎಲ್ಲಿದೆ?
ಪೇಜ್ ನಂಬರ್ 14.
ಪೇಜ್ ನಂಬರ್
14.
14.
Ink page 14. 16 to 2024.
So, the council submission with regard to office objection is accepted since this MFA is filed. Dismissal of application filed under order 9 rule 9 of CPC. Post the matter for admission
On date may kindly begin.
on 2/12.
12 ಅಶೋಕ್ ಜೀವಿ.
Date may kindly begin.
2/12 ಕೊಟ್ನಲ್ರಿ.
For the appellant in this case.
Address etc. issue emergent notice. ಹಾ ಹೇಳಿ.
Lord, I have tried to serve them by hands, but we are not able to trace them. Therefore, we serve through post also, my lord.
The case for R1. In memo, you know, what is that memo? You are appearing for R1?
R1 to R3.
Hmm?
I have once again taken the notice again. to the-
RPD.
Please, ma'am.
Receipt acknowledgement early.
I have filed today, my
You
lord.
sent it to whom, madam?
R1 to,
Advocate or parties?
earlier it was for the advocate, my lord, for the, now it is for the
Why
respondent.
you have sent it, madam? Order is through court.
Please. By hand it was
Order is
issued.
through court.
By hands it was issued, my lord.
And ilva ಎಲ್ಲಿದೆ hand summons ಇದೆಯಾ ನೋಡಿ madam?
We received the hand summons, therefore.
Furnishing of PF correct address etc. to issue emergent notice ಅಂತಿದೆ.
That was also carried out, my lord, subsequently. Along with that, the same was also carried out. Hand summons was also issued to them.
Hand summons order ಇದೆಯಾ ನೋಡಿ.
ನೋಡ್ತಾ ಇದ್ದೀನಿ.
Hmm? 1 to 12.
The acknowledgement with respect to R1 is also filed on 15/11/2024, my
The
lord.
council has filed memo stating that hand summons taken to the respond number 1 to 12 through post. ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಕಳ್ಸಿರೋದು?
My lord.
And the same was sent on
14th of November, my lord.
14th of November. 15th
Apologies, my lord, 15/11,
15th November.
Please, my lord.
And yet to receive the acknowledgement. The memo is taken on record.
My lord, one submission.
What about PF?
I'll make the requirements today itself, ma'am. Regarding 15/11 memo, R1 has taken the summons and the notice of the appeal, my lord. Through.
I pay for R1, my lord.
R1 already appear ಆಗ್ತಾ
It
ಇದಾರಲ್ರಿ?
was ordered 1 to 12, my lord. That's why we had taken again, once again, the steps against them.
2 to 12 ಆಗ್ಬೇಕಿತ್ತು. 13 also ಇದಾರಾ? ಇಲ್ಲ.
Illa, madam.
But you have already sent it through 1 to
Registered.
12 also. ಆಯ್ತು ಅದಿರ್ಲಿ ಬಿಡಿ. Already they are on record. But why you have not paid the PF and correct address ಅಂತಿದೆ? ಹಿಂದೆ ವಾಪಸ್ ಹೋಗಿ ಬಂದಿದೆಯಾ ಮೇಡಮ್?
ಹೌದು ಸರ್, ಇದು ಸೆಕೆಂಡ್ ಟೈಮ್.
Petitioner counsel also submit that going to pay the PF to issue emergent notice through court against R2, R4, R7 and R10.
Please.
What about R3, R5 and 6?
ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ? ಮತ್ತೆ ಇಲ್ಲ ಮತ್ತೆ 2 to 12 ಅಂತ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಯಾಕೆ ಮತ್ತೆ? ಈಗ ಹಾಕಿರೋದು ಅಷ್ಟೇನೆ ಅದು. ಈಗ ಹಾಗಾದ್ರೆ ಓನ್ಲಿ 2, 4, 7 and 10 ತಗೊಳ್ಳಿ ಮೇಡಮ್ ಅಷ್ಟೇ. Others have been served.
My lord, interim order may be extended. Interim order may be
Yeah.
extended. Please, my lord.
Interim order granted earlier is extended till next date of hearing. List this matter on
ಕರೆಕ್ಟ್.
10, 12. 13, Puneet C. Value of the appeal as stated at valuation para as per copy of sub-registrar guidelines for the purpose of jurisdiction. ಹೇಳ್ರಿ ಏನಿದೆ?
The valuation office has accepted the valuation, please.
ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ವ್ಯಾಲ್ಯೂ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆಯ್ತು ಗೊತ್ತಾಯ್ತು. ಹೇಳ್ರಿ, ನೀವೇನ್ ಪ್ಲೀಡ್ ಮಾಡಿರ್ತೀರಿ ಅದ್ ಮಾತ್ರ ಅಪ್ಲೈ ಆಗೋದು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಈಗ ಇಲ್ಲಿಂದ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ತಗೊಳಕ್ಕಾಗಲ್ಲ.
My lord, what has happened, please, my lord? I have also made a request to the trial court advocate
You am-
file a fresh valuation slip.
ಅಲ್ಲಿ ಹಾಕಿ
Yes,
amend
ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, ಅಲ್ಲಿ ಹಾಕಿ ಏನ್ ಹೇಳ್ತೀರಾ, ನೆನ್ನೆ ಅಡ್ವಾನ್ಸ್ ಮಾಡಿ ನೆನ್ನೆ ಅವ್ರ
ಡೇಟ್
ವ್ಯಾಲ್ಯೂ
ಬೇಕಾ ಈಗ?
ಹಾ?
ಡೇಟ್ ಬೇಕಾ?
ನಾಳೆ ಅಥವಾ ನಾಡಿದ್ದಕ್ಕೆ ಹಾಕೊಳ್ಳಿ, ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
ನೋಡಿ, appellant seeks time. This matter on 26/11.
Monday, if I may request.
26/11, Monday, no sitting, Tuesday.
Please.
14, office objection raised on PF to furnish 12 sets of correct appeal copy. ಇಲ್ವಾ?
ಫರ್ನಿಶ್ ಮಾಡ್ತೀನಿ ಮೇಡಮ್,
ಅವಾಗ
ಇವತ್ತೇ ಮಾಡ್ತೀನಿ ಮೇಡಮ್.
the counsel submits that he is going to comply with office objection today itself. If furnished, issue notice to R1 to 12. ಇದು ಇನ್ನೊಂದ್ರಲ್ಲಿ ಏನೋ await
Waiting
ಇದೆಯಾ?
ಇದೆ ಮೇಡಮ್, awaiting
And and await notice in other connected matter. List this matter on 10/12. 10/12. ಈಗ ಆಲ್ರೆಡಿ ಇಶ್ಯೂ ಆಗಿದೆಯಲ್ಲ, ಅವರು ಕೊಡ್ಬೇಕಲ್ಲ. ಇನ್ನು ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಿ. 16/12, 10 ಬಂದು 16/12.
15.
Mahesh and company acceptance of wakalat filed in respect of R4 since notice not ordered. ಆಯ್ತು, wakalat is accepted for R4. Maintainability of the appeal against order dated 89/24 passed by the
one number submission
letter on IA number 21 in CMP. ಹೇಳ್ರಿ.
ಇದರಲ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್ ಮೇಲೆ ಬಂದಿದೆ. We have challenged the partial award, rejection of partial award passed by the honorable single arbitrator. Now officer says the objection has got the maintainability. So we are withdrawing with the permission to file before the honorable commercial court. ಅಲ್ಲಿ ಬರುತ್ತೆ ಅದು.
Before the
Commercial court ಅಲ್ಲಿ appeal ಆಗುತ್ತೆ.
ಆಯ್ತು ತಗೊಳ್ಳಿ. Appellant counsel seeks permission of this court
Sorry.
by filing memo with liberty to approach the commercial court.
Commercial court.
And hence permitted to withdraw with liberty as sought in terms of the memo. ಆಯ್ತು.
Obligation.
60.
ಇದು ಯಾವ್ದ್ರದ್ದು?
ಅದೇ connected to
Sub
serial number
registrar.
13. ಹೌದು.
ಖಾತೆ ಕೊಟ್ವಿ 26.
26/11.
26.
It
Appellant
may be
counsel
tag
seeks time.
ಮಾಡು.
ಹಾ?
Tag ಮಾಡು.
ಎರಡು ಸೇಮ್
ಹೌದು, IA number 2 and 3 ಮೇಲೆ.
ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ಕಾಮನ್ ಆರ್ಡರ್.
ಕಾಮನ್ ಆರ್ಡರ್ ಅಲ್ಲ, ಡಿಫರೆಂಟ್ ಆರ್ಡರ್ ರೈಸಿಂಗ್ ಸೇಮ್ ಸೂಟ್.
ಇರ್ಲಿ ಅವತ್ತೇ ಬರ್ಲಿ, ಒಟ್ಟಿಗೆ ಬರ್ಲಿ.
Please.
ಬೇರೆ ಬೇರೆ ಬರ್ಲಿ. Next, Mani Patil PS.
Not I pay, no, I may
Ah.
permitted not to convert this into CRP, not, but is.
Conversion, The appellant counsel seeks permission of this court to convert the same as
Sorry.
CRP na?
No, CRP.
CRP, and hence permitted to convert the same as CRP and for the statistical purpose MFA is disposed
Make-
of.
80.
Permitted to make necessary corrections and
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ.
ಈಗ ಇಲ್ಲಿ ಮಾಡಕ್ಕಲ್ಲ, ಆಫೀಸಲ್ಲಿ ಹೋಗಿ ಮಾಡ್ಕೋಬೇಕು.
ಆಯ್ತು.
ಅದಿನ್ನು ಕನ್ವರ್ಟ್ ಆಗ್ಬೇಕು, CRP ಆಗ್ಬೇಕು.
ಆಯ್ತು.
ಆಮೇಲೆ ಅವ್ರ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡ್ತಾರೆ. ನೋಡಿ.
80.
And for the appellant in.
Yes, madam.
Your
On
lordship,
amendment of cast title in appeal in respect of disease R10, with order 15/2.
I'll do it now itself. I'll carry out amendment.
Pass over ಮಾಡ್ಬೇಕಾ?
ಇವಾಗ್ಲೇ ಮಾಡಿ. Your lordship amended.
Pass over. Why
amended
you are not
appeal.
done from February to 20, this day, madam?
I apologize, your lordship. Even I'm filing
Aye,
amended
pass over,
cost.
pass over.
Please.
90.
Next.
AP Pulakeshu.
My lord, in this case, my court has
ಅದ್ರಲ್ಲಿ ಏನ್ರಿ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲೂ ಕೂಡ ಸಚಿನ್ BS ಇದಾರಲ್ಲ, ಅವ್ರದ್ದೇನು? ಅದೇ ನಾನ್ ಫರ್ನಿಶಿಂಗ್ PF ಕವರ್ ಯಾವಾಗ?
ಅದು amendment.
ಅದು ತೊಗೊಳ್ಳಿ. ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ. ಅದ್ರಲ್ಲೂ ಅಮೆಂಡ್ಮೆಂಟ್ ಇದೆ, ನೀವು ಮಾಡ್ಬೇಕು. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್.
In this case, my lord, this honorable court directed me to
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆಫ್ ಕೌನ್ಸಿಲ್ ಆನ್ ರೆಕಾರ್ಡ್ ಬೈ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಅಪಲೆಂಟ್ ವೈಡ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 15/10. ಹೇಳಿ.
my lord, in this case, my 2 weeks time required, my lord, another, because I have instructed the party, my lord, he is verified, my lord. Subsequently,
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ seeks another 2 weeks time. Yes, 2007 matter ಲೇನ್ರಿ?
please, my lord,
ಡಿಸ್ಮಿಸಲ್ ರಿಕಾಲಿಂಗ್.
recalling, my lord, in view of the death of the council on record, my lord.
ಕೌನ್ಸಿಲ್
matter-
ಯಾವಾಗ ತೀರ್ಕೊಂಡಿರೋದು ಅಂತ ಕೇಳಿದೆ.
ಅದಕ್ಕೋಸ್ಕರ, my lord, I have instructed the party to get the
ಅದರ್ ಸೈಡ್ ಇದಾರ?
other side ಇಲ್ಲ, my lord. ಅಲ್ಲಿ ಏನಾಗಿದೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಡೆತ್ ಮಾಡಿ ಅವ್ರ ಆಫೀಸ್ ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಂಡು ಮನೇನು ಎಲ್ಲ ಶಿಫ್ಟ್ ಮಾಡ್ಕೊಂಡು ಎಲ್ಲ ಹೋಗಿದಾರಂತೆ. ಇವನ್ ಐ ಆಮ್ ಸರ್ಚಿಂಗ್ ಇನ್ ದ ಬಾರ್.
ಆಯ್ತು, 2 weeks ಕೊಡಿ, ಡೇಟ್ ಕೊಡಿ.
10/12.
10/12.
ಓಕೆ
20.
Non amendment of cast title and non filing of amended cast title.
My lords, amended
Full
cost,
appellant wide order
amended
dated
cost
date,
title
madam.
has been filed.
Huh?
Amended cost title has been filed this morning, my lord.
Why you are not amended?
Will kindly pass over, my lords.
10-10-24, 4-11-24, 4, ಯಾವಾಗ ನಾವು ರಿಕಾಲ್ ಮಾಡ್ತೀವಿ ಆರ್ಡರ್ ಅಂದಾಗ ಇವತ್ ಬಂದಿದ್ದೀರಿ ಪಾಸ್ ಓವರ್. ಹಾ
21.
Non-compliance of office objections
As I
raised
assure for the respondent,
on
may
IA 1
kindly
of
pass over.
23, compromise petition not signed by all the parties and seal not affixed in both wakalat.
I appear for the respondents, my lords. May kindly pass over, my lords. The appellant
Yes,
counsel
pass
is
over,
not-
pass over.
22.
22, non-filing of acknowledgement for having paid the cost of ₹500 by advocate for
Needful
appellant
done,
with
Your
order dated 4/11. ಕೊಟ್ಟಿದ್ದೀರಾ?
Needful.
Appellant counsel submits that cost is paid.
Submission. On the previous date of hearing, there was a direction to the council to amend the cost title.
Amended the cost title.
That objection was
ಏನ್ರಿ ಅದು? ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀರಾ?
Amendment ಮಾಡಿದ್ದೀನಿ.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರೇನ್ರಿ?
ಕಟ್ಟಿದ್ದಾರೆ,
ಕಾಸ್ಟ್ ಮೇಲೆ
ಹಾಕಿದ್ದೀನಿ.
₹500 ಅಲ್ಲ ಕಟ್ಟಿದಾರ? ಈಗೇನ ಕೊಟ್ರದ ಅಕ್ನಾನ್ಮೆಂಟ್ ಇದೆ, ಮೋಸ್ಟ್ಲಿ ಅಮೆಂಡೆಡ್ ಇರ್ಬೇಕು.
500 rupees.
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಕಾಸ್ಟ್ ಹಾಕಿದೀವಿ. ಈಗೇನ್ ಇದು ಕಾಸ್ಟ್ ಕೊಟ್ರದ್ ಇದು? ಆಯ್ತು, ರಸೀಟ್ ಕೊಡ್ಬೇಕಲ್ಲ. Appellant counsel submits that he has paid the cost and also amended the cost title and also filed amended cost title. ಅದು ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೀನಿ.
Post the matter for ಏನಾಗಬೇಕು?
not received the copy. Not received the copy.
ಒಂದ್ ಕಾಪಿ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ.
I will give the copy.
And
I
the appellant
request it-
counsel is directed to furnish the copy of the amended appeal memo on the other side. List this matter on final hearing.
Fourth,
Final hearing.
finally,
ಯಾವಾಗ ಬೇಕು?
fourth ಕೊಡಿಸು.
4/12. ಆಯ್ತು.
23.
23 hearing interlocutory application.
Hearing for the respondent. Filing.
ಏನಿದು? Days in filing.
Directions of this honorable court plan, we have filed the RTA information application to BDA to produce the JP Nagar 6 plan, whether this the suit property acquired or they dropped the proceedings.
ಆಯ್ತು, ಏನಾಯ್ತು?
That is the lad, we have filed the memos and the along with the RTA information documents. Lad.
Same
We
submission.
will seek
Same submission was
10
made
days
last time.
time for producing this document. Lad. 10 days time. Lad.
My lord,
Producing the plan.
Whether they have replied to your letter?
Reply to my letter. Lad.
ಏನಂತ?
Or 10 days ಅಲ್ಲಿ we will give the
We
information.
will give ಅಂತ ಕೊಟ್ಟಿದಾರಾ? ಆಯ್ತು.
my lord, your lordship, may kindly see the order. Last time also they said they were making the submission that memo is also not.
ಆಯ್ತು
served on-
ಮೇಡಮ್, ನೀವ್ ಹೇಳ್ದಂಗೆಲ್ಲ ಕೆಲಸ ಮಾಡಲ್ಲ
ಇಲ್ಲ
ಅಲ್ಲಿ.
ಮೆಮೋನ ಕೊಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ, ನೋಡಿ ಆರ್ಡರ್ ನೋಡಿ, ಲಾಸ್ಟ್ ಟೈಮ್
ಏನಂತ?
Last time.
Already- They have already applied alva.
No, they have not given me the memo.
Filed a memo along with the document, learned counsel for respond number 1 and 2 submit that copy is not served on
They
him.
are not serving the
Aven
copy.
copies ಕೊಡ್ರಿ memo
Open
ಹಾಕಿರೋದು.
court, sir.
They have given me commissioner's objections to the commissioner's report, not the memo.
What the learned counsel for the appellant is directed to serve the copy of the memo along with the documents ಅಂತ ಇದೆಯಲ್ರಿ. Last time ನೀವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದೀವಲ್ಲ.
ಹೌದು, ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
Copy of the memo along with the documents to the learned counsel
Lad,
for
I
respond
filed
number 1 and 2
the,
forthwith.
I filed the objections to the commissioner appointed by the son of.
ಬ್ಯಾಡ್ರಿ,
Along with the documents.
ಮೆಮೋ ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅದ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ.
Yes.
ಕೊಡಿ, ನೀವೇನ್ ಮೆಮೋ ಹಾಕಿದ್ರಿ ಅದ್ ಕೊಡಿ ಅವ್ರಿಗೆ, ಕಾಪೀಸ್ ಕೊಡಿ ಅದರ್ ಸೈಡ್ಗೆ.
So I will.
ಫೈಲ್ಡ್ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ರಿ, ಆ ಕಾಪೀಸ್ ಯಾಕೆ ಸರ್ವ್ ಮಾಡ್ಲಿಲ್ಲ ನೀವು?
ಲಾಸ್ಟ್ ಟೈಮ್ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಹೇಳಿದ್ರು, ಯಾರ್ದು ಸಿಗ್ನೇಚರ್
ಏನ್ ಕೊಟ್ಟಿದಾರ ಕೊಡ್ರಿ ಮೇಡಮ್ ಮೆಮೋನ.
ಸಿಗ್ನೇಚರ್ ಯಾರ್ದು ಹೊಡೆದಿದ್ದಾರೋ ಗೊತ್ತಿಲ್ಲ, ನಮ್ಗೆಂತೂ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
ಅದೆಲ್ಲ commissioner report, I have served the copy.
ಲಾಸ್ಟ್ ಟೈಮ್ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದಾರೆ ನೋಡಿ, ಅದೇನು ಅದು.
I will serve copy.
ಹಾ?
One copy is there, I will serve.
ಕೊಟ್ಬಿಡಿ. ಅವ್ರು ಅದೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾರೋ ಸೈನ್ ಮಾಡಿದಾರೆ, ಸೈನ್ ಮಾಡಿರೋದು ಅವ್ರು ನಮ್ ಸೈನ್ ಅಲ್ಲ ಅಂತ ಏನೋ
ಹೌದು, ನಮ್ದು ಇಲ್ವೇ ಇಲ್ಲ ಅದು.
ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರಲ್ವಾ?
ಹೌದು, ಇಟ್ಸ್ actually I must say,
ಕೊಡಿ ಅಂತ ಮಾಡಿದ್ವಿ.
I must say it is a fourth signature, my lord.
Commissioner report documents ಕೊಟ್ಟೆ ಅವತ್ತನೇ ಕೋರ್ಟಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೆ.
ಹೇಳಿದ್ದು ಕೇಳ್ರಿ ಫಸ್ಟ್.
Yes.
ನಾವು ಕಮಿಷನರ್ ಬಗ್ಗೆ ಮಾತಾಡ್ತಾ ಇದೀವ. ಮೆಮೋ ಹಾಕಿದ್ರಿ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ರಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ಅದನ್ನ ಕೊಡಿ ಅಂತ ಆಫೀಸ್ ಕೋರ್ಟಲ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
I will give.
ಮತ್ತೆ ಅದೇ ಪದೇ ಹೇಳ್ತಿರಲ್ಲ, ಆಗಿಂದ ಹೇಳ್ತಾ ಇದ್ವಿ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಫೈಲ್ ಮಾಡಿದಿರಾ, ಅದ್ರ ಕಾಪೀಸ್ ಕೊಡಿ ಅಂತಂದ್ರೆ ಕೊಡಕ್ಕಾಗಲ್ಲ, ಒಂದು ಬೇರೆ ಏನೇನೋ ಹೇಳ್ತೀರಿ.
May I, my lord, submit, my lord.
ಪಾಸ್ ಓವರ್ ಫಸ್ಟ್ ಕೊಡಿ. ಈಗಲೇ ಕೊಟ್ರಾ?
ಈಗ copy ಒಂದು xerox
ಕೊಡಿ, ಕೊಟ್ರೆ ಡೇಟ್ ಕೊಡ್ತೀನಿ, ಇಲ್ಲವ್ರಿಲ್ಲ. ಮಾರ್ನಿಂಗ್ ಬೆಳಗ್ಗೆ ಎದ್ದು ದಿನಕ್ಕೆ 100 ಬರೀ ಈಗ ರಿಪೇರಿ ಕೆಲಸನೇ ಇರುತ್ತೆ, 1.5 ಗಂಟೆ ಬರೀ ಬೇರೆ ಕೆಲಸನೇ ಆಗಲ್ಲ. ಅದ್ರಲ್ಲೂ ಮತ್ತೆ ಈ ತರದ್ದು ಸಬ್ಮಿಷನ್ಸ್. ಪಾಸ್ವರ್ಡ್ ಕೊಡಿ, ಕಾಪೀಸ್ ಕೊಡಿ ಆಮೇಲೆ.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಕೊಟ್ಟಾಯ್ತಾ ತಗೊಳ್ಳಿ. ದ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ರಿಸೀವ್ಡ್ ದಿ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಫೈಲ್ಡ್ ಅರ್ಲಿಯರ್ as directed by this court. And also counsel for the appellant seeks 10 days time to produce the document. And hence this matter, 2 ವಾರ ಬಿಟ್ಟು ಕೊಡ್ರಿ.
ಫೈನಲಿ ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಟೈಮ್ 2 weeks ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ.
4/12.
4/12.
24 ಸಂಪತ್ ಎ.
Permission to prosecute the appeal.
For respondents, your lordship.
A1 to A16. Head. Illu appellant counsel illa?
No, your lordship. Filed an IA for injunction, your lordship. Respondents filed an IA for injunction.
Well, appellant counsel is absent.
On the previous occasion also, your lordship.
Kodi in the order sheet kodi. And in the previous occasion also he was absent.
He is present here.
For the petition.
Finally, 2 weeks time granted to file objections to A1 of 24 ಅಂತ ಇದೆಯಲ್ಲ, ಯಾರು A1 of 24 ಯಾರು ಹಾಕ್ಬೇಕು?
By respondents, your lordship.
ನೀವು ಹಾಕಿದಿರೇನ್ರಿ?
ಹಾಕಿದಿ sir.
ಯಾವಾಗ?
Long back.
Objections are not filed within 2 weeks, the same will be taken as no objections to A number 1 of 24 ಅಂತ ಇದೆ. ಏನದ A1 of 24?
For injunction, your lordship. Injunction. When the said
ಸರಿ, ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಹೇಳ್ರಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್?
24 September, your lordship.
My lords, IA1 of 24 is filed by the respondent. I am for the appellant, my lords.
Who has to file objections to IA1 of 24?
I have to file, my lords.
ಹಾಕಿದಿರಾ?
I have not filed, my lords. The application that is oral objections, I am ready to submit. My lords,
ಹೇಳಿ ಏನದು?
there's already a sale deed, my
The
lords.
order is very clear. If the objections are not filed within 2 weeks, the same will be taken as no objections to A1 of 24 ಅಂತ. ಹೇಳಿ ಏನು?
My lords, IA1 of
ಏನ್ ಪ್ರೇಯರ್ ಕೇಳಿದ್ರಿ ನೀವು?
Your lordship, when the matter was pending, they have sold the said scheduled property to some other person. The said GPA holder has sold it to his wife and other friends. So to stay that further proceedings, your lordship.
Further alienating.
Yes, your lordship.
Pendency of this appeal, property was sold.
Yes, your lordship.
ಹೇಳ್ರಿ.
My lords, purchaser is not party in the case. Purchaser, my lords, is not a party. My lords, kindly see, my lords, the relief sought for, please to stay the absolute sale deed executed before the sub-registrar so and so. And my lords, restraining purchasers from further alienating. My lords, purchasers are not party. in this.
Purchaser ನ ಪಾರ್ಟಿ ಮಾಡ್ದಲ್ಲಿ ಹೆಂಗ್ರಿ alienate restrictions ಮಾಡಕ್ಕಾಗುತ್ತೆ?
The said GPA holder has sold it to his wife, your lordship.
ಸರಿ, ಇಂಪ್ಲೀಡ್ ಮಾಡಿ ಅವ್ರನ್ನ.
Yes, your lord.
Implede ಮಾಡಿ, then you seek relief. That's all.
Okay.
My lords, in this, my lords, there's a, the probate has been obtained by the respondent. My lords, without making the appellants as party, my lords. I filed an application, my lords, seeking leave to appeal. And that application is also pending consideration.
ಏನ ಸಿಡಿ ಬೇರೆ ಇದೆ, ಡಿಲೇ?
My lords, condonation of
Objections
delay,
has
my
been
lords,
filed,
delay
your
could not arise. my
A1
lords.
of 23 ಹಾಕಿದಿರಾ?
Hakidis.
Objections.
Yes, your lordship.
That's, I was not made a party in the probate proceedings. I came to know the order of the probate only, my lords, when they came to the property, my lords. And the respondent, my lords.
No, your lordship, they are not at all a party to this one. The said-
ಅದಕ್ಕೆ that's why they came before this court for cancellation of the.
it was not at all required, your lordship. That said testator was so
ಅಲ್ಲ ರೀ, ನೀವು probate ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಅಲ್ಲಿ ಫಸ್ಟ್ ರಿಲೀಫ್ ಕೇಳ್ಬೇಕಲ್ವಾ?
And
Oh, you can come directly to this court.
My lords, I have a right of appeal, my lords, that's why I filed it.
lordship, in the previous occasion, they were supposed to produce additional documents telling that they are the actual legal heirs of the testator, but they are failed to produce the same thing.
ಅಲ್ಲ, ನೀವ್ ಈಗೇನ್ probate ಕೊಟ್ಟಿದ್ದಾರೆ,
Probate has been given.
ಅದನ್ನ ಕ್ಯಾನ್ಸಲೇಷನ್ ಕೇಳಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಅಲ್ಲೊಂದು ಅಯ್ಯ ಹಾಕೊಂಡು ಇದನ್ನ ಸ್ಟೇ ಕೇಳ್ಬೇಕಲ್ವಾ?
My lords, I'll just verify the legal
but-
aspect. I'll verify that legal.
Unless that probate is cancelled, how you can seek the relief before this court in MFA?
My lords, I'll just verify the legal aspect, my lords. I thought an appeal could be filed against the order of.
Instead of filing appeal, you can seek for the filing by filing a fresh proceedings.
I'll verify that. my lords.
Seeking for cancellation of probate granted,
My lords,
wherein you can file an application and get it stay the order. ಇದ್ ಮಾಡ್ಬೇಕು ನೋಡಿ, ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ. ನನಗಿರೋ ನಾಲೆಡ್ಜ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ.
I'll also verify.
You
Weeks
examine.
time.
Third. The appellant counsel seeks time. And counsel for respondent is present, list this matter. ಯಾವಾಗ ನೋಡಿ ಡೇಟ್ ಕೊಡಿ, 2 ವಾರ ಬಿಟ್ಟು ಕೊಡಿ. 5/12.
Much obliged.
25. Shankraj KG.
Respondent.
I am
Give
appearing
the
for the
nomination,
appellant,
I
my
may be permitted to file,
We have 278 days.
I may permitted to file, no, ವಕಾಲತ್ in the office.
ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, ನಿನ್ನೆ ಫೈಲ್ ಬಂದಿಲ್ಲ.
ಕೌನ್ಸಿಲ್ ಶ್ರೀ
BM ಕುಶಾಲಪ್ಪ.
P.
BM ಕುಶಾಲಪ್ಪ.
Kushalappa, BM Kushalappa submits that he is going to file wakalat in the office today, na?
Today.
Today itself. If wakalat is filed, show the name of the counsel for respondent. And also given 2 weeks time to file objections to IA 1/24 and list this matter on the other date code. 10/12.
Obliged.
56.
IA 6/23 for direction filed by counsel
Respondent
for
1 to
RA.
3 months.
Recalling the order dated 79, ಏನ್ರಿ ಅದು recalling the order?
Lordship, one submission. All these applications may be taken along with main matters.
ಅಲ್ಲ ಏನು recalling order ಏನದು?
Recalling the earlier there was an order, interim order passed by this honorable court, ಅದನ್ನು recall ಕೇಳ್ತೀವಿ.
ಅದನ್ನ interim
ಹೌದು.
order ನ recall ಆ?
ಹೌದು.
Huh?
It may be taken up for final hearing, my lords,
I
along
suppose
with these
counsel submits
applications.
that matter may be heard on the main appeal. And IS can be considered along with main appeal and hence, ಏನ್ ಆರ್ಡರ್ ಆಗಿರೋದು? ಇಂಪ್ಲೀಡಿಂಗ್ ಅಲೋ ಆಗಿದೆಯಾ? 79/14. ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆನ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
One submission, my lords.
Aye.
Learned counsel for appellant, my lords, LS Krishna is no more.
ವೆಂಕಟಕೃಷ್ಣ
ಹೌದು, ಅವ್ರು
ಅವ್ರು ಬರಲ್ಲ, ಬೇರೆ ಯಾರು ಹಾಕಿರ್ಬೇಕಲ್ಲ?
ಇಲ್ಲ
ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ
ವಕಾಲತ್ ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ, ಅವ್ರು ಏನು ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಗೊತ್ತು.
ಅಲ್ಲ, 5th ನೀವಿದ್ದೀರಿ.
ಈ-
ಇಲ್ಲಿ
one-
LS ವೆಂಕಟಕೃಷ್ಣ was appearing for A1,
One
A2C,
AC,
A2, A2C,
ಹೌದು.
A1, A2 and A3 ಇದ್ದಾರೆ. ಅವ್ರಿಗೆ ಮತ್ತೆ ಯಾರು ತಗೊಳ್ಳಿ. ದಿ ಕೌನ್ಸಿಲ್ LS ವೆಂಕಟಕೃಷ್ಣ ಇಸ್ ನೋ ಮೋರ್. ನೋಡಿ ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ವೆಂಕಟಕೃಷ್ಣ ಜೊತೆ ಯಾರ್ದಾರು ಸೈನ್ ಇದೆ ನೋಡಿ, ಅವ್ರ ಹೆಸರನ್ನೇ ತೋರಿಸ್ಕೊಡೋಣ.
Yes, ma'am.
ಬೇರೆಯವ್ರ ಕೊಲೀಗ್ಸ್ ಇದ್ರೆ ವಕಾಲತ್ತಲ್ಲಿ ತೋರ್ಸೋಣ.
ನೋಡ್ತಾರೆ.
ವಕಾಲತ್ ಹಾಕ್ದಾಗ್ಲೇ ಇರುತ್ತೆ ನೋಡಿ, ಅಪೀಲ್ ಹಾಕ್ದಾಗ ಅವರೇ ಮೋಸ್ಟ್ಲಿ ಒರಿಜಿನಲ್ ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇರುತ್ತೆ. ಆರ್ ವಿಜಯ್ ಕುಮಾರ್ ಫಾರ್ A4 ಇದಾರೆ ಅವರು.
A4 ಗೆ ವಿಜಯ್.
NOC. ನೀವಾ?
ನಾವು A6.
A6, A5 ಇದಾರೆ. A4 ವಿಜಯ್ ಕುಮಾರ್ ಬಂದಿಲ್ವಾ? ಆರ್ ವಿಜಯ್ ಕುಮಾರ್ ಇಲ್ಲ.
ನೋಡ್ತೀನಿ ಸರ್, ಫಸ್ಟ್ ಹಾಕಿದವರು ಬರೀ ಆರ್ ಗೋಪಾಲ್, ಆಮೇಲೆ ಇವ್ರದ್ದು ವಕಾಲತ್ ಸಿಗ್ತಾ ಇಲ್ಲ, ನೋಡ್ಬಿಟ್ಟು
ಮಾಡ್ತೀರಾ? ಆಯ್ತು ತಗೊಳ್ಳಿ. The matter may be heard on merits and hence list this matter on 10/12 and counsel for A5 submits that he is going to intimate the colleagues of LS Venkatakrishna who appears for A1, A2C and A2, A2C.
57.
Dependent appellant, my lord.
Respondent plaintiff.
Cancellation of revenue entries.
I have filed this application,
Hmm.
my lord, for cancellation of the entries made by the appellant. My lord, the appellant is the defendant in the trial court. During the pendency of this appeal, my lord,
A copy serve ಮಾಡಿದಿರಾ?
I have served the copy and he has filed the objection. My lord, on the last occasion, my lord, your lordship had directed, my lord, that now the parties are governed by the principles of Muslim law, my lord. Now, my lord, in the plaint, I have clearly stated that, my lord, in the plaint, it is a suit for declaration and injunction, declaration and possession of the property. My lord, the suit is filed and suit is decreed. My lord, this honorable court, my lord, remanded the matter back to the trial court to find out an issue whether the appellant who is the defendant in the trial court claims the property as gift. My lord, now the trial court has negated that issue and said that there is no oral gift between the parties and the plaintiff is the absolute owner of the suit schedule property. Now, my lord, during the there is no declaration given by the High Court saying that he has become the obsolete. He has now mortgaged the suit schedule property, and the mortgagee, the bank has taken over the possession of the property now. He has mortgaged the suit schedule property for 37 lakhs. On the last occasion, my lord, I had also filed an application before this honorable court. He had mortgaged the property, same property, for 12 lakhs. Now he has again mortgaged the property for 37 lakhs, my lord. Now I have,
Very same bank.
yes, my lord.
Hmm.
Now
Why you did not give objections to the bank when the advance of rupees 12 lakhs?
I had no notice about this possession when they have.
12 ಲಕ್ಷ ತಗೊಂಡವನೆ ಅಂತ ಗೊತ್ತಾಯ್ತಲ್ಲ ಅವಾಗ
Immediately we filed an application before this honorable court, my lord, that.
Before this court?
Yes, my lord.
ಹೇಳ್ರಿ ಏನ್?
My lord, the original suit itself was not maintainable.
Huh?
It was the original suit which is under challenge, the order challenge in challenges before this court was not maintainable at all. It was hopelessly time barbell. The cause of action.
ಆಯ್ತು, ನೀವ್ ಹೇಗೆ ರೆಕಾರ್ಡ್ಸ್ ನ ನಿಮ್ಮ ಹೆಸರಿಗೆ ಮಾಡಿಸ್ಕೊಂಡ್ರಿ?
No, ಅದು ತಪ್ಪು. ಅದು ಒಪ್ಪುತ್ತೆ. ಯಾಕಂದ್ರೆ ನಾವು come on through NOC this year only. But he should not have done. But the
ಅದನ್ನ ರಿಕಾಲ್ ಮಾಡೋಣ. That's all. Now application is only for direction to cancellation of revenue entries.
My lord, the
suit maintain ಆಗುತ್ತೋ ಇಲ್ವೋ, they are entitled for relief, ಅದೆಲ್ಲ ನೋಡೋಣ ಆಮೇಲೆ.
My lord, at the stage of final hearing, he has raised this objection.
ಆಯ್ತು.
And this is have been filed after 37 years long.
ಆಯ್ತ್ರಿ, how you got the records in your name when you have suffered the decree? This is an appeal filed by you.
Oh, stay was there. Stay was granted by this honorable court against execution. But whereas he has filed execution 2 times.
On what basis you got the transfer the property in your name?
No, nowadays, now, my lord, the getting loan is very easy. And he had some 2-3.
Getting loan easy ಅದಾಗ್ಲಿ ಬಿಡಿ, ಆ ಸ್ಟೋರಿ ಇವೆಲ್ಲ ಬೇಡ. ನನ್ನ ಪ್ರಶ್ನೆಗೆ ನೀವು ಉತ್ತರ ಕೊಡಿ ಅಷ್ಟೇ.
He was compelled because he is fighting this litigation for the last 44 years. Since 1980.
You are arguing other things. You are not answering to my question. What is the basis for transfer of the property in your name when the
I am admitting, my lord, he should not have availed the loan without the knowledge of this, without getting the approval of this from this court. I am agreeing that. But the thing is, the order which is under challenge before this honorable court, the case itself was not maintainable.
ಕೈಯ ಜೊತೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನ್ ಹಾಕಿದಿರಿ?
My lord, I have filed the encumbrance certificate and the encumbrance certificate and the photograph.
ನೀವು ರಿಲೀಫ್ ಕೇಳಿರೋದು cancellation of entries in the revenue records, ಹೌದಾ?
Encumbrance ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅಯ್ಯೋ 1/24. ಅಯ್ಯೋ 1/24 ಎಲ್ಲಿದೆ ಮೇಡಮ್? ಡೈರೆಕ್ಷನ್.
He had filed one application in 22 also. He has not pressed for it also, my lord.
Lord, the encumbrance certificate is along with the application. I have filed an encumbrance.
Encumbrance certificate ಬಿಡ್ರಿ, ದಾಖಲೆ ಎಲ್ಲಿದೆ? ನೀವು ಅವ್ರ ಹೆಸರಿಗೆ ಮಾಡಿಸ್ಕೊಂಡಿರೋದು ಅದು ತೋರಿಸಿದ್ರೆ ಬೇರೆಲ್ಲ ಮಾತಾಡ್ತೀರಾ?
A photograph.
What is the relief you have sought in the prayer? ಅಯ್ಯೇ.
For cancellation of the.
Cancel the revenue entries and restore the original name of the respondent number 1 as the owner of the property ಅಂತ ಬರ್ದಿದ್ದೀರಿ.
ಅಲ್ಲ, encumbrance certificate ಕೊಟ್ಟಿದ್ದೀನಿ, photographs ಕೊಟ್ಟಿದ್ದೀನಿ. ಬ್ಯಾಂಕ್ ಅವರು IFSL
ಅವ್ರ ಹೆಸರಿಗೆ ದಾಖಲೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಎಲ್ಲಿದೆ ರೀ ತೋರಿಸಿದ್ರೆ ಬರೀ encumbrance certificate ಮಾತಾಡ್ತೀರಿ.
ಅಲ್ಲ, encumbrance certificate shows that now he is at serial number 3, my lord.
ನೀವು ಬ್ಯಾಂಕ್ ಲೋನ್ ಅಲ್ಲಿ ತಗೊಂಡಿರೋ ಬಗ್ಗೆ ಮಾತಾಡ್ತಾ ಇದ್ದೀರಾ, ನಿಮ್ ಎಂಟ್ರೀಸ್ ಬಗ್ಗೆ ಮಾತಾಡ್ತೀರಾ?
ಅದ್ರ ಫೋಟೋಗ್ರಾಫ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಜೊತೆ.
ಅವ್ರ ಹೆಸರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆದ ದಾಖಲೆ ಹಾಕಿದಾರೇನ್ರಿ?
ಅಲ್ಲ, encumbrance certificate ಅಲ್ಲೇ ಬರುತ್ತೆ ಅದು, ಬೇರೆ ಯಾವ್ದು ಬರಲ್ಲ.
List this matter after 2 weeks.
ಅಲ್ಲ, 2 weeks ಬೇಡ ಸ್ವಾಮಿ.
You are not answering to the court question. List this matter on 5/12. ಬೆಳಬೆಳಗೆಲ್ಲ ಬರ್ತೀರಿ ನಮ್ ಜೀವ ತಿನ್ನಕ್ಕೆ. ಕೇಳಿದ ಕ್ವಶನ್ ಆನ್ಸರ್ ಕೊಡೋದಿಲ್ಲ ನೀವು. ಅದ್ನೇ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನ್ರಿ, ನೀವು ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಬಡ್ಕೋತೀರಲ್ರಿ. Where are the documents for having transferred the property in their favor ಅಂತ ಕೇಳಿದ್ರೆ ಆನ್ಸರ್ ಮಾಡಕ್ಕಾಗಲ್ವಾ? ಮತ್ತೆ
ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಅಲ್ಲಿ ಏನು ಇರ್ತದೆ? ಮ್ಯೂಟೇಷನ್ ಕೊಡಿ.
ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಶೋಸ್
BBMP ಪ್ರಾಪರ್ಟಿ ಇದು.
ಮ್ಯೂಟೇಷನ್ ಆಯ್ತು, ಖಾತಾ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ರಿ.
ಅವ್ರ ಹೆಸರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿರೋ ದಾಖಲೆ ತೋರಿಸಿ ಅಂತಂದ್ರೆ ಅದ್ ಬಿಟ್ಟು ಬೇರೆ ಎಲ್ಲ ಮಾತಾಡ್ತೀರಾ ನೀವು?
ಟ್ರಾನ್ಸ್ಫರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ, ರೆವೆನ್ಯೂ
ಕೇಳಿದ್ರಿ, ಅದ್ರ ಬಗ್ಗೆ ಹೇಳ್ರಿ ಇದ್ರೆ ದಾಖಲೆನ ಇನ್ನೇನ್ರಿ?
BBMP
ಆಯ್ತು, ಖಾತಾ ತಂದು ಕೊಡಿ. ಟ್ರಾನ್ಸ್ಫರ್ ಖಾತಾ ತಂದು ಕೊಡಿ.
ಏನ್ ಹಾಕಿ ಅಲ್ವಾ ನೀವು?
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ. ಅವ್ರೆ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಇದ್ದಿದ್ನ ಅವ್ರ ಹೆಸರಿಗೆ ಮಾಡಿಸ್ಕೊಂಡು ದಾಖಲೆ ತೋರಿಸಿದ್ರೆ ಬೇರೆ ಎಲ್ಲ ಮಾತಾಡ್ತೀರಾ? ಈಗ ಹಾಕಿದೀರಾ ಅಯ್ಯ ಜೊತೆ? ಇಲ್ಲೆಲ್ಲೂ ನನಗ್ ಕಾಣ್ತಾ ಇಲ್ಲ, ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದೀನ್ರಿ. ಪಾಸ್ ಓವರ್.
Transfer of ಖಾತಾ. BBNP property.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ. ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಬೈ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ R124.
ಆಮೇಲೆ ಬಿಡೋ.
ಹಾ.
Suit as a plea.
KV ಸತೀಶ್ ಇದಾರಾ? ಇಲ್ಲ. Heard on A1/24 for early hearing. And this is the matter of the year 2011 and already a decade has elapsed. And hence for the reasons stated in the accompanying application, IA is allowed. List this matter for final hearing.
For an application not to alienate. They are trying to alienate B-share property.
ಎಲ್ಲಿದೆ ಅದು? IA
Number 2.
not to alienate IA ಅದು ಬಂದಿಲ್ವಲ್ಲ? ಪೇಪರ್ ಬುಕ್ ಯಾಕೆ ಹಾಕಿಲ್ಲ? ನೀವು ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಕೇಳ್ತೀರಿ, ಪೇಪರ್ ಬುಕ್ ಯಾಕೆ ಹಾಕಿಲ್ಲ?
ಅವ್ರು ಹಾಕ್ಬೇಕು, ನಾನಲ್ಲ. ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬೇಕು.
ಅಪಲೆಂಟ್ ಅವ್ರದಾ ಅಪೀಲು? ಹಾ. ಎಲ್ಲಿದೆ ನಿಮ್ಮ IA ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
IA/2/22.
ಇದೆಯಾ ಮೇಡಮ್?
24.
ಇದೆ.
ಹಾ 24. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ ಅದರ್ ಸೈಡ್ ನೋಡಿ.
ಇನ್ನೊಬ್ಬರು ಒಂದು ಪ್ರಾಪರ್ಟಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಇವರು ಮಾಡ್ತಾ ಇರೋದು.
ಯಾರನ್ನ ರಿಸ್ಟ್ರೈಂಟ್ ಆರ್ಡರ್ ಕೇಳಿದ್ರಿ? ಯಾರ ಅಗೇನೆಸ್ಟ್? ಕಾಪಿ ರಿಸೀವ್ಡ್. The appellant counsel and the respondent counsel has filed an application under Order 39 Rule 112 of CPC. Praying, restrain the appellants and their representatives, alienating, encumbering or creating any charge on the suit shall property pending disposal of the above appeal. And copy is also served on the, ನೀವೇನ್ರಿ?
28.
ಹೇಳಿ. ಹಾ. ಈಗ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರೆ IA 2/24 ಗೆ. Copy was received on 31/7.
ಹಾಕಿಲ್ಲ ಸರ್, ಯಾಕೆ?
ಹಾ. ಹಾ. ನಾಟ್ ಏನೇಟ್ ಕೇಳಿದಾರೆ, ಮಾಡೋಣ ಆರ್ಡರ್ ಅಷ್ಟೇ. ಪೆಂಡಿಂಗ್ ಅಪೀಲ್. And copy is served on the other side on 31/7/24 and till date not filed the objections and relief is also sought not to alienate the same till the disposal of the appeal. And for the reasons stated in the accompanying application and affidavit, IA is allowed restraining the appellant in alienating or encumbering the property as sought till the disposal of the appeal. This the matter for final. Paper book ಯಾಕ್ರಿ ಹಾಕಿಲ್ಲ?
ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿತ್ತು ಸರ್ ಲಾಸ್ಟ್.
ಯಾವಾಗ ಆಗಿದೆ ಹೇಳಿ?
ನಾವು ಇನ್ವೆಸ್ಟ್ ಹಾಕಿರೋದು ಬಿಫೋರ್
Not much, only thing is.
Suit for partition.
Partition, there is no dispute about the fact that the property.
2015 ಅಲ್ಲಿ 14 ಅಲ್ಲಿ ಅಡ್ಮಿಟ್ ಆಯ್ತು. ಹಾ ಆಯ್ತು. ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿಲ್ಲ ಅಲ್ರಿ ಯಾವಾಗ್ಲೂ?
ಬಿಫೋರ್ ಅಪಿಯರ್.
ಹಾ.
Only question is, they set up a bill, they are not proved by examining witnesses, that's all. That is the only ground. Short ground, it can be.
ಆಯ್ತು. ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡೋಣ. ಪೇಪರ್ ಬುಕ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ ಮೇಡಮ್? Filing of paper book is dispensed in suit is for the relief of partition. This matter for final hearing date code 10/12. 10/12. Next.
29. Somshikara came.
Non-filing of receipt for having paid the cost of rupees 2,000. ಹೇಳಿ. Paid. The appellant counsel submits that cost of rupees 2,000 is paid today. ಏನಾಗ್ಬೇಕು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಏನ್ ಹೇಳಿ? LIC 2014. ಏನ್ ಅಪೀಲ್ ಇದು? AG ನಿಮಗೆ ನೋಟಿಸ್ ಆಗಿಲ್ಲನ್ರಿ?
ಆಗಿದೆ ಮೇಡಮ್.
ಆಗಿದೆಯಾ?
I received a copy, that's all.
MA not filed ಅಂತೇನೋ ಇದೆ. ಹೇಳಿ ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನ್ ಹೇಳಿ? ಅಡ್ಮಿಷನ್ ಈಗ ಡಿಸ್ಮಿಸಲ್ಗೆ ಅಂತ ಇಟ್ಟಿದ್ವಿ, ಅಡ್ಮಿಷನ್. Cost not paid and if the learned counsel for the appellant doesn't argue the matter on the next date of hearing, the matter will be dismissed. ಹೇಳಿ ಏನ್? ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲಲ್ಲ ಮೇಡಮ್? ಆಗಿದೆಯಾ ನೋಡಿ? ಅಥವಾ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಈಗ ಬಂದು ಬರ್ಲಿಲ್ಲ ಅಂತ ಕಾಸ್ಟ್ ಹಾಕಿದೀವ ನೋಡಿ. ನೋಡಿ ಹೇಳ್ರಿ ನೀವೇನ ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ ಏನು ಅಂತ?
ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ?
Admit
ಹಾ,
ಆಗಿದೆ.
ಹೇಳಿ ಏನು? ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತಲ್ಲ, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಆಮೇಲೆ
ಇದೆ records ಇದೆ.
ಬಂದಿದ್ಯಾ?
ನಾಳೆ ಎಲ್ಲ ಮಂಡೆ ಹಾಕೊಳ್ಬೋದು.
ಕೊಡಿ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. 2014
6/12.
6/12. ನೀವು ನೋಡ್ಕೊಳ್ರಿ ಅಷ್ಟರೊಳಗೆ ಪೇಪರ್ಸ್ ತರ್ಸ್ಕೊಂಡು ನೋಡಿ.
Observation can be removed.
ಯಾವ್ದು?
It is failed to argue the matter.
ಆಗೋಯ್ತಲ್ಲ, ನೀವು ಬಂದು ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಿ ಅಂದ್ರೆ ಆಗೋಯ್ತಲ್ಲ, ಇನ್ನೇನು?
ಬರ್ತಾನೆ ಇರುತ್ತೆ.
ಏನಂತ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಬರಲ್ಲ, ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಅಂತ ಮಾಡಿದೀವಲ್ಲ. ಅಡ್ಮಿಷನ್. ಹಾ,
Parted in here. Admission matter 30. Chandrasekhar Patil.
ಹ್ಮ್
pending in the trial court, my lord, which is posted for judgment for today, my lord.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ? ಹಾ,
So requesting the.
ಇವತ್ತಿಗೆ ಇದೆಯಾ ಜಡ್ಜ್ಮೆಂಟ್ಗೆ? ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ.
28/11.
28/11.
31. T. Sheshkri Rao. MB Chandrachud.
File a compilation.
Hmm?
File a compilation of the documents which
ಹ್ಮ್
produced before the trial court.
ಹ್ಮ್
It's the matter where not
ಏನ್ ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬೇಕಾ? ಏನ್ ಮಾಡ್ತೀರಿ?
pass over ಮಾಡಿದ್ರೆ file ಮಾಡ್ತೀವಿ.
ಹಾ
Pass over ಮಾಡಿದ್ರೆ file ಮಾಡ್ತೀವಿ.
ಹಾ
Can be taken up either during the course of the day or not on a day.
ಪಾರ್ಟೆಡ್ ಅಲ್ಲ?
Parted.
ಹಾ, ನೀವು ರೆಡಿ ಇದ್ರೆ ನನ್ಗೇನಿಲ್ಲ, ಪಾಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ತಿವಿ ಅಂತಂದ್ರೆ
Yes, yes, it's almost ready, madam.
ತಗೊಳ್ಳಿ. The council submits that he is going to file documents in the registry and hence list this and also directed to furnish the copy to the other side and list this matter on. ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಪಾರ್ಟೆಡ್
29/11.
29/11.
32. CH Hanumantraya.
CH Hanumantraya. Veeresh R. Budihal.
My lord, some inconvenience, could be on 23rd, subject to my lord's convenience, my lord.
Lordship, on last occasion, they were directed to verify whether the stay was subsisting when the matter was disposed in the trial court. That is all was the direction given to them, because 26/2019 notification was stayed by this honorable court by a court.
That is,
Well, there are two submissions, my
was
lord.
heard.
Lord, I have verified, my lord. Lord, there was indeed interim order that was subsisting, but neither the petitioner herein, neither the appellant herein, nor the respondent herein were the parties, my lord. In fact, my colleague has got a compilation of the cause title of each one of the matters. ಹೌದು. ಅಲ್ಲ, ಅದನ್ನ my colleague will not hand over. My colleague will hand over.
ಇಲ್ವಲ್ಲ, ಇಲ್ಲೇನು ಕೊಡ್ರಿ, ಅದೇನ್ ಕೊಡ್ತೀರಿ ನೀವು?
Cost title of each matter, my lord.
ಅದರ್ ಸೈಡ್ ಹೇಳ್ತಾ ಇದಾರೆ appellant is also a party in that proceedings ಅಂತ.
ಇಲ್ಲ.
Serial number 3.
ಕೊಡ್ತಾ ಇದಾರೆ ನೋಡಿ, serial number 3.
It may be taken about 23rd, my lord. In fact, I have myself verified.
TC Rajendra.
I have furnished this copy to him also on the last occasion, Your Lord. TC Rajendra is the appellant here.
ಕೊಡ್ರಿ, ಅವ್ರೇನೋ ಕೊಡ್ತಾರಂತಲ್ಲ, ಕೊಡ್ರಿ ಅದೇನ್ ಮೇಡಮ್?
And he is only representing the respondent number 1 and his name is also reflected in the
Very
corpus.
same council.
Yes, sir.
You only represented ಅಂತ ಹೇಳ್ತಾರಲ್ರಿ.
My lords, the appellant therein, my lords, was Vishwesvaraya Cooperative Bank
At
Limited.
the request of the respondent council, list this matter on 23rd, Saturday.
Please, please,
Your
please.
Lordship, not Saturday, Your Lordship. May I request for next 28?
Saturday working day, madam, ಒಂದು ವರ್ಷದಿಂದನೇ ಮಾಡಿರೋದು ಕ್ಯಾಲೆಂಡರ್.
Already 3 matters have been posted. ಇಲ್ಲಿ 3 matter ಬೇರೆ.
ಆಯ್ತು, 26/11.
26.
Please.
Interim order may be extended.
Interim order granted, earlier is extended till next date of hearing.
Admission matter 33.
Steps to be taken.
In this case, my lord, a sole appellant died and I have filed IA 1 of 2018. It has to be put up, my lord, on 23/3/2018.
ಇದೇನಾ notice to R3 ಬೇರೆ ಇದೆ?
ಅಲ್ಲ, ಅದು ಮೇನ್ ಇದ್ರ ಮೇಲೆ, ಬಟ್ ಅಪೆಲೆಂಟ್ ಸತ್ತೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾನು I have filed IA 1 of 2018.
ಯಾವಾಗ ಹಾಕಿದೆ?
On 23/3/2018.
1 of 18.
ಇದು ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಆಗಿತ್ತು, ತಾವು ರಿಕಾಲ್ ಮಾಡಿದ್ರಿ, ಅದಕ್ಕೆ ಬಂದಿದೆ.
ಏನೇ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತಾ?
ಅಲ್ಲ, ಮೇನ್
ಅಪೀಲ್ ಮೇನ್ ಅಪೀಲ್.
ಅದಕ್ಕಿಂತ ಬಿಫೋರ್ ಹಾಕಿದ್ದೀರಾ?
ಆಯ್ತು, 1 of 18 ಏನೋ ಇದೆ ಅಂತ ನೋಡಿ. ಅಲ್ಲ, ಇದ್ಯಾಕೆ ಇಲ್ಲ R4 refuse ಗೆ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು ಮತ್ತೆ? Steps to be taken ಅಂತ ಇದೆಯಲ್ಲ.
ಸ್ಟೆಪ್ಸ್ ಅಂದ್ರೆ ಅವರು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಅದು ತಗೊಂಡಿದ್ದು. ದೇ ಆರ್ ಕ್ಲೇಮ್, ದೇ ಆರ್ ಫಾರ್ಮಲ್ ಪಾರ್ಟೀಸ್. 3 ಜನ ಒಂದೇ ಪ್ರತಿ, ನಾನು ಅವ್ರನ್ನ ರೆಸ್ಪಾಂಡ್ ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ. ದೇ ಆರ್ ಆಲ್ ಕ್ಲೇಮೆಂಟ್ಸ್ ಮೇಲೆ.
R3 ಗೆ ಯಾಕೆ ನೀವು ಕೊಟ್ಟಿಲ್ಲ PF? ನೋಟಿಸ್ ಟು R3 ಅಂತ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ?
ಇದೆ,
ಕೊಡ್ಬೇಕಲ್ಲ. ನೋಟ್ PF ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
ಕೊಡ್ತೇನೆ.
ನಿಮ್ಮ ಐಎಗೆ ಬ್ರಿಂಗಿಂಗ್ ಆಫ್ ಎಲ್ಲಾರ್ಸ್ ಆಫ್ ಸೋಲ್ ಅಪಲೆಂಟ್
Sole appellant, sole
ಅದರ್ ಸೈಡ್ ಏನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರ ಐಎಗೆ
ಇಲ್ಲ, ಅಲ್ಲಂದ್ರೆ ಹಾಕಿಲ್ಲ.
ರಿಟರ್ನ್ ವಿತ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ ನೋಡಿ.
ಸರಿ ಮಾಡಿ ನಾವು.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಮತ್ತೆ ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ ನೀನು.
ಪ್ಲೀಸ್ ಕೊಡ್ತೇನೆ.
The appellant counsel submits that sole appellant is also no more and seeks time to serve the copy of IA number
1 of 2018.
18 on the other side and hence list this matter on
2911,
2911.
Much.
34, MR Hiremath, Shanti Bhushan,
ಲಾಸ್ಟ್ ಟೈಮ್ ಅವರೇ ಕೇಳಿದ್ರು ಟೈಮ್, ಇವರು ಇಲ್ವಾ ಹಿರೇಮಠದ್ದು? ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್. ತಗೊಳ್ಳಿ ಈಗ ಹಾಕ್ಬಿಡಿ. ಬೋತ್ ದಿ ಕೌನ್ಸಿಲ್ಸ್ ಆರ್ ಆಬ್ಸೆಂಟ್, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್. ಯಾವ ವರ್ಷದ್ರಿ? 2017 ರೈಲ್ವೆ ಕ್ಲೇಮ್ಸ್ ಟ್ರಿಬ್ಯುನಲ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 10/12. ಅಲ್ಲೇ ಹಾಕ್ಬಿಡಿ. ಇಫ್ ದಿ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಡಸಂಟ್ ಅಪಿಯರ್ ಇನ್ ದಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್, appeal will be dismissed for non-prosecution.
35, Vaibhav M.
Vaibhav.
Your Lordship, I'm ready, my lords. Kindly pass over, my lords. I'm ready, my lords. I'm ready.
Pass over.
36, Sanmesh G. Pandey.
Appeal has to be, my lord, posted for the division bench. It exceeds more than 15 lakhs value of the appeal is. It has to be posted for the division bench.
Division bench ಗೆ ಹಾಕೋಬೇಕು.
It exceeds.
ಅಲ್ಲ ರೀ, ನಿಮ್ಗೆ ಅಲೋ ಆಗಿರೋದೇನ ಅವಾಗ 15,44,880 as against 14,35,038.
Please.
Difference amount is less than the 15 lakhs.
No award has been passed, my lord, in respect of the.
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ತಿರೋದು ಏನು?
The measurement of the property, my lord.
What is the challenge made before this court?
In paragraph. Lord, in.
ಈಗ ನೀವು ಎನಾನ್ಸ್ಮೆಂಟ್ ಮಾಡೋದನ್ನೇ ಚಾಲೆಂಜ್
In
ಮಾಡಿದ್ದೀರಾ?
paragraph 10 of the impugned order.
ಅಲ್ಲ, ಎನಾನ್ಸ್ಮೆಂಟ್ ಮಾಡೋದನ್ನೇ
Not for the enhancement, my lord. No award has been passed in respect of 25,748 square feet. That I have challenged.
ಅದ್ರ ಮೇಲೆ ನೀವು ಅಪೀಲ್ ಅಲ್ಲಿ ಏನ್ ವ್ಯಾಲ್ಯೂ ಮಾಡಿದಿರಿ? ಅವಾಗ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ತಿರೋದಕ್ಕೆ
Entire extent.
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ ಇರೋದೇ 2,95,011. Total claim before this honorable court including 30% solace and 12%. ಏನ್ 1 crore ಆಯ್ತು?
Please, my lord.
Total amount.
1,75,77,219.
This is the matter before the division bench. Hello, permitted to ಹಿಂಗ ಹಾಕ್ಬಿಡಿ. Permitted to post the matter before the division bench. And in the meanwhile comply the office objections.
Please.
Office objections ಏನೇನು ಇದೆ ನೋಡಿ, comply ಮಾಡಿ.
Please.
37.
37, PG
ಶಾಂತರಾಜ್ BM ಕುಶಾಲಪ್ಪ. ಹೇಳಿ ಏನು?
Lord, the one.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ ನೋಡಿ ಮೇಡಮ್, ಇದ್ರದ್ದು ಇದೆಯಾ?
ಇದೆ.
ಏನ್ ರೀಸನ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಹೇಳಿ.
Body cut into 2 pieces, my lord. And the ticket was seized, definite ticket, but the ticket is also a cut with and blood stain ticket has been seized by the investigation agency, my lord. But the tribunal come to conclusion that if the deceased fallen down by the train while moving, so the body will not be cut into 2 pieces. And assumption and presumption drawn by the.
Discussions made herein above and as on the basis of the material available, it is held that the deceased was not a bona fide passenger and the death of the deceased cannot be established as that of due to accidental fall amounting to untoward incident. Reasons ಏನ್ ಹೇಳಿದೆ?
My lord,
Person falling from the exit of a bogie.
The person is
have
the.
a trajectory effect of fall which would drop him, if not a feet or 2 away from train, but at least 6 to 8 inches from the train. The forward motion would throw the person forward and not laterally, meaning thereby that the body would not have been cut into 2 valves. Railway line at the spot of incident had a curvature. Had there been a curve, there could have been a possibility of so and so.
The deceased was the permanent resident of Bhadravati town,
town, my lord. He was working at Bangalore. In the usual weekend course, he was used to travel to his native place. As such, the deceased had got the journey ticket from Bangalore to Bhadravati of the intercity train. So, and while traveling by the intercity train, he, in the midsection, he fell down by the train and sustained severe injuries. And moreover, the physical appearance of the deceased was the bulk body, my lord. So how it happened, no one is the eyewitnesses given the statement, how the incident happened, my lord. For evidence, for the purpose of traveling the journey, the journey ticket also with blood stain ticket has been seized and it has been marked in the tribunal, my lord. Based on the assumption and presumption, tribunal has come to wrong conclusion. As per the Reena Devi Supreme Court judgment, the facts is very important. Whether the deceased fallen down by the train or not. For that, the applicants have elicited with all investigation papers and oral evidence before the tribunal, my lord. So the categorically the respondent has denied all the facts through their reply statement. And final report also given by the investigation agency. This is an unexpected incident. Due to the untoward incident, the deceased fallen down by the train and died, my lordship. There is no any substantial evidence to disbelieve the deceased was not a bona fide passenger, my lordship.
ಏನ್ರಿ DRM ರಿಪೋರ್ಟ್ ಒಂದೇನಾ ನಿಮ್ಗೆ? ಬೇರೆ ಏನು ಎವಿಡೆನ್ಸ್ ಏನು ಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಬ್ಲಡ್ ಸ್ಟೈನ್ ಟಿಕೆಟ್ ಆಲ್ಸೋ ರಿಕವರ್ಡ್.
ಹಾಫ್ ಟಿಕೆಟ್ಸ್ ಎಲ್ಲಿಂದ
ಹಾಫ್ ಟಿಕೆಟ್ ಫ್ರಮ್ ದಿ ಬಾಡಿ ಅದು
ಗೇಟ್ ಅಲ್ಲಿ ಫ್ರಮ್ ವೇರ್ ಟು ವೇರ್ ಟ್ರಾವೆಲ್ ಮಾಡಿದ ಆ ಡೀಟೇಲ್ಸ್ ಏನಿಲ್ಲ.
ಅದ ಹೆಂಗಿರುತ್ತೆ ಹಾಫ್ ಟಿಕೆಟ್ ಇದ್ದಾಗ?
ಬರೀ ಅಲ್ಲಿ ನಂಬರ್ ಇದೆ.
ಆಯ್ತು, ಆ ನಂಬರ್ ನೀವು ಚೆಕ್ ಮಾಡ್ಬೇಕು ನಿಮ್ಮಲ್ಲಿ ಕಂಪ್ಯೂಟರ್ ನಲ್ಲಿ ನಿಮ್ಮಲ್ಲಿ ಇಶ್ಯೂ ಆಗಿದೆ ಇಲ್ಲ ಅಂತ.
ಅರ್ಧ ಕಟ್ ಆಗಿರೋ ಟಿಕೆಟ್ ಮಾರ್ಕರ್ಸ್
ನಂಬರ್ ಇದೆಯಲ್ಲ, ಏನಿರುತ್ತೆ ಅರ್ಧ ಟಿಕೆಟ್ ಅಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ? ರೈಲ್ವೆ ಟಿಕೆಟ್ ಹೌದಾ ಅಲ್ಲ ಅದು?
ರೈಲ್ವೆ ಟಿಕೆಟ್ ಬಟ್
ಮತ್ತೆ
ಇಲ್ಲಿಂದ ಎಲ್ಲಿ ಟ್ರಾವೆಲ್ ಮಾಡ್ತಾ ಇರೋದು ಏನ್ ಡೀಟೇಲ್ಸ್ ಇಲ್ಲ, ಬರೀ ಒಂದು ಅರ್ಧ
ಸರಿ ರೀ. ನಿಮ್ ನಂಬರ್ ಇದ್ರೆ ನಂಬರ್ ಚೆಕ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗಲ್ವಾ ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಹೋಗಕ್ಕೆ ಅಂತ ಇಶ್ಯೂ ಮಾಡಿದಾರೆ ನಿಮ್ ರೈಲ್ವೆ ಅಲ್ಲಿ ಅಂತ?
No eyewitnesses to the incident and no one has seen.
ಯಾರು ಐ ವಿಟ್ನೆಸ್ ಇಟ್ಕೊಂಡು ಟ್ರಾವೆಲ್ ಮಾಡ್ತಾರ?
ಬೆಳಿಗ್ಗೆ 6 ಗಂಟೆಗೆ ಹೊರಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. The incident is reported in the afternoon 2:30.
ನಿಮ್ಮ ರೈಲ್ವೆ ಪೊಲೀಸ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ರಲ್ಲ, ವಾಟ್ ಇಸ್ ದ ರಿಪೋರ್ಟ್?
Exhibit R1.
ವಾಟ್ ಇಸ್ ದ ರಿಪೋರ್ಟ್? R1 ಅದಲ್ರಿ, DRM ರಿಪೋರ್ಟ್ ಬಿಟ್ಬಿಡಿ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನ್ ರಿಪೋರ್ಟ್?
ಚಾರ್ಜ್ ಶೀಟ್ only enquiry report is conducted by the
ನಿಮ್ದು ಅದು ಸೆಲ್ಫ್ ಸ್ಟೈಲ್ ರಿಪೋರ್ಟ್ ರೀ ಅದು DRM. ಅರ್ಥನೇ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ. FIR ಏನ್ ಹೇಳ್ತದ್ರಿ? ತುಮಕೂರು ರಸ್ತೆ ನೋಡಿದ್ರಲ್ಲಿ ಮೃತಪಟ್ಟ ತನ್ನೆಂದು ಮೆಸೇಜ್ ಇದ್ದ ಮೇರೆಗೆ ಪ್ರಕರಣ ದಾಖಲಿಸಿಕೊಂಡು ತನಿಖೆ ಕೈಗೊಂಡಿದೆ. Some public informed that one male aged about 40 years, dead body found at kilometers on so between Mallasandra. This is for information and necessary. Received on dated so and so. ನಿಮ್ ಸ್ಟೇಷನ್ ಹೌಸ್ ಆಫೀಸರೇ ಕೊಟ್ಟರದ ಇದು ಇಂಟಿಮೇಶನ್? ಅವಸಾನ A3 inquest. Report of investigation conducted on an unknown male body aged 40 years found in between so and so. Bangalore Rural Railway Police Station. ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಯಾವ್ದ್ರಿ ಮಾರ್ಕ್ ಮಾಡಿರೋದು ನೀವು?
Only DR report has been.
ಅಂತಿಮ ವರದಿ ಇದು ಇದೆಯಲ್ಲ. ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆಫ್ ಪೊಲೀಸ್ ರೂರಲ್ ರೈಲ್ವೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್. ಮೃತನಾಳ ಸನ್ನಿವೇಶ ಪರಿಸರ ವಿದ್ಯಮಾನಗಳಿಂದಲೂ ಮೃತನ ಮೇಲೆ ಆದ ಗಾಯಗಳನ್ನು ಮೃತದೇಹದ ಕಣವಾಗಿ 2 ಭಾಗಗಳ ಬೇರ್ಪಟ್ಟಿರೋದು, ಒಳಗಾಗಿದೆ, ಅಂಟಿಕೊಂಡಿರೋದು, ಮೃತನ ಬಟ್ಟೆಗಳಿಗೆ ಆಗೋದು, ದೊರೆತಿರೋದು, ಬ್ಯಾಗ್ ಮೃತದೇಹ ಸ್ಲೀಪರ್ಗಳನ್ನು ಪಕ್ಕದಲ್ಲಿ ದೊರೆತು ಮೃತರ ಪ್ಲಾಂಟಿನಲ್ಲಿ ರೈಲ್ವೆ ಪ್ರಯಾಣದ ಟಿಕೆಟ್ ದೊರೆತಿರುವುದು. ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಗಮನಿಸಿದ್ರಲ್ಲಿ ಮೃತರು ತನ್ನ ಜೀವಂತವಾಗಿರುವ ಸಮಯದಲ್ಲಿ ಯಾವುದೋ ಕೆಲಸ ಕಾರ್ಯ ನಿಮಿತ್ತ ಬೆಂಗಳೂರಿನಲ್ಲಿ ರೈಲ್ವೆ ಪ್ರಯಾಣ ಟಿಕೆಟ್ ಪಡೆದು ಯಾವುದೋ ಬೆಂಗಳೂರು ಕಡೆಯಿಂದ ಹುಬ್ಬಳ್ಳಿ ಕಡೆಗೆ ಹೋಗುವ ಯಾವುದೋ ರೈಲು ಗಾಡಿಯಲ್ಲಿ ಪ್ರಯಾಣ ಮಾಡುತ್ತಿರುವ ಸಮಯದಲ್ಲಿ ರೈಲು ಗಾಡಿಯು ತುಂಬಾ ರಶ್ ಇರುವ ಕಾರಣದಿಂದ ಮೃತರು ತನ್ನ ಬಟ್ಟೆಗಳಿಂದ ಬ್ಯಾಗಿನೊಂದಿಗೆ ಬಾಗಿಲಲ್ಲಿ ನಿಂತು ಕುಳಿತು ಪ್ರಯಾಣಿಸುವ ಸಮಯದ ರೈಲು ಗಾಡಿಯ ಬೋಗಿಯ ಬಾಗಿಲು ಬಡಿದು ಚಲಿಸುತ್ತಿರುವ ರೈಲು ಗಾಡಿಯಿಂದ ಆಕಸ್ಮಿಕವಾಗಿ ಕೆಳಗೆ ಬಿದ್ದು ರೈಲಿಗೆ ಸಿಕ್ಕಿ ಸುಮಾರು 45 ಸ್ಲೀಪರ್ಗಳವರೆಗೆ ಎಳೆದೊಯ್ದು ಕಾರಣ ತೀವ್ರ ಗಾಯ ಸತ್ರಗಳಿಂದ ಆಕಸ್ಮಿಕ ಮೃತಪಟ್ಟಿರುವುದು ತೋರಿ ಬಂದಿರುತ್ತದೆ. ಮೃತನ ಪ್ರಕರಣ ಯಾವುದೇ ದುಷ್ಕೃತಿಯನ್ನು ಸಂಭವಿಸುವುದೆಂದು ತನಿಖೆಯಿಂದ ದೃಢಪಡಿದೆ. ಆದ್ದರಿಂದ ಪ್ರಕರಣ ತನಿಖೆ ಮುಕ್ತಾಯ ಮಾಡಿ ಆಕಸ್ಮಿಕ ಕಾರಣ ಎಂದು ಪರಿಗಣಿಸಿ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಹಾಕಿದಾರಲ್ರಿ ನಿಮ್ಮವ್ರೇನೆ ರೈಲ್ವೆ ಅವರೇನೆ. ಟಿಕೆಟ್ ಕೂಡ ಸಿಕ್ಕಿದೆ ಅರ್ಧ.
Ticket
ಹಾ.
has been found.
Huh?
Half ticket has been found. There is no details
ಆಯ್ತು,
from
A7.
from where it is then traveled.
ಹೋಗ್ಲಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಎಲಿಸಿಟ್ ಮಾಡಿಸಿದ್ರ ನೀವು?
That's only mother has been examined. AW1.
ಮದರ
The mother, the petitioner number. This is mother. Now ticket ನೋಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. Did not see the ticket. Then Swanand said, he always travel near the doors. ಲೇಡಿ ಟ್ರೈನ್ ಅಲ್ಲಿ ಇದ್ರು ಅವ್ರು ಮತ್ತೆ ಬಂದು ಹೇಳಿದ್ರು ಈ ತರ ಯಾರೋ ಬಿದ್ದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ರೆಕಾರ್ಡೆಡ್.
Nature of injury ಗೆ 40 sleepers ವರೆಗೂ ಡ್ರಾಗ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಬಾಡಿ. At that time how it happened no one cannot imagine my lord.
Heard the appellant counsel and also the counsel appearing for the respondent. This miscellaneous first appeal is filed against the rejection of claim petition filed before the Railway Claims Tribunal in OA number 2U030 of 2017. The factual matrix of
same ತರ incident.
the factual matrix of the case of the claimant before the Railway Tribunal that the deceased by name Sri Michael Bilmoria boarded the train on 22/1/2016 to travel from Bangalore to Bhadravati in an intercity passenger train. While traveling from the said train fell down and an untoward incident was taken place. As a result, his body was found in a cut off two portions. And the same was intimated to police, and police have registered the FIR and thereafter investigated the matter and filed the charge sheet. Filed the final report. Alien's claim was made and the claim was rejected only on the ground that not proved that he is a bona fide passenger. The council would vehemently contend that even though half ticket was also recovered from the dead body of the deceased, which prima facie discloses that he had travelled in the said train. And tribunal failed to consider both oral and documentary evidence. And the order passed by the tribunal is arbitrary. The council also brought to notice of this court A1 and A7 FIR as well as the final report, wherein also the final report specifically mentioned it is an untoward incident while traveling in the train. And council also would submits that in the evidence of AW1 nothing is elicited except denying that deceased not travelled and fell down from the train. The same has been categorically denied. The railway tribunal committed an error in coming to a conclusion that he is not a bona fide passenger. And mainly relies upon the DRM's report, which is a self-styled report, and even not adduced any evidence as against the evidence of the claimant. And railway tribunal comes to an erroneous conclusion that it is a clear case of trespassing into the railway property without a valid journey ticket or authority of law. The tribunal has given an erroneous finding that the body of the deceased was cut into two halves, HALVES halves. This would clearly indicate that the deceased must have been run over by some train, as otherwise the body could not have been cut into two halves, with one half between the tracks and the other outside the tracks. The nature of injuries sustained by the deceased and the manner in which two pieces of the dead body of the deceased was found lying will not suggest the fact that he could have fallen down from a running train. The reason assigned in paragraph number 4 and 5 is only an imaginary, and the railway tribunal given its own interpretation, considering the nature of the body found, and acted as an expert that body would not have been cut into two halves by the train running over it. And the very approach of the railway tribunal is erroneous. Per contra, the counsel appearing for the respondent would contend that the railway tribunal, while rejecting the claim petition, given the reasonings and also taken note of material, and body was cut in two pieces. If really the an untoward incident was taken place, no such injury could be caused, and the same has been appreciated by the railway tribunal. The counsel also, in support of his argument, relied upon the judgment of 2019 within bracket 12 Supreme Court cases 391. ಏನ್ರಿ ಇದರಲ್ಲಿ reasoning?
Same ತರ incident ಆಗಿರ್ತದೆ. The court come to the conclusion it cannot.
And brought to notice of this court paragraph number 7 and appellate court and the apex court made an observation that body of the deceased had been cut into two pieces, and was lying next to the railway track. The report further indicates that intestine of the deceased had come out of the body. The above factual position reveals that body was cut into two pieces from the stomach. This can be inferred from the facts expressed in the inquest report that the intestines of the deceased had come out of the body. It is not possible for us to accept that such an accident could have taken place while boarding a train. The counsel referring this judgment would contend that the facts of the case and also the discussion made by the apex court in the judgment fit into the case on hand. Hence, praise this court to dismiss the appeal. Having heard the appellant counsel and also the counsel appearing for the respondent, and also having considered the material on record, the point that would arise for the consideration of this court, or whether the railway tribunal committed an error in arriving at a conclusion that he was not a bona fide passenger, and whether it requires interference of this court, what order. Having heard the appellant counsel and also the counsel appearing for the respondent, it is the case of the claimant that deceased traveled in the intercity passenger train which was proceeding, and the deceased traveled from Bangalore to Bhadravati, and he accidentally fell down. As a result, body was cut into two pieces. It is also their claim that even bloodstained half ticket was also found in the pocket of the deceased, and recovery is also made during the course of investigation. Having perused the evidence of AW1, who is the mother of the deceased, Allah? Yes. Mother of the deceased reiterates the averment made in the claim petition. And in the cross-examination of AW1, except suggesting that deceased was not travelled in the said train, nothing is elicited to disbelieve the case of the AW1. It is also important to note that on perusal of A1, an intimation is received that body was lying between Tumkur and Mallasandra railway station at kilometer number 70/100.200. And the said information was received at 3:30 p.m. The FIR was registered in terms of A1, and also counsel appearing for the appellant brought to notice of the railway who conducted the investigation and filed the charge sheet, wherein also specifically it is mentioned, having considered the material on record, particularly cause of death is due to shock and hemorrhage and wounds sustained. And no doubt body was cut into two pieces, and one piece was lying inside the railway track, and another half portion was lying outside the track. And while filing the final report also, investigating officer taken note of the said fact, and apart from that taken note of the half of the railway ticket found in the pant pocket of the deceased, and also comes to the conclusion that while traveling in the train, he fell down and sustained the injuries. And final report is also not questioned by the railway, and railway tribunal fails to consider particularly document of A1 and A7. And A7 is also the final report filed by the railway police themselves. And the railway tribunal proceeded to consider the material on record in coming to the conclusion that this type of injuries would not have been caused in a railway accident. No doubt the counsel appearing for the respondent relied upon the judgment of the apex court referred supra, wherein discussion was made with regard to the body cut into two pieces. And not only consider the same, even consider the material available on record. And also comes to the conclusion that a perusal of the first information report leaves no room for any doubt that the deceased was seen coming from the direction of Bangalore. And while crossing the railway track, he having not noticed the oncoming train, was overrun by the train. And having considered the factual position comes to such a conclusion. But in the case on hand, it has to be noted that there is a very specific case of claimant that he traveled from Bangalore to Bhadravati. And apart from that, also even a railway ticket also found from the pocket of the deceased. And the same has not been disputed. And also the investigation has been conducted by the railway after registration of the case. And railway police also filing the final report also comes to the conclusion that an untoward incident was taken place while traveling. And he fell down and sustained the injuries. Even though the railway relies upon the DRM's report, except marking of DRM report, nothing is placed on record to counter the case of the claimant. And particularly document of A1, FIR, A7 final report, and also A2 intimation given to the police on the very same day at 15:30 hours. And also A3 inquest also here with regard to the involvement of the involving of deceased while traveling in the train, fell down and sustained the injuries. And except the DRM report, nothing is placed on record by the railway to dislodge the case of the railway claimant. And the railway tribunal fails to consider the final report of A7. Nothing is discussed except discussion made with regard to the body cut into two pieces and assumed that no such body will cut into two pieces in a case of railway accident. And railway tribunal acted as an expert without any basis making such an observation in the impugned order. In paragraph number 4 and 5. And instead of reporting the same, comes to a conclusion that the accident death report has not been discredited by the applicants. And the reasoning given by the trial court is without any basis on assumption, except relying upon the DRM report. Hence committed an error in coming to such a conclusion that claimants have not proved the case that it was an railway accident and an untoward incident was taken place. The reasoning assigned by the railway tribunal is erroneous and hence it requires interference of this court. In view of the discussions made up, I pass the following order. And hence I answer the point as affirmative that tribunal committed an error. In view of the discussions made up, I pass the following order. Appeal is allowed, infirmed order is set aside. ಯಾವ ವರ್ಷದ್ದು 8 lakhs?
2016.
Date of accident is 2016, madam.
16.
Amendment is 1/1/2017.
17 ಅದು.
8 lakhs.
4 lakhs.
8 lakhs maximum must.
Maximum.
The claimants are entitled for an amount, appeal is allowed. Impugned order is set aside. Consequently, claim application is allowed. Granting compensation of rupees 4 lakhs. If the interest not accumulates to the 8 lakh, and the same is awarded as 8 lakh rupees ಅಂತ ಹಾಕ್ಬಿಡಿ.
38.
ಯಾರಿಗೆ ಎಷ್ಟು ಅಮೌಂಟ್ ಅಂತ
ಇಲ್ಲ ಒಬ್ರೇ
ಒಬ್ಬರೇ ಇರೋದಲ್ಲ, ಮದರ್ ಒಬ್ಬರೇ ಹಾಕಿರೋದು. ಮದರ್ ಒಬ್ಬರೇ
number
ಹಾಕಿರೋದು.
2.
ಅದರಲ್ಲಿ ಕಂಡೀಷನ್ ಟು ಪೇ ದಿ ಅಮೌಂಟ್ ವಿತ್ ಇನ್ ಟೈಮ್ ಪೀರಿಯಡ್ ಅದೆಲ್ಲ ಇದೆಯಲ್ಲ, ಅದು ಮಾಮ ಹಾಕ್ತಿರಲ್ಲ, ಅದ್ರಲ್ಲಿ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. ಸೇಮ್.
If they have not paid, interest may be carried. In time, if the respondent did not pay, the interest may be carried.
ಯಾವಾಗ?
Within.
ನೋಡಿ, if the amount is not paid within 6 weeks,
Yes.
the compensation will carry the interest at the rate of ಎಷ್ಟು 6 9?
9% of 9%.
6%.
9 from the during the course of trial.
Supreme Court judgment ಹೇಳಿ, ನಿಮ್ದೇನು ಹೇಳ್ಬೇಡಿ.
9%.
9%.
6%.
ಆಯ್ತ್ರಿ, 9% ಯಾವಾಗ ಅಂದ್ರೆ in case if you have filed
From
in case of default. Geeta G Menon,
38.
Ashok P Patil. 38.
The first appellant has died, Your Honor. I have to make the LRs, all the LRs are already on record in the civil court. I will just make the necessary application and I appear for the remaining LRs. So, Your Honor, may give me a week's time, Your Honor.
He wants to file an application. Why you want to file an application? You file a memo. If you already LRs.
No, the
are
other
record.
LRs are not parties arrayed as party. The other LRs are not arrayed as parties because only the contesting plaintiffs are made as parties,
All LRs are not on record.
not in the high court.
I thought. Appellant counsel submitted that one of the, yaar appellants
First appellant.
First appellant is no more and seeks time to file necessary application, and hence 2 weeks time granted. List this matter on 6/12.
Much obliged.
39. Chetan B.
Appear for the appellant. Lord, it's a defendant's appeal, my lord. Lord, against the order of temporary.
One allowed interfering.
Yes, my lord. Lord, the specific case of the plaintiff is that, my lord,
Sanat
the
Kumar Shetty, KVTR counsel ilwa? ಯಾಕ್ರಿ ನಿದ್ದೆ ಮಾಡ್ತಾ ಇದ್ರ? ಹೆಸರು ಕರೆಯವರೆಗೂ ಸುಮ್ನೆ ಇದ್ದೀರಾ? ನಾವು ಹುಡುಕ್ತಾ ಇದ್ದೀವಿ, ಎಲ್ಲಿದ್ದಾರೆ ಸನತ್ ಕುಮಾರ್ ಶೆಟ್ಟಿ ಅಂತ. ಹೇಳಿ.
Lord, the specific case of the plaintiff is that, my lord, he is the owner of site number 10, my lord, Khata number 581/8, my lord, measuring.
Number 10.
10, yes, my lord, measuring 40 into 60. And my lord, he claims that, my lord, he has acquired the property as per sale deed dated 23/1/1995. 23/1/1995. And further claims that, my lord, the under land acquisition proceedings, the entire property, including this subject property, was also acquired by way of notification dated 4/1/1985. That is much prior to the sale deed. And even the possession was also taken by the, my lord, the under due process of law on 5/11/1992. Lord, but he claims that, my lord, the organization, the NTA society, my lord, which the property, the under which the acquisition proceeding is the beneficiary, my lord, they have not taken it with a due process of law, and no compensation is awarded. And according to them, my lord, in view of section 24(2) of the Right to Fair Compensation and Transparency of Land Acquisition Act, my lord, 2013, my lord, the proceedings is left because of not taking possession and not remitting the, my lord, the award amount. My lord, the further case of the plaintiff is that, my lord, the one in one of the writ petition, the organization filed
my lord, before this honorable court, a certain direction was issued. And for issuing the, my lord, the modified plan of, by the BDA. That order was challenged by one of the organization, my lord, claiming that Shantivana Residents Association. My lord, in the writ appeal, certain observations were made that the members of the association need to be evicted with due process of law. That is the observation made by this honorable court, my lord. My lord, now, though he is not the member, though the plaintiff is not the member of the said society, but he claims that he is the member of the society. And in the meanwhile, what happened, my lord, the society also filed one suit against the defendant, plaintiff herein for taking possession. My lord, later on they withdraw it, my lord, stating that, my lord, on a wrong notion they had filed the suit for seeking possession, because the entire property, my lord, was taken possession by the land acquisition officer by way of the notification, and the protection was rendered only with respect to the members of the said association, not to all the landowners, my lord. My lord, in that light, my lord, he claims that, my lord, I am the allottee. Through allottee, I have purchased the suit schedule property. My lord, my site number is 686. My lord, in survey number 17/6. My site measurement is 40x50. My lord, he claims that, my lord, I'm interfering in their peaceful possession. My lord, my specific case before the trial court was that, my lord, no injunction order can be granted against the true owner. My lord, I am in exclusive possession. My lord, to prove that, to show that they are in possession, my lord, there was absolutely no material before the court. My lord, I have also relayed, my lord, certain judgments which says that, my lord, the suit itself was not maintainable. But the trial court, my lord, says that, my lord, the judgment which I have relayed is not applicable in the facts of the case. Hence, my lord, the injunction was granted, my lord.
But plaintiff is the purchaser.
My lord, plaintiff is the purchaser much after the acquisition proceedings.
From whom? Owners?
From the landowners. My lord, the landowners, my lord, they have not challenged the acquisition proceedings at all.
But according to them, even the preliminary notification and final notification also issued.
Yes, my lord.
No possession was taken and no amount of compensation was paid.
According to them, my lord. My lord,
is there any material to show that the award was passed and also the amount was remitted?
Yes, my lord. My lord, so far as the remittance, my lord, I have not produced the.
Then
my lord,
automatically it lapses.
My lord,
if consideration is not paid, value of the property.
My lord,
how the acquisition will be valid?
My lord, they have not challenged the acquisition proceedings itself.
Why they have to challenge it? Automatically lapses.
My lord, the
taking of the possession as well as the payment of
possession is taken, my lord. Possession is, my lord, I have produced.
Possession ಹೆಂಗ್ರಿ ತೊಗೊಳಕ್ಕಾಗುತ್ತೆ?
My lord,
possession ನಮ್ಮ ಮೇಲೆ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ.
ಅವರೇನಾ?
Amount is also.
ಹೌದು.
ಸೊಸೈಟಿ ಅವರು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ.
ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ.
ಪೊಸೆಷನ್ ಗೆ ಸೂಟ್ ಹಾಕಿ ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು, ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ದಟ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ my lord. ಅವರ
My lord,
they themselves have withdrawn the suit.
Yes, my lord.
For taking possession.
My lord, amount is remitted, my lord. My lord, the award amount is remitted.
ಆಯ್ತು, ಸೊಸೈಟಿ ಅವರು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ಮೇಲೆ, ವಿಡ್ರಾ ಮಾಡಿದ್ಮೇಲೆ, possession claim ಮಾಡಿ, how you can say that you have been in possession in view of the formation of that layout?
My lord, because my lord, the possession notification was passed. My lord, I have produced annexure J. My lord, wherein the particular site number, my lord, is survey number 16. My lord, the possession was taken, my lord. Page number 123. My lord, that serial number 75.
ಇದೆಲ್ಲ ನೋಟಿಫಿಕೇಶನ್ ರೀ.
Yes, my lord.
ನೋಟಿಫಿಕೇಶನ್ ರಿಲೇ ಮಾಡ್ಕೊಂಡು ಪೊಸಿಷನ್ ಟೇಕನ್ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತೀರಿ ನೀವು? ಎಲ್ಲಿದೆ ಅವಾರ್ಡ್ ಅಮೌಂಟ್?
My lord, so far as the award is, my lord,
ಅವಾರ್ಡ್ ಎಲ್ಲಿದೆ? ಪೇಮೆಂಟ್ ಆಫ್ ಅಮೌಂಟ್ ಎಲ್ಲಿದೆ? ಏನು ಇಲ್ಲ.
My lord, award, my lord, I'll furnish the copy, my lord.
ಅದೇ ಮೇನ್ ಅಲ್ಲ ಬೇಕಾಗಿರೋದು. Crux of the issue ಅದೇನೆ. Unless they pay the compensation amount, how can they take the possession and form a layout and sell the site in favor of you?
My lord,
that is the crux of the issue.
My lord, that was done, my lord, much prior to the sale deed
ಆಯ್ತು
was
ರೀ,
executed
ಆಯ್ತು
in-
ಅದನ್ನೇ ಎಲ್ಲಿದೆ ಮೆಟೀರಿಯಲ್ ಪ್ರಿಮಾ ಫೇಸಿ ಮೆಟೀರಿಯಲ್ ಬೇಕಲ್ಲ
my lord, I'll produce it. My
ಮತ್ತೆ
lord, in the meanwhile, my lord,
ರೀಸನಿಂಗ್ ಕೊಟ್ಟಿರೋದೇನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್
my lord, reasoning is that, my lord,
But on perusal of the pleadings and arguments, what is emanating from the case is that admittedly plaintiff has purchased the social property under the sale deed dated 23/1/1995. It is the plaintiff contended that he is in possession of the property so and so, but the NTI society with having no whatsoever right, title and interest over the social property with intent to grab his land had sold the property in 21 to Jetmal Jain. Within a month, he in turn sold the same in favor of the present defendant herein. But prior to the present suit, defendant's vendor, that is NTI society, who is claiming the title based on the acquisition made by way of filed the suit in OS number so and so before the court by seeking relief of possession against the plaintiff herein, but during the pendency of the said suit has allotted the sold for its member. The member in turn, after getting the sale deed, sold the same in favor of the present defendant herein. Admittedly, plaintiff herein is the possession and of the, which is an undisputed factor. To adjudicate the dispute for injunction, what is to be considered is that whether the plaintiff was in lawful possession as on the date of filing the suit. Admittedly, he is also claiming the property based on the title, but the defendant is claiming the title through NTA society itself. In that event, unless by adopting the due process of law, parties have not chosen to take out possession from the plaintiff, he cannot dispose by mode which is unknown to law. In that conditions, this court is of the opinion that decision relied upon by the defendant is not acceptable to the facts. So and so the plaintiff is settled position of law since 1995. He has to dispose with due process of law.
Even before in the writ appeal court, my lord, the society has undertaken to take possession in accordance with law. That's why they find this.
my lord,
That's why they find.
my lord, if he is the member of the, my lord, our specific case is that he is not the member of the association, my lord, Shantivana Association. My lord, they have not produced any document to show that they are the members, my lord. My lord, in the meanwhile, my lord, what?
Why he has to make a?
My lord, in the meanwhile, what happened, my lord, before the trial court, my lord, there was a settlement talks. Today also, yesterday also, my lord,
ಆಯ್ತ್ರಿ ನಿಮ್ಮ ಟೈಟ್ಲಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸೊಸೈಟಿ NTI ಸೊಸೈಟಿ ಅಕ್ವೈರ್ ಆಗಿದೆ ಅನ್ನಕ್ಕೆ ಏನಿದೆ ಮೆಟೀರಿಯಲ್ ಎಕ್ಸೆಪ್ಟ್ ನೋಟಿಫಿಕೇಶನ್ ನಥಿಂಗ್.
My lord, notifications, my lord, award notification, my lord, I'll produce it, my lord.
ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ ಅಥವಾ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಲಾ ಸೂಟಲ್ಲಿ ನೋಡಿ ನಿಮ್ಮಿದ್ರೆ ನೀವು.
My lord, I'll produce it, my lord. My lord, why? Because in the meanwhile, my lord, yesterday evening we discussed, my lord, if there is any scope for amicable settlement, my lord, the matter may be referred for mediation, my lord.
Mediation. ಏನ್ರಿ ತಗೊಳ್ಳಿ. Heard the matter in part. Both counsels submit that matter also can be referred to the mediation. Mediation ಯಾಕೆ ಈಗ ಒಂದು ಲೋಕ ಅದಾಲತ್ ಇರ್ಬೇಕಲ್ಲ ಅವತ್ತು ಹೋಗ್ತೀರಾ ಮಾತಾಡ್ತೀರಾ ಆಯ್ತು mediation and hence the mediation ಕಳಿಸ್ಬೇಕಾ ಅಥವಾ ನೀವೇ ಮಾತಾಡ್ತೀರಿ? Mediation. And hence the registry is directed to send this file to the mediation center. And list parties are directed to appear before the mediation center on ಯಾವತ್ತು ಹೋಗ್ತೀರಿ ಹೇಳಿ?
First week.
Next week, any day.
29th, Friday, next Friday. 29th at 3 PM.
Obliged.
Registry is directed to send the consent papers to the mediation center and discuss matter on 5th of December.
Obliged.
40, Vinod Prasad, K. Venkatesh, Sachin BS.
The respondent.
Respondent number 2.
That was decreed. We were placed ex parte because address was of
Address?
was given earlier address, not the present address. Earlier we have filed a suit.
You are defendant number 1? You are defendant number 1?
Earlier we have filed a suit that was decreed. It was held that the sale deed is not a fabricated one in favor of the present plaintiff. Then he files, without filing miscellaneous petition, he filed present suit. We were not served the summons.
Earlier suit ಯಾವುದು judgment? ಎಲ್ಲಿದೆ ಅದು copy?
Other copy, they don't dispute. What they say is they were placed ex parte because we have given their wrong address. Though there is a paper publication.
I have got the copy here since ಇದಾಗಿಲ್ಲ ನಾನು ಹಾಜರು ಮಾಡಲಿ. Now spot question whether we have been
Case,
served.
in this case, whether you have been served or not.
Not, we have not been, so kindly, page 59 for a moment, kindly be looked into.
59.
59 of the paper book. Sorry, 62 of the paper book.
62.
Oh, yes. The affidavit starts from 61. Handwritten application, typed copy is at 63. Kindly typed copy 63. I submit. I have filed the above suit. Defendant declaration in emergency notice. Defendant address from one place to other. I have been searching the locality, is unable to trace out the address of defendant. Hence, just an necessary to issue notice by paper publication. The paper publication I have produced, kindly in a corner of paper, we are illiterates, and he was an employee in government, 4th class. What the court says is you are in the same address, hence served. Short answer by the court.
Miscellaneous ಅಲ್ಲಿ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಆಯ್ತಾ?
Pardon, my lord?
Miscellaneous ಅಲ್ಲಿ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಆಗಿದೆಯಾ ಅಂದೆ?
ಆಗಿದೆ.
ಆಗಿದೆ.
Evidence ಆಗಿದೆ. What the court says kindly be looked into.
ಇದೆಯಾ ಮೇಡಮ್?
ಇಲ್ಲ ಸರ್.
Page 4.
ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತಲ್ವ? ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನಿದೆ ನೋಡೋಣ. ಏನ್ ಅಡ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು ಗೊತ್ತಾಗ್ತದೆ.
Evidence is that page.
ಎವಿಡೆನ್ಸ್ ಹಾಕಿದ್ದೀರಾ?
ಆಗಿದೆ.
ಎಲ್ಲಿದೆ?
They have cross-examined me. And
ಎಲ್ಲಿದೆ ಅಂದೆ ಎವಿಡೆನ್ಸ್? ಅನೆಕ್ಷರ್ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲಿ ಮಾಡ್ಲಿಲ್ಲ. I got paper certificate copy is here.
ಮಾತ್ರ ಇದೆ, ಬಟ್ ಕೋರ್ಟ್ ಮುಂದೆ ಏನಿದೆ? ಯಾಕೆ ರೆಕಾರ್ಡ್ಸ್ ತರಿಸ್ಬಿಡೋಣ. ಇಲ್ಲೇ ಬೆಂಗಳೂರು ಸಿಟಿ ಅಲ್ವಾ? ಬೆಂಗಳೂರು ಸಿಟಿ.
ಹೌದು.
Call for records and list this matter for admission along with records on 512. 512 ಬೇಡ, 1012 ಹಾಕಿ ಬರ್ಬೇಕಲ್ಲ ರೆಕಾರ್ಡ್.
41 ನಂದೀಶ್ ಗೌಡ ಜಿಲ್ಲೆ.
Plaintiff appeal. Suit for partition and separate possession. Application filed under order 39 rule 1 and 2, my lord. Restraining the defendants from alienating the suit scheduled property pending disposal of the suit. Dismissed by the trial court. Holding that, my lord, there is a prior partition had taken place in the between the defendants in the year 1982. And in the year 2016, my lord, the plaintiff executed a relinquishment deed in favor of the defendant number 1 and 2, my lord. That alleged relinquishment deed, my lord, was also called in question by filing an application for amendment. My lord, one more my lord, the reason assigned by the trial court rejecting the application, that my lord, the question of maintainability of the suit, since 82 itself, my lord, there is a partition had taken place. The question of the suit itself is not maintainable. That is the reason assigned by the trial court. My lord, in page number 26, para 20.
20 ನಲ್ಲೇ ಇರೋದು. Plaintiff has not
approached the court
and she suppressed the execution of release deed in favor of defendant number 1 and 2, and suit appears to be bad for non.
By looking into any angle, the maintainability of the suit for partition in present forum is doubtful. It is well settled that the prima facie case includes the maintainability of the suit also. When the maintainability of the suit itself is doubtful, the question, the conclusion would be that there is no prima facie case. Merely, my lord, the mutation has been registered in favor of the brother, my lord, the defendant number 1 and 2, my lord. It is not a conclusive proof, my lord. There was a partition had taken place, my lord, in the year.
Relinquishment deed ಅಂತಿದೆಯಾ?
Relinquishment deed, that is also called in question by the plaintiff, my lord, by filing an application.
Release deed.
ಹೌದು.
By filing an
application for amendment.
ಈಗಿನ್ನು ಈಗ ಹಾಕಿದಿರಿ?
ಹಾಕಿದೀವಿ, ಅದು ಏನು ಆರ್ಡರ್ ಆಗಿಲ್ಲ. And apart from that, my lord, item number 3 and 4, my lord, the joint name of the defendants. Hence, my lord, the class 1 heirs, my lord, alone has been made parties. My lord, in absence of all the parties to the suit anta ಹೇಳ್ತಾರೆ ಅವರು. in respect of item number 3 and 4, the property itself is not, the property itself is not maintainable. ಅಂತ. Main defense in the written statement itself is that, my lord, the prior partition had taken place. Apart from that, my lord, relinquishment deed. For execution of relinquishment deed, my lord, the alleged relinquishment deed is also called in question.
Relinquishment deed executed by this
Plaintiff in favor of defendant number 1 and 2.
registered document.
ಇಲ್ಲ ಅದ್ ನನಗೆ
Registered document.
ಹೌದು.
ಮತ್ತೆ registered document ಆದ್ಮೇಲೆ ಏನ್ರಿ prima facie there is a document in their favor.
My lord, it is the fraud played by the defendant number 1 and 2, my lord, by getting
ಅದೆಲ್ಲ ಪ್ರೂವ್ ಆಗ್ಬೇಕಲ್ಲ.
ಅದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದೀವಿ.
ಟೋಟಲ್ ಪ್ರೂವ್ ಆಗ್ಬೇಕದು.
ಹೌದು.
ಈಗ ನೋಡ್ಬೇಕಾದ್ರೆ ನಾವು prima facie ಕೇಸ್ ಮಾತ್ರ.
ಹೌದು.
ಇಂಜಂಕ್ಷನ್ಗೆ ಹೌದಿಲ್ಲ.
ಹೌದು.
ಯಾರು ಅದರ್ ಸೈಡ್ ಆರ್ ಇಲ್ಲ
ನೋಟಿಸ್ yet to be issued.
ಆಗಿಲ್ವಾ?
ಇಲ್ಲ.
The appellant counsel is directed to serve the copy of this appeal memo on the counsel who appears on behalf of the respondent before the trial court and list this matter on 10/12.
42.
And in the meanwhile, issue notice against respondents and appellant counsel is directed to pay PF. Emergent notice is not.
42 is the headed.
Matter is arising out of the compensation that was paid by the land acquisition officer under the National Highways Act. Under the claim, there was two claims made before the arbitrator with regard to the enhancement of compensation as well as the awarding of additional solatium and interest on the solatium. Which was declared by the Supreme Court also, it is payable under this act also. But the claim was not answered at all by the arbitrator. Against which the suit was filed by the appellant before the learned judge under section 34 of the Arbitration Act. The learned judge also did not consider that aspect in spite of making this claim in the suit. So hence the appellants are before this on court.
Defendant number 3 has not assessed the market value of the acquired land as on the date of preliminary notification. The compensation owed by the defendant is now too low. Defendant number 3 has not followed the procedure 3G.
In the entire order, the learned judge did not say about the claim made by the appellants with regard to the solatium and the interest, my lord. That was the claim made before the
Notice against the respondent. Respondent yaru?
Respondent land acquisition is the NHAI and deputy commissioner and land acquisition officer.
Deputy commissioner ge AJ ilva? AJ is directed to take notice for R3.
Or two Prakash Angadi is appearing for this.
1 and 2 ge?
1 and 2 ge Prakash Angadi appears for usually in cases as a panel advocate, but there are other advocates also. Anybody can be.
Yari Prakash Angadi madbaka? Counsel Prakash Angadi is directed to take notice for R1 and R2. Appellant counsel is directed to serve the copy of this appeal memo on the counsel for R1 and R2 and also to AG. AG inu copy serve madilala? List this matter on 12/12.
43, Vishwanath Shetty B.
Appellant. This is defendant's appeal matters. That's the respondent plaintiff files this suit for ejectment of the appellant from B scheduled property to the plaintiff. Claiming that, my lords, please, he acquired this property in presence of a registered gift deed dated 11/6/2018 from his mother. He continued in possession of the entire A scheduled property. I am brother of this respondent, and that on my request, he allowed to continue in first floor portion of that is B scheduled property. And monthly rent of rupees 5,000. I paid rent for some time. Then I have not paid at all the rent of due of 35,000 and all.
My lord, he sought for ejectment, and then he sought for an injunction against me for entire property. My lord, the actual facts are different. It is not in dispute that the both appellant and the respondent are the brothers, who are the children of one Srimati Indrani and Sri M. Rangaswamy. My lords, please, the entire suit schedule A property is consisting of 30 into 54 on one side and 60 on the other side. This property was purchased by Srimati Indrani on 1979. My lord, speed subsequently, my lord, this Indrani and Rangaswamy are having in all 4 children, my lords, please. One Mohan, there is no dispute with regard to him. And then Arunachalam is the respondent, the appellant, my lords, please. Then Chandrakant is the sister, appellant sister. Then Vasudeva. This Mohan concerned is the respondent, my lords, please. First respondent. My lord, this property is concerned. Srimati Indrani during her lifetime, she has executed a registered will on 13/3/2014, my lords.
13/3?
13/3/2014.
14.
Sorry, sir. 3/3/2008.
13/3/2008.
Sorry, 3/3/2008. Sorry, my lords. My lord, this property, entire property of A schedule property, it has been bifurcated into 2 portions actually, my lord, since quite long time. In the middle, there is a 6 feet passage. That means 3 feet in this property. Western portion of entire property consisting of ground floor and first floor existing thereon is bequeathed in favor of the appellant. Then another portion is bequeathed in favor of the respondent, equally, my lord. My lord, we continued in possession from the lifetime of our mother. My lord, our mother is also passed away on 22/5/2021. This Mohan respondent is my elder brother, my lord, please. He was working in railway department. He retired. I am working in private. I am making out my livelihood. In the ground floor, I am in occupation of the property, and a portion is let out in favor of. My lord, it seems my brother very intellectually has got cancelled the will by taking undue advantage of my mother's illiteracy and innocence somewhere on 13/3/2014 itself. In respect of my portion and his portion, then intellectually he has obtained a gift deed on 11/6/2018. My lord, from 11/6/2018, I had no knowledge. My mother died in 2021. My lord, after death of my mother, my lords, my brother has started to lay a claim on the basis of this gift deed, my lord. My lord, he gone to police station and lodged a complaint against me, saying that he is owner and I am a tenant. My tenants also, he started to disturb and lock the doors. Then, my lord, immediately, my lord, I have filed a suit for the relief of declaration. That gift deed is obtained fraudulently by misrepresenting to my mother, and also cancellation of that will is not out of desire of my mother, and there was no dispute all along during her lifetime.
Yes.
OS number 202 of 2022, I filed, my lord. So the suit of the respondent is of the year 2021. My lord, while in the suit also the respondent, my lord, as could be seen from the observation made by the Honorable Trial Court also in page 31, order page number 5 of the Honorable Trial. ನಾನು ಸ್ವಾಧೀನದಲ್ಲಿ ಇರೋದೆಲ್ಲ ಹೇಳ್ತಾರೆ. ಅವ್ರ ಆರ್ಡರ್ ಕೇಳ್ತಾರೆ both A and B schedule property-ಗೆ. The Honorable Court has not assigned any reason. My lords, please kindly peruse the last page ಅಲ್ಲಿ. Page number 72 and the order 46 some trial court page. Page number 72 ನಲ್ಲಿ 3 ಪಾಯಿಂಟ್ ಮಾಡ್ಬಿಟ್ಟು ಸ್ವಾಮಿ ಇಲ್ಲಿ ರೀಸನ್ಸ್ ನಾನು ಅವ್ರ ಗಿಫ್ಟ್ ಡೀಡ್ ನೋಡಿದೆ, ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಖಾತೆ ಇದೆ, ಕಂದ ಇದೆ, ನಾನು ಇಂಜಂಕ್ಷನ್ ಕೊಡಿ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಈವನ್ ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ಮೈ ಲಾರ್ಡ್, ನನ್ನ ಪೊಸಿಷನ್ ನಲ್ಲಿ ಇದ್ದೀನಿ ಅಂತ ಒಪ್ಕೊಂಡು ನನ್ನನ್ನು ಎಜೆಕ್ಟ್ಮೆಂಟ್ ಕೇಳಿರೋದು ಕೂಡ, ವಾಟ್ ಎವರ್ ಮೇ ಬಿ ದಿ ರಿಸಲ್ಟ್ ಆಫ್ ಮೈ ಸೂಟ್ ಆರ್ ದಿ ಸೂಟ್, ಮೈ ಲಾರ್ಡ್, ದಿ ಆನರಬಲ್ ಕೋರ್ಟ್ ಗ್ರಾಂಟ್ಸ್ ದಿ ರಿಲೀಫ್ ಫಾರ್ ದಿ ಎಂಟೈರ್ ಪ್ರಾಪರ್ಟಿ ಇಂಜಂಕ್ಷನ್. Now, under the guise of this order, my lord, he wanted to throw me out of the property. In my suit, what happened, my lords, please? Now, we were about to club both the matters. ನನ್ನ ಸೂಟಲ್ಲಿ ಈಗ ಏನು ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ, ನನ್ನ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಸೂಟ್ ಅಲ್ಲ. ಸೊ ಇನ್ ಮೈ ಸೂಟ್ ಆರ್ಡರ್ಸ್ ಇಸ್ ನಾಟ್ ಪಾಸ್. ಇನ್ ದಿಸ್ ಸೂಟ್ ದೋ ಐ ಆಮ್ ಇನ್ ಪೊಸಿಷನ್ ಇವನ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಹಿಮ್ ಇನ್ ಫಸ್ಟ್ ಫ್ಲೋರ್ ಪೋರ್ಷನ್ ಮೈ ಲಾರ್ಡ್, he says I am a tenant ಅಂತ. ಎಂಟೈರ್ ಇದಕ್ಕೆ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್ ಫಾರ್ ಬೋತ್ A and B schedule. My lord, he wanted to throw out. As on today, I am in position. I am continued. In my suit, in fact, he made an attempt for rejection of the plight. I have filed objections. Matter is also heard. Because in pursuance of the orders passed by this honorable court, my lord, I am not in a position to pursue my IA also there, because the honorable court says that some orders are passed in this suit. So in my suit also, so far it concerned to my a portion of the property which was bequeathed and where I have continued from 2008 to till today, my lord, it could not possible. So my humble submission, my lord, status quo order, what is as and today. And so at consent to this suit, it may be heard on merits. I will also place all my documents and also the documents produced by them. It can be taken into consideration on main also, my lords, please, on appearance of the other side. Now, my lord, if this order is continued, you will not allow, and I like to
Copy
pass.
serve ಮಾಡ್ಕೊ ಬನ್ನಿ other side, then we'll
Huh?
see. Copy serve ಮಾಡ್ಕೊ ಬನ್ನಿ other side.
ಮಾಡ್ತೀನಿ, ಮಾಡ್ತೀನಿ.
Appellant
ಇದರಲ್ಲಿ
counsel-
ಆರ್ಡರ್ 39 ರೂಲ್ 1 and 2 ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದೆ ಸ್ವಾಮಿ.
Appellant counsel is directed to
ಇದರಲ್ಲಿ
send a copy of this
ಎಂಟೈರ್ ಇದೆ ಸ್ವಾಮಿ.
appeal memo on
ಪ್ರಾಬ್ಲಮ್ ಐ ಹ್ಯಾವ್ ಫೇಸ್ಡ್.
other side.
Schedule may kindly be carried and order also. Sought for relief for both A and B. Scheduled properties and premises ಅಂತಾರೆ, scheduled properties. Order is granted as prayed for. ಅಲ್ಲಿ A at least A ಗಿದ್ದಿದ್ದು ಅವ್ರ ಲೆಕ್ಕದಲ್ಲಿ, B ನಾನಿರೋದು ಅದು ಬಿಟ್ಟಿದ್ರು ಸರ್ ಹಾಗಿಲ್ಲ ಸ್ವಾಮಿ. The annual trial court has not taken into consideration of anything. Only in one page order for 50 pages of order, one page says that he is having gift deed, so I passed the order. So at least status quo order, my lord, till then. Till then, as and today, what is existing there on my lord?
But rental agreement ಇದೆಯಲ್ಲ
ಸ್ವಾಮಿ ಇಲ್ಲ ಸ್ವಾಮಿ, ಎಲ್ಲ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಕೊಟ್ಟು ನಾನು ಯಾಕೆ ಕೊಡ್ಲಿ ಸ್ವಾಮಿ, ತಾಯಿ ನನಗೂ ಅರ್ಧ ಅವ್ರಿಗೂ ಅರ್ಧ ಅಷ್ಟೇ ಅಲ್ಲ ಸ್ವಾಮಿ, ದೇರ್ ಆರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಈ ವಿಲ್ ಆದ ತಕ್ಷಣ ಸ್ವಾಮಿ, my brother has given consent for transfer of revenue record, I mean this power, electricity, power connection, water to take separately. ಆಮೇಲೆ I have also given one affidavit to my brother to separate his electricity and all the documents are there, my lord. And in fact,
ನೀವು ಫಸ್ಟ್ ಫ್ಲೋರ್ ಇದೀರಿ ಅಂತ ತೋರ್ಸಕ್ ಈಗೇನ್ ದಾಖಲೆ ಇದೆ?
ಸ್ವಾಮಿ
ಫಸ್ಟ್ ಫ್ಲೋರ್ ಇದೀರಿ ಅಂತ ತೋರ್ಸಕ್ ದಾಖಲೆ ಏನಿದೆ ಅಂದೆ?
ನಾನು I got the very will ನಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ.
ಈಗ ಹಾಕಿದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲ, ನಾನು ಕೊಡ್ತೀನಿ all those documents.
According to you are in.
And he has admitted, my lord. Please, my lord, kindly peruse page number 32, my lord. ಇದೆ plaint ಅಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ. Suit itself for ejectment. May kindly peruse page 32, my lords, please. Page 32 in the middle, swami. Adu plus page page 31 ನಲ್ಲಿ ನಾನಿರೋದು ಬರೀತಾರೆ. Dead end. The first defendant is my younger brother. Hence, the defendant family are continue residing in B schedule property. One portion in the first floor of the schedule A property as a tenant paying. Irli our claim ಹಾಗೆ ಇಲ್ಲ ಬೇಡ. Next ಇದರಲ್ಲೂ ಕೂಡ B schedule property ನಾನು ಇದ್ದೀನಿ ಅಂತ again this says my lord. And suit is for ejectment. According to him, I am a tenant where it is bequeathed to me and I continued also, my lord. So at least status quo order regarding this party's position as on today, my lord. And my in return statement also in detail I have stated, the honorable trial court extracted entire my return statement and their pleadings. Then finally in last page, points 1, 2, 3, then in one page, reasons is in one page for all the point number 1, 2, 3, and it says that his gift deed is there, revenue records are there in his name, so that he is entitled for an order. At least has not taken into consideration of the alleged first floor portion, whatever the respondent. ಇಲ್ಲೇನಾಗಿದೆ ಗೊತ್ತಾ ಸ್ವಾಮಿ, ಎರಡು ಪೋರ್ಷನ್ ಅನ್ನು ಮಿಕ್ಸ್ ಮಾಡಿಬಿಟ್ಟು he is claiming now. So ನಾನು ಫಸ್ಟ್ ಫ್ಲೋರ್ ಎಲ್ಲಿ ನಾನು ಮೊದಲಿಂದ ನಂದು ಕಂಟಿನ್ಯೂ ಇದೀನೋ ಅದನ್ನೇ ಬಾಡಿಗೆ ಅಂತ ಸೆಟಪ್ ಇಸ್ ಕ್ಲೈಮ್. Even I have plain copy, my lords, please, where he sought for ejectment of B schedule property, prayer, my lords, please. Direct the defendant to pay rent ಕೇಳ್ತಾರೆ and direct the defendant to quit, vacate and deliver vacant position of schedule B property ಅಂತ plain text.
The appellant counsel is directed to serve the copy of this appeal memo on the counsel who appears on behalf of the respondent before the trial court and list this matter on 6/12.
44. P. Narayanappa, V.B. Shivkumar.
Appellant in. My lord, appellant number 1 expired. And remaining appellants are the legal heirs on record. Respondent number 1 also, respondent 2 also expired. I filed memo. All the legal heirs are on record.
ಎಲ್ಲರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆ.
House.
ಹೇಳಿ ಏನು?
This is the partition shoot filed by the plaintiffs for the.
ಏನ್ ಮೇಡಮ್ ಅಕಾಮಡೇಷನ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ಟೈಮ್ ಕೇಳಿದಿರಿ, ಪ್ರತಿ ಸಾರಿ ಡೇಟ್ ಕೇಳಂಗಿಲ್ಲ. How many times court has to read the papers? Na ಬರ್ಕೊ ಬಂದಿದ್ದೀನಿ RPT. RPT ಅಂದ್ರೆ respondent counsel press time ಅಂತ. ಹೇಳಿ. Pass over. ಆಯ್ತು.
45, Kamaleshwara.
Very important.
Apply for response.
An appellant is the dependent before the trial court.
Your IA is rejected.
Yes. IA filed by the plaintiff came to be allowed.
Allowed and your IA is rejected.
Rejected.
IA
First, you
to-
kindly see,
It's last occasion I made a mention, my lords. Interim order was granted in this appeal saying that construction shall be put up subject to outcome of this appeal. Lords, your lordship suggested if the suit is to be disposed of, because PW1 is already examined, I am the plaintiff. And about 68 documents are marked. Now the stages for cross-examination. I will cooperate with the trial. Lordship may fix even 3 months, my lords, I'll cooperate and conclude the matter. Lords, his interest is completely protected if your lordships were to.
Suit is for?
Suit is for injunction. My lords, your lordships have already observed, my lords, that I'll not be entitled to claim equities.
ಕೊಟ್ರಿ ಅದೇನೋ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಟ್ರಿ.
interim order, my lordship, kindly see.
That is 15.
Interim protection is made in my favor, not for him. Kindly see the interim order passed by this honorable court.
This court.
Yes. Wherein it is made very clear that.
Date ಹೇಳಿ ಯಾವಾಗ?
My lord,
15/12. Correct, Allah?
15, 12.
15
Honorable,
15/12, my lords.
of 23.
yes.
15/12/23.
Detailed order has been passed.
Originally, the property belonged to Vishwabharati House Building Cooperative Society. Allotted the site bearing so and so, so and so, so and so.
Your lordships may observe, my lords, that I'll not claim any equities. Ultimately, if he is in a position to prove the title to the property, I don't think there's any way that I can prevent him from taking possession together with the constructions.
ಈ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಏನಾಗಿದೆ?
Lord's construction is
Kindly
completed and
see.
the property is occupied.
As on the date of filing this appeal, it was a vacant site.
No.
The operative portion of the order passed by this honorable kindly see. After hearing the learned counsel for the parties, this court is of the opinion that the matter is requires detailed hearing. Hence, post this matter after winter vacation 2023, it is made clear that any construction made by the respondent plaintiff in the suit scheduled property is subject to the result of this appeal.
ಆಯ್ತು.
They have
I'm-
taken the calculated risk.
I'm
And
actually,
there is no
I'm
positive
giving
direction
him,
to them to put up the construction.
as a matter of fact, if this is an offer which was made to me, I would have taken it. I'm saying your lordships may observe that I'll not claim
What is
equity.
the matter, sir?
Your lordships may observe that I'll not even claim equity.
They have taken the risk.
So that
They bound to have.
they will not be relegated, my lords, to another suit. So they can instead, my lords, if I'm not claiming equities, my lords, then they'll have the fruits of the decree whenever it's passed in their favor. There is a suit for injunction filed by them against my vendor. There is a suit for injunction which is filed by me. The question of title requires to be gone into. There is a flow of title in respect of my property in the manner in which I have claimed.
I am the appellate.
Whether
in
title suit is pending?
Lords, both the suits are injunction suits.
Oh, yes.
Both are injunction suits.
Extension suit.
Yes, both are clubbed. So if your lordships directs within 3 months, my lords, the matter could be. I'll not claim any equities because there is a. I will not come in the way.
Kindly see.
But I only suggested, my lord, that this is. I have no
The
difficulty.
interim order,
Let
my
them-
lord. The Lahad counsel for the respondent submitted 2 points. One is they have the benefit of interim order. One. Second, they suppressed the latest order of this honorable court. They pressed into service the previous order passed by this honorable court. For a moment, your lordship kindly see annexure B. There is a status quo. Both the parties were directed to maintain status quo. How my learned friend say that that order is in their favor? By that time, site was the vacant site. Annexure B, lordship kindly see. Para number 7 is operated. The trial court is directed to dispose of the IA number 1 and 2 filed by the plaintiff and defendant under order 39 rule 1 and 2 of CPC in OS number 7896/2022 in accordance with law within a period of 2 months from the date of receipt of copy of the order, and interim direction passed by the trial court directing the parties to maintain status quo shall be continued till disposal of the said application. My lord,
That order passed in the earlier.
Yes. First, what happened, my lord? They filed a suit for permanent injunction. Ex parte order was got. On the protection of ex parte order, they demolished the front wall of my compound. Immediately, I rushed before the court. I filed written statement with the counterclaim and also filed application under order 39 1 and 2 of CPC. After hearing my argument, the law and trial judge was pleased to modify the order. IA number 2 filed by me is allowed, and both the parties were directed to maintain status quo. After hearing both the sides, the very same order was confirmed by the trial court. Against that order, my lord, they prepared a MAP number 2102/2023 before this honorable court. This honorable court is also continued the same order till pending disposal of the IA number 1 and 2. The reason for this order is, my lord, the law and trial judge has not passed the speaking order. Only to pass the speaking order, the trial court was directed to dispose the matter. Finally, my lord, the law and trial judge, without considering any one of the documents produced by me, came to the conclusion that, my lord, they have made out a prima facie case, and accordingly, IA number filed by the plaintiff came to be allowed, IA number 2 filed by me came to be dismissed. My lord, before Lordship R. Natarajan, the matter was somewhat argued. My lord, wherein my Lordship has directed me to produce the document. In that connection, my lord, I produced one document, Lordship kindly see.
Yes, what is the error committed by the trial court in allowing and rejecting your application?
My lord, firstly, para number, Lordship kindly see. My lord, para number 16 of the impugned order. May I please, my lord?
Yes, 16.
16. But without going through the documents of the defendant, this court cannot conclude that prima facie case and balance of convenience is in favor of the plaintiff. Hence, this court gone through the documents produced by the defendant and the averment of this written statement. On plain reading of written statement and counterclaim, we can find a clever drafting that the counterclaim schedule is mentioned without mentioning the survey number and by mentioning only site number 373, formed by VBHCS. As per paper publication and other documents produced by the plaintiff, there are other survey numbers including in survey number 238 of Halage village, wherein the VBHC has itself declared that some misconception by Krishna Bhatt in his written statement. It is alleged that as he is a plaintiff and his counsel signed as he is the counsel for plaintiff in the verification portion. At the time of filing the return, kindly see, at the time of filing the return statement and counterclaim on 27/9/2023, he has produced only the copy of the order in MAP number 2858/2023. Also kindly see. The copy of the sale deed dated 23/11/1993 in respect of similar property and not the property of counterclaim schedule. Copy of the complaint given by the defendant before Lokayukta and copy of the conversion order dated 3/9/2023. It shows that without producing the document about his ownership, title or document or possession, he has merely prayed for permanent injunction against the plaintiff. Later, he has produced the photograph which shows broken compound wall, which displays that site number 372 belongs to B.S. Manjunath. He has argued that after grant of ex parte temporary injunction, it was demolished by the plaintiff. But there is no document to show that such compound wall existed there. The defendant himself produced the photograph showing the board depicting site belongs to Leela, but the same is not produced by the trial, by the plaintiff. These findings of the trial court is totally incorrect. I produced the document. In my additional document, lots of kindly see. in additional document, my lord, page number 74.
And what date you have produced?
It is produced, my lord, on
2/4/24?
through court. 15/12/2023, my lord. 15/12/2023. Part of the record, my lord.
15/12 ಯಾವ್ದಿಲ್ವಲ್ರಿ?
I produced, my lord, about 27 document.
ಯಾವ್ದೋ ಫೋಟೋ ಇಟ್ಟು ಹಾಕಿದಿರಲ್ಲ ಅದ?
The first document is the, my lord, photos, correct. This is the photo as on the date of filing this appeal. The status of the suitable property is this.
15/12/23.
Yes, yes, my lord. First, kindly see page number 74.
74.
This is the list of document produced before the trial court. Certificate copy though. This document is produced before the trial court on 16/12/2022. How many documents I produced, lordship, kindly see. The first one is photos in 3 numbers. The copy of the registered sale deed dated 3/2/2012 in respect to my property. The copy of the increment certificate dated 1/4/2011. The copy of the Kata certificate dated 6/3/2012. The copy of the Kata extract dated 6/3/2012 in the year 2012. The copy of the membership receipt. The copy of the sale deed dated 23/11/1993. The copy of the increment certificate. The copy of the possession certificate dated 21/9/1996. The copy of the Kata certificate dated 10/11/1998. The copy of the payment receipt in 3 numbers to the society by the vendor of dependent. The copy of the betterment charge payment receipt dated 9/11/1998. The copy of the taxpayer receipts from 1998 to 2012, 19 numbers. The copy of the payment receipts for transfer of Kata dated 6/3/2012. The copy of the approved layout plan. The copy of the police complaint acknowledgement dated 11/12/2022. The copy of the police complaint dated 11/12/2022. Iಷ್ಟು document ಅನ್ನ 16/12/2022 at the time of my counterclaim return statement I produced before the court. None of these document the learned trial judge looked at. The order passed by the trial judge, lordship, kindly see the order passed by the trial court date 20 November 2023. In fact, I produced it in the year 2022. All these documents are part of the record. Because of this mistake, my lord, the learned trial judge has not looked into any one of the documents produced by me and wrongly come to the conclusion that I have not produced any document. On the other hand, they have produced a document. And moreover, my lord, the order passed by this on annexure H, my lord, fully covered by the matter. What you find is annexure H, fully covered by the matter. Though I produced the copy of the order passed by this honorable court, the lawyer and learned trial judge ignored to consider the same. Annexure H, your lordship, kindly see. Annexure H, page number 84, my lord, in my paperwork. Here, the plaintiff and the plaintiff in the present suit are similarly situated. Both were purchased the property from Lankappa. They filed suit against the similarly situated dependent. Their application under order 39/192 came to be dismissed. Against that order, my lord, they prepared a MFA before this honorable court. This honorable court was pleased to dismiss the said MFA as they have not made out a prima facie case. Second, my lord, the mistake committed by the learned counsel for the respondent would be they proceeded into service the previous order. That order is also considered in the present suit, the present order. Lordship, kindly see.
ಏನ್ರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಒಂದ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ರಿಲೇನೆ ಮಾಡಿಲ್ಲ ಅವ್ರು ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
If your lordship feels matter requires a remand, I have no difficulty. Instead of remanding and rehearing the matter, I am giving them a better opportunity. Hearing takes place another 4 weeks or 6 weeks as the case may be. The trial will be concluded. They will have the fruits of the decree. If they
Now
don't
the
want,
nature of the property
But I-
entirely changed. They
now-
put up a
now-
steep building.
if your lordship observes no equities will be claimed, the court will consider only on the date of the suit as to whether they had a title to the property or I had title to the property for the purpose of claiming injunction. If it is determined, my lord, that I don't have title, I will not claim equities. Let them take the
When this
property.
honorable, no, my lord, when this honorable
Okay.
conclusion that the matter requires detailed argument, I am ready for argument. My
Very well, my
lord,
lords, I have no
cannot
difficulty.
interrupt the time.
Your lordship may set aside
My
this
lord,
order and
kindly see.
remand it for fresh consideration in a time.
108 of the, my paper book, lordship, kindly.
Yes, counsel, I will remand the matter because you have produced list of documents which have been placed before the trial court has not been considered. Unless those documents are considered, this court cannot sit and consider the matter, that's all.
Yes.
ಅಲ್ಲ ತಮ್ಮ ಆರ್ಡರ್ನೇ ವೈಲೇಟ್ ಮಾಡಿದ್ದಾರೆ. ತಮ್ಮ ಆರ್ಡರ್ ಎಲ್ಲವನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದೀರಿ.
ನೀವೀಗ
This part is also not considered.
ಏನ್ ಹಾಕಿದಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅದನ್ನ ಮಾಡಿಲ್ಲ, ಕನ್ಸಿಡರ್
ಈಗ
ಮಾಡಿಲ್ವಲ್ಲ.
ನೇಚರ್ ಚೇಂಜ್ ಆಗ್ಬಿಡುತ್ತಲ್ವಾ? ಮೊದಲು ಖಾಲಿ ಸೈಟ್ ಇತ್ತು, ಈಗ ಬಿಲ್ಡಿಂಗ್ ಆಗ್ಬಿಡುತ್ತು.
ಆರ್ಡರ್
ಈಗ ಅದೇನ ಕೇಳ್ಬೇಕು, ಅದ್ರಿಗೆ
ಆಯ್ತು, ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಏನಾಗಿದೆ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅಲ್ಲ ರೀ, ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದಾರಲ್ಲ ಅವತ್ತು ನೀವೇ
ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್
ರಿಸಲ್ಟ್ ಆಫ್ ದಿಸ್ ಅಪೀಲ್ ಅಂತಿದೆ.
The same can be continued as
Also
subject to
kindly
the
see.
Any construction made by the respondent plaintiff in the suit shall property subject to the result of this appeal ಅಂತಲೇ ಇದೆ.
ಅದ್ರಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ಬಿಲ್ಡಿಂಗ್ ಆಗಿತ್ತು. ಆ ಕೇಸಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಸ್ ಆಲ್ರೆಡಿ ಓವರ್. ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ಇಸ್ ಅನ್ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿಸೋ.
ಇದು 8388 ಆರ್ಡರ್ ರೀ. There are two appeals ಅಲ್ವಾ, 2997 of 24 and 8388
ಇದಾದ ನಂತರ ಅದಾಗಿದ್ದು. ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ಇಂಪ್ಲುಯೆನ್ಸ್ ಆಫ್ ದಿಸ್ ಆರ್ಡರ್ that I came to be dismissed. ಅದ್ರಲ್ಲಿ ಏನವ್ರೆ
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ, ರಿಮ್ಯಾಂಡ್ ಮಾಡ್ಬೇಕೋ ಬೇಡವಾ?
ರಿಮಾಂಡ್ ಮಾಡಿದೆ. ಈಗ ಸ್ವಾಧೀನಕ್ಕೆ ಐ ಲಾಸ್ಟ್ ದ ಪೊಸೆಷನ್ ಮೈ ಲಾರ್ಡ್ ಪೆಂಡೆನ್ಸ್ ಆಫ್ ದಿಸ್ ಅಪೀಲ್. ನಾನು ಸ್ವಾಧೀನಕ್ಕೆ ಮೈ ಲಾರ್ಡ್ ಇನ್ ಸಿಮಿಲರ್ ಸೆಟ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ ಮೈ ಲಾರ್ಡ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟೆಡ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಟು ಹ್ಯಾಂಡ್ ಓವರ್ ದ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಪೊಸೆಷನ್ ಟು ಮೀ because my lord they have taken the calculated risk. Lordship, kindly I have one order, lordship, kindly see.
Again, what is the stage of construction now?
Lords, we have completed it. We are already occupying the
ಆಗಿದೆ.
property.
ಆಗಿದೆಯಾ?
The construction is completed. We are occupying the property.
This honorable
Lords may make an observation, my lords, if the matter requires to be heard on merits, I have absolutely no difficulty. my
my
lord.
lord, all these
We,
things are
we-
very much
I really don't
in
understand, my
judgment.
lords. A person,
Intentionally, he has not brought the notice of this honorable.
But sir,
Really?
a person who's having
This is my lord.
absolutely no semblance of
The-
title to
the
the property
respondent
wants
has
to come
suppressed the
before the
fact.
court and trouble. Lords, may I just pass on the photographs, my lords, of the
Counsel,
present
now
status
you
of
are
the
not
property.
disputing that already they have put up the construction, ಹೌದಾ? They have already put up the construction. What is your prayer in your IA?
Entry matter, kindly see, my lord. Entry matter passed by this honorable court.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಈಗ ಓದಿದ್ರಲ್ರಿ ಅದೇ ಇಲ್ಲೇನ್ರಿ? ಈಗ ಓದಿದ್ರಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಅದೇ ತಾನೆ?
ಹೌದು, ಅದ್ರಲ್ಲಿ
Subject to the result of this appeal ಅಂತಿದೆ.
ಹೌದು.
ಈಗ subject result of this appeal would be remanding the matter to the trial court in view of non-consideration of your documents.
They cannot claim any equity, my lord. They cannot claim in the event.
ಕ್ಲೈಮ್ ಮಾಡಲ್ಲ ಅಂತ
ಅಲ್ಲ,
ಹೇಳ್ತಾರೆ.
in the event,
ನಾನೇ ಹೇಳಿದ್ದೀನಿ ಅವ್ರಿಗೆ.
my status of the suited property is a vacant site. In the event I succeeded that I am in possession, they bound to hand over the possession to me, my lord. If such order observation is
ಅವ್ರು
made,
ಹೇಳಿದಾರಲ್ಲ, we will not claim any equity ಅಂತ.
they have to, in the event of they lose the case, they have to hand over the
What-
possession to me.
What
with
it
the-
means
with the
by saying we
concession.
don't claim equities, the
With the-
council should have some maturity, my lords, with which they make the submissions. When we make a
told-
statement, they should understand.
Heard the appellant counsel and also the counsel appearing for the respondent. These two appeals are filed against the order passed by the trial court on IA number 1 and 2. ಎರಡು ಅಪೀಲ್ ಈ IA number 1 and 2 ಚಾಲೆಂಜ್ ಮಾಡಿ ಅಲ್ವಾ?
Please.
ಹೌದು.
ಒಂದು ಅವ್ರದ್ದು ಅಲೋ ಆಗಿರೋದು, ನಿಮ್ದು ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು.
Dismiss ಆಗಿದೆ.
Minutes, the connected appeal, it's different minutes.
ಕನೆಕ್ಟೆಡ್ ಏನ್ ಮತ್ತೆ?
ಅದರಲ್ಲಿ
Passed in a different suit.
8388 ಅದ್ರಲ್ಲಿ documents are considered, whatever documents they have produced.
ಅದನ್ನ ರಿಮೈಂಡ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಹಾಗಾದ್ರೆ ಡಿಲಿಂಕ್ ಮಾಡ್ಬೇಕು.
Dealing matter that can be considered separately.
Huh?
That
That
can be
has to be
considered
considered.
separately. It's in a separate suit.
ಡಾಕ್ಯುಮೆಂಟ್ ಏನಾಯ್ತಂದ್ರೆ
ಸರಿ, ಈಗ ಆರ್ಡರ್ಸ್ ಆನ್ OS ನಂಬರ್ 7897 of 22 ಇದೆಯಲ್ಲ, ಸಿಂಗಲ್ ಅಪೀಲ್ ಹಾಕಿದಿರ ಅದ್ರಲ್ಲಿ.
ಹೌದು, ಅದು ತಪ್ಪಾಗಿದೆ.
ನಿಮ್ಮ ಅಯ್ಯ ರಿಜೆಕ್ಷನ್, ಅವ್ರ ಅಯ್ಯ ಅಲೋ, ಎರಡಕ್ಕೂ ಒಂದೇ ಅಪೀಲ್.
ಇದರಲ್ಲಿ ಎರಡಕ್ಕೊಂದು ಅಪೀಲ್ ಹಾಕಿ, ಎರಡಕ್ಕೊಂದೇ ಅಪೀಲ್ ಹಾಕಿ.
ಎಲ್ಲ ಅವರು ಅದನ್ನೇ
ಅದರಲ್ಲಿ ಇನ್ನೊಂದ್ರಲ್ಲಿ
Filed against Lanka.
Lords,
My
strictly
application
speaking,
dismissed
they cannot
ಆಗಿದ್ದಕ್ಕೆ
maintain a
ನಾನು
single appeal.
MFA
Lords, when the
number
matter came up on the first hearing
10.7
date, I
2000.
told them that procedurally they are required to file another appeal.
Other appeal ಕೊಡಿ.
They have filed it as
Same suit or different suit?
different suit.
ಇದು ಡಿಫರೆನ್ಸ್
Different suit. I am not a party in that suit.
Registry is directed to delink the appeal 2997 of 2020.
ಓನ್ಲಿ ಒನ್ ಸಬ್ಮಿಷನ್ ಮೇಲೆ
ಹಾ?
ಎಲ್ಲ ಕಾಮನ್ ಡಾಕ್ಯುಮೆಂಟ್, ಕಾಮನ್ ಟೈಟಲ್ ಡೀಡ್,
ಎರಡು ಬೇರೆ ಬೇರೆ ಆರ್ಡರ್ ಇದೆ ಅಲ್ರಿ, ಎರಡು ಬೇರೆ ಬೇರೆನೆ ಮಾಡ್ಬೇಕು.
ತಾವೇ ಡಿಸೈಡ್ ಮಾಡೋದು ಒಳ್ಳೆ.
ಹಾ?
ಇದ್ರ ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ ಅದರಲ್ಲಿ ಇದೆ, ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ.
ಸರಿ, ಎರಡನ್ನು ಈಗ ಬೇರೆ ಬೇರೆನೆ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು. ಆ ಅಪೀಲ್ ಅಲ್ಲಿ ಕೆಲವು ಪಾರ್ಟೀಸ್ ಆರ್ ನಾಟ್ ದಿ ಪಾರ್ಟೀಸ್, ಹೌದಾ?
ಅದು ಏನಾಗಿದೆ
ಕಾಮನ್ ಆರ್ಡರ್ ಕೆನಾಟ್ ಬಿ ಪಾಸ್ಡ್.
ದಟ್ ಸೂಟ್ ವಾಸ್ ಫೈಲ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ದ ವೆಂಡರ್ ಆಫ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್.
Whatever it
ಅಂಕಪ್ಪನ
may be,
ವಿರುದ್ಧ ಆ ಕೇಸ್ ಹಾಕಿದ್ದು.
whatever
He is
it
the
may be.
purchaser from the
That's
vendor.
all documents are considered, orders passed.
He is the vendor, he is the
court,
purchaser.
Order passed by the Supreme Court, everything is considered, and my lords is injunction, this application is rejected, against which my lords an appeal is.
ಅದರಲ್ಲಿ ಮೈ ಲಾರ್ಡ್ ಕೈಂಡ್ಲಿ ಸಿ, ಅದರಲ್ಲಿ ಮೆಜರ್ಮೆಂಟ್ ಆಫ್ ದ ಸೈಟ್ ಇಸ್ 50 into 70 ಅವರದ್ದು, ಇವ್ರದ್ದು ಪೋರ್ಷನ್ 50 into 45.
ಪೋರ್ಷನ್ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ.
ಹಾ?
ಆಯ್ತು, ಎರಡು
ನನಗೆ
ಎರಡನ್ನು ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂದೆ.
ಏನಾಗಿದೆ ಅಂದ್ರೆ ನನಗೆ ಒಳಗಡೆ
ಸೋಲ್ಡ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಇನ್ ಪೋರ್ಷನ್ ಅಲ್ವಾ? ಮತ್ತೆ
ಅದಕ್ಕೆ ಎರಡನ್ನು ಒಟ್ಟಿಗೆ ಡಿಸೈಡ್ ಮಾಡಿ ಡಾಕ್ಯುಮೆಂಟ್ ವೈಸ್ ನನಗೆ ಈಸಿ ಆಗತ್ತಂತ ನಾನು ಐ ಪ್ರೊಡ್ಯೂಸ್ ಆಲ್ ಡಾಕ್ಯುಮೆಂಟ್.
ಅಲ್ಲ ರೀ, ಪಾರ್ಟೀಸ್ ಆರ್ ಡಿಫರೆಂಟ್ ಅಲ್ಲೇನ್ರಿ? Parties are different and property is also a different.
Yes.
Portion is different. I
ಅದರಲ್ಲಿ
don't know why this both are clubbed together.
Because they mentioned my lords.
My submission is
Orders are different, independent consideration.
ಅವರೇ
submission
mention
is-
ಮಾಡಿದ್ದು.
he is the vendor, he is the purchaser.
ಅದ್ರಲ್ಲಿ portion ಅಲ್ಲೇನ್ರಿ?
ಅದೇ
He has retained the remaining property. ಹೌದಲ್ವಾ? It appears at your request it is clubbed together.
Yes.
Yes, yes.
ಎರಡು ಇಯರ್ ಮಾಡೋದ್ ಬಿಡಿ, ಅದಕ್ಕೆ ಯಾಕೆ ಸಪರೇಟ್ ಆಗಿ ಮಾಡೋಣ?
ಅದೇ
ಒಂದ್ ರಿಮೈಂಡ್
document-
ಮಾಡೋಣ, ಒಂದ್ ಇನ್ನೊಂದ್ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ ಮೆರಿಟ್ಸ್ ಮೇಲೆ.
ಅಷ್ಟೇ.
ಬೋತ್ ಆರ್ಡರ್ಸ್ ಆರ್ ಆಗಿದ್ರೆ
ಈ ರೆಕಾರ್ಡ್ ಅವ್ರ ಜೊತೆ ಇರ್ಲಿ ಸ್ವಾಮಿ.
ಯಾರ ರೆಕಾರ್ಡ್?
ರೆಕಾರ್ಡ್ ಇದ್ದರೆ ನನಗೆ ಯಾಕಂದ್ರೆ ಆಲ್ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಐ ಪ್ರೊಡ್ಯೂಸರ್ ಇನ್ ದಿಸ್ MFA number 8388.
MFA 2997 of 2024 is delinked from MFA number 8388 of 23 since both are arising out of different orders on different suits. Different suits. List both the matters. ಯಾವ ತರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್, ಎರಡು ಒಟ್ಟಿಗೆ ಬರ್ಲಿ. ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
Lordships.
ಕಾರ್ಟೆಡ್ ಅಂತ ಮಾಡಿ
ಪಾಟಾಡ ಯಾಕೆ?
ನನ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಪಾರ್ಟ್ಲಿ ಮಾಡಿದ್ನಲ್ಲ ನಾನು.
ಪಾಟಾಡ ಎಲ್ಲಾಗಿದ್ದೀರಿ? ಮಾಡೋಣ, ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ, ಇವಾಗ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಮಾಡೋಣ. ಈಗ ಒಂದೇ ದಿವಸ ಪಾಟಾಡು ಬೇಡ, ಏನು ಬೇಡ.
ಅಲ್ಲ, ದಟ್ ಇಸ್ ಲೆಫ್ಟ್ ಟು ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್. ಮೈ ಲಾರ್ಡ್, ನಗುಗೆ ನಾನೇನ್ ಜೋಕ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಐ ಆಮ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ಮೈ ಕ್ಲೈಂಟ್. He don't want to laugh before the court.
ಆಯ್ತು.
This type of attitude I get.
Some maturity should be there in submissions.
10-12 ಆಯ್ತು. 10-12.
Lordships.
Ultimately, we have to get justice from the court. That's all.
46. Then Sridhar.
ಅದೆರಡು ಸಪರೇಟ್ ಡೀಲಿಂಗ್ ಆದ್ಮೇಲೆ ಎರಡನ್ನು ಸಪರೇಟ್ ಆಗಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಒಂದೇ ದಿವಸ ಹಾಕ್ಬೇಕು. 46.
Paying for appellant, my lord. Suit for partition, my lord.
Hmm.
Challenge the order of allowing the IA number 1 under order 13 and.
For not to alienate.
Yes, my lord.
ಹಾ, ಹೇಳಿ. What is the error committed by trial court in passing such an order?
Suit scheduled property, their contention is suit scheduled properties, ancestral and joint family properties. My contention, it is a self-acquired property of the appellant, my lord. Because the land bearing survey number 21 was purchased by the father of the dependent appellant in the year 1978, my lord. After he died in the year 2003, and children of the father of they have entered into the. They have filed a suit in the year 2014 for partition, my lord. Suit has been decreed in the year 2017 and final decree is drawn in the year 2021. As per the final decree, he has acquired the scheduled property. Scheduled property. It is a self-acquired property of the appellant, my lord.
Now this, who are all the parties?
Wife and daughter and wife has filed a suit, my lord.
Against whom?
Against father and husband, my lord. Daughter and wife.
Husband.
Yes.
Ah.
Daughter and wife has filed a suit against the father, and
This
partition number 1 has executed.
Venkatesh is the husband of
Husband of.
plaintiff number 2.
Yes, my lord.
ಹೌದಾ?
Yes, my lord.
First plaintiff is the daughter of first defendant.
Yes, my lord.
Defend number two yaru?
Brother of the defend number one, my lord.
Brother of the defend number one.
Yes, my lord.
Ah,
Since he has executed the registered gift deed in the year 2023.
who executed?
D1 has executed a registered gift deed in the year 2023 in favor of D2, my lord.
Ah,
Since it is a self-acquired property, my lord. From part, for 30 years, D1 is aged about 65 years, my lord. Since 30 years, he is suffering from asthma, TB and heart element. She is left defend number one, my lord. So she stayed separately. He is taking care of from party for 30 years under the shelter of.
brother is taking care of.
Yes, sir, he is under the.
Ah,
There are many panchayat have held. She is not taking care of husband, my lord. So she is filed a suit against the D1, my lord.
how this first defendant got the property?
78, his father has purchased, my lord.
Hmm.
In the 24 children have filed a suit, my lord. Partition suit. 2017, it came to be decreed, my lord. 7 and 21, it is FTP has drawn, my lord.
The father of this defend number one and two got the property in the year 1978.
Under the registered sale deed, my lord.
Sale deed purchase ಮಾಡಿದ್ದು.
Yes, my lord.
ಆಯ್ತು.
His father has died in the year 2003, my lord.
His father.
Yes, my lord.
Hmm.
Then they have filed in the 2014, my lord. Children,
There was an inter-se suit between the
Partition suit,
defend
my-
number one and two. ಹೌದಾ?
no, all the children of the Anumantappa has filed a partition suit, even including the daughters, my lord.
ಆಯ್ತು.
It came to be decreed in the year 17, my lord. And 2000,
Compromise decree.
yes, my lord.
ಹೌದಾ? ಹಾ.
Decree part, no, my lord, it is not compromised. FDP has been compromised. FDP and the scheduled property is acquired. D1 has acquired the scheduled property under the FDP 25 of 25, my lord.
What is the reasoning given by the trial court? While allowing the IA? Property which was acquired by Hanumantappaya was self-acquired property of Sri Hanumanthaya. That the partition of scheduled properties among the children of Tammayya through FDP was made as per section 8 of the Investigative Act. That the property inherited as per section 8 of Investigative cannot be said to be ancestral property by virtue of the so-and-so. The plaintiff, other hand, has not produced any document to show that scheduled property is ancestral property. It is the contention of the plaintiff that scheduled property is a joint family property and he has right in the scheduled property. The plaintiff has not produced any document to show that the scheduled property is ancestral property. The findings given in order deserves to be referred here. Getting the clarity on the nature of properties. The court at para number 1 had accepted the contention of the plaintiff that the scheduled property was purchased by Sri therein in the year 1978. From the facts of the judgment in OSO, court had no opportunity to examine whether the property was proportionally ancestral or joint family property in view of the death of Sri Hanumanthaya and his wife. That only other claimants were the children of Hanumanthaya. The court had not given findings whether the properties are self-acquired property. Sri Hanumanthaya is a joint family property acquired through the nucleus of the joint family properties. Hence, the finding given in is not conclusive to answer the question raised by the plaintiff. Other hand, has prima facie proved her case. The plaintiff has shown that the scheduled property was inherited by her father, Hanumanthaya. Joint family is an issue to be decided at the trial court. Other side appear agidara?
Notice.
Notice agilla.
Illa.
Appellant counsel is directed to serve the copy of the appeal memo on the counsel who appeared on behalf of the respondent and list this matter on 9/12.
47.
Srikanth says.
Srikanth, yes. Janardhan Ravi.
Plaintiff's appeal on an interim order. Plaintiff and defendant are sister and brother. Sister has filed a suit. Father acquired the property as a share in a partition deed. Therefore,
Here in the partition.
in a partition deed, father acquired. My brother is a party to the partition deed. I was not a party to the partition deed. Daughter was not made a share party to the partition deed. I am now saying that whatever has come to my father passed away. So whatever has come to the father, 50-50 between the brother, two siblings. We are only two siblings. That is a suit that I have filed. My brother has filed his written statement admitting relationship and admitting share. He only disputes the quantum of share. He says, no, you don't get 50%. You will get only 1/5 share because to the earlier partition deed with our father, there were 5 siblings. That is the only
Third of 1/5 share of Dodda Muddappa anta.
Correct. That is my brother's contention. I am saying no, what came to our father in partition, we are entitled to, it is his absolute share. So upon his demise, we are entitled to equal share.
Father died in which year?
Oh, my father died. 2003 is what I'm told.
2003.
Three. Lord, at para 12, initially interim order granted in my favor that my brother will not alienate the properties pending the disposal of the suit. At page 26, all that the trial court says at the confirmation of the interim order that everything has to await trial. Everything has to await trial, my lord, but prima facie, if in the written statement relationship is admitted and a share is admitted. The written
yes,
statement is produced at page 51. In written statement also, he says, yes, page 51, only quantum, para 10 note. Our father along with 4 brothers. Therefore, he says 1/5 share. Para 10, this defendant submits, that is my brother, late dot so-and-so, Byatappa, on the demise of Byatappa, the grandfather of parties, the sons of deceased Byatappa continued in occupation and enjoyment. In the year 1965, Dodda Muddappa, that is our father, of the parties herein expired. On account of demise of said Dodda Muddappa, status of joint family and much less the co-personally got distrusted as per the law prevailing at the point of time. Thus, the property devolved on class 1 heirs of Dodda Muddappa as per the provision of section 6. Property was to be enjoyed not as members of the family, and demise of Dodda Muddappa, the plaintiff, defendant and their mother got to their share of the property at the rate of 1/3 of 1/5 or a. That is the only controversy. As 1/3 of 1/5 baralla, Chandar Sen and all, my lord is familiar with it. Once our father got a share in the partition, it is his absolute property. We all are entitled to 1/3. This issue needs to be.
Whether father had executed any testamentary document?
Not as per the pleading.
During
No.
his lifetime, no.
No,
What is your prayer not to alienate?
not.
Yes, counsel.
The father is died in 1965.
1965.
House.
Aye.
That's right.
Father is died in 1965. The partition took place along with the uncles, the defendant's uncles, 4 members, in 2006.
2006.
2006. In the partition deed is not produced before the court. In the partition deed, along with the uncles, I have filed the objection statement, extracted the contents of the partition deed. Page 57.
Admittedly, partition was taken place in the year 2006 between the defendant and his uncles. Oda,
Defendant is uncle. Adu defendant.
of the share of the plaintiff and defendant number 1.
Defendant's father.
Defendant
Plaintiff and
father.
defendant's father.
Plaintiff and defendant father.
Father.
ಹೌದಾ?
ಅದರಲ್ಲಾಗಿದೆ.
ಮತ್ತೆ?
ಅದು ಆಗ್ಬೇಕಾದ್ರೆ, this is their land which has been regranted.
Hmm.
No, it was not regranted earlier.
Regranted in favor of whom?
Regranted in favor of the family,
Family.
along with all the members of all the 5 members.
And the 5 members, that is brothers of the.
Brothers of family.
father also.
ಅದನ್ನ ಅವರು 1965 ಅವ್ರ ತಾತ ತೀರೋದ್ರೂ ತಂದೆ ತೀರೋದ್ರು ಕೂಡ ಏನು ಮಾಡ್ಕೊಂಡಿರ್ಲಿಲ್ಲ. Defendant has taken a initiative and he got the regrant order ಮಾಡ್ಕೊಂಡು.
Anyhow, admittedly, she is entitled for a share in the property. Maybe your contention that she is entitled for notional share or a share equal to the defendant. That is. That has to be
ಅದಕ್ಕೆ
considered.
ಅವ್ರ ಶೇರ್ ಪ್ರಾವಿಷನ್ ಡೇಟ್ ಅಲ್ಲಿ ಇವ್ರ ಶೆಡ್ಯೂಲ್ ಏನ್ ಬಂದಿದೆಯೋ ಆ ಶೆಡ್ಯೂಲ್ ಪೂರ್ತಿ ಇವ್ರಿಗೆ ಪೂರ್ತಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಪೂರ್ತಿ ಶೆಡ್ಯೂಲ್ ಬರಲ್ಲ ಆಕ್ಚುಲ್ ಆಗಿ.
ಆಯ್ತು, ಅದನ್ನ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಡಿಸೈಡ್ ಅಲ್ವಾ?
ಇಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆಯಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲೇ ಮೆನ್ಷನ್ ಮಾಡಿದಾರಲ್ಲ.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್?
ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ.
Whether she is a party to the partition deed?
She is not party to the partition deed, but
how it is binding on
she has
her?
not made all the partners to the co-sharer to the suit. And the mother is alive. ಬೇರೆ 5 ಜನ ಏನಿದಾರೋ ಅವ್ರನ್ನ ಯಾರನ್ನೂ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ಅದರ ಅಲೈವ್
ಎಲ್ಲ ಇದಾರೆ.
ಬೇರೆ
ಮದರ್ ಇದಾರೆ. ಮದರ್ನು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ಅದರ ಆಮೇಲೆ
ಆಫ್ ದಿ ಪ್ಲೇಂಟಿಫ್ ಅಂಡ್ ಡಿಫೆಂಡೆಂಟ್. ತಂದೆಯವರು
ತಂದೆ ತೀರೋದ್ಮೇಲೆ ಯಾರ್ಯಾರು ಇದಾರ್ರಿ?
ತಂದೆ ತೀರೋದ್ಮೇಲೆ ಮದರ್ ಇದಾರೆ.
ಮದರ್, ಬ್ರದರ್, ಸಿಸ್ಟರ್,
ಪ್ಲೇಂಟಿಫ್
ಮೂರೇ ಜನ ಅಲ್ವಾ?
3 ಜನ. ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ 1/5 ಶೇರ್ ಬಂತಲ್ಲ, 1/5 ಬರ್ಬೇಕಾದ್ರೆ ಅದರ 4 members was uncles to this plaintiff and defendant.
ಆಯ್ತು,
ಅವ್ರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ಅವ್ರನ್ನ ಯಾಕೆ ಮಾಡ್ಬೇಕು? ಆಲ್ರೆಡಿ
ಯಾಕಂದ್ರೆ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ there is a
Already there was a partition alva.
ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ
ಹಾ.
ಆಸ್ ಪರ್ ದಿ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡ್ರೆ ತೊಂದರೆ ಇಲ್ಲ. ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ದೇರ್ ಇಸ್ ಸಮ್ ಕಂಡೀಷನ್ಸ್.
ಏನಂತ?
ಏನಾಗಿದೆ ಅಂದ್ರೆ ದೊಡ್ಡ ಮುದ್ದಪ್ಪ ಇಸ್ ದಿ ಫಾದರ್ ಆಫ್ ದಿ ಪಾರ್ಟೀಸ್. ಚಿಕ್ಕ ಮುದ್ದಪ್ಪ ವಾಸ್ ದಿ ಅನದರ್ ಅಂಕಲ್. That ಚಿಕ್ಕ ಮುದ್ದಪ್ಪ was given, he has no children. This defendant is taking care of ಚಿಕ್ಕ ಮುದ್ದಪ್ಪ and his wife. Now ಚಿಕ್ಕ ಮುದ್ದಪ್ಪ is also died. ಚಿಕ್ಕ ಮುದ್ದಪ್ಪ is given bequeath and in the document itself 1/5 share to this defendant.
ಆಯ್ತು.
ಆ 1/5 ಶೇರ್ ಚಿಕ್ಕ ಮುದ್ದಪ್ಪನ ಶೇರ್ ಪೂರ್ತಿ ಬಂದಿದೆ. ಅದನ್ನು ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಸೇರಿಸಿ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಆಯ್ತು.
ಇವಾಗ ಚಿಕ್ಕ ಮುದ್ದಪ್ಪ ಶೇರ್ ಇದೆಯಲ್ಲ, ಆ ಶೇರ್ಗೆ ಹೌ ದೇ ಕ್ಯಾನ್ ಎಂಟೈಟಲ್ ಟು ಓನ್ಲಿ ದೊಡ್ಡ ಮುದ್ದಪ್ಪನ ಶೇರ್ ಏನಿದೆ ಅದನ್ನ ನಾನು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದೀನಿ ಇದೆ ಅಂತ.
ಆಯ್ತು.
ಚಿಕ್ಕ ಮುದ್ದಪ್ಪನ ಶೇರು ಎಂಟೈಟಲ್ ಆಗಿರುವಾಗ ಅದು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ against the entire
Let the trial court decide who are all entitled for how many.
ಅದಕ್ಕೆ ಪ್ಲೇನ್ ಗವರ್ಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ. ಪ್ಲೇನ್ ಗವರ್ಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ.
ಸರಿ ರೀ, ಎಲಿನೇಟ್ ಮಾಡಿರ್ ಮತ್ತೆ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು?
ನಾವು we are not alienating it. We are not
undertaking.
we are not alienating it. Iವ್ರ ಮಗ
undertaking ಕೊಟ್ರಿ, that's all. Their relief is also same. During the pendency of this suit, not to alienate.
we are not alienating it, but only thing is PD disposal ಗೆ ನೀವು ಅವಕಾಶ ಕೊಟ್ರೆ ಬೆಟರ್ ಅಂತ ಕಾಣುತ್ತೆ. ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋದ್ರೆ ದಿನ ಸೂಟ್ ನಡೆಸೋದೆಲ್ಲ ಬರೋದಿಲ್ಲ, ಸೂಟ್ ನಡೆಸೋದಿಲ್ಲ.
ಈಗ ಅದು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀವಲ್ಲ MFA ನ.
MFA ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ, MFA ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ. ಸೂಟ್ಗೆ ನಾವು ಈಗ ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಅಂತ ನಾವು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಬಿಟ್ರೆ ದಿ ಸೂಟ್ ಮುಂದಕ್ಕೆ ಹೋಗ್ತಾನೆ ಇರುತ್ತೆ.
ಟೈಮ್ ಕೊಡೋಣ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕೆ. ಯಾವ ವರ್ಷ ಟೈಮ್ ಬೌಂಡ್ ಫಿಕ್ಸ್
Issues have been framed. It's for my evidence. I will lead evidence.
ಟೈಮ್ ಬೌಂಡ್ ಪೀರಿಯಡ್ ಯಾವ ವರ್ಷ? 22 ನಾ?
22.
ಬೆಂಗಳೂರಲ್ಲೇ ಇರೋದು, ರೂರಲ್ ಕೋರ್ಟ್.
ಹೌದು ಬೆಂಗಳೂರಲ್ಲಿ.
ಒಂದ್ ವರ್ಷ ಕೊಡೋಣ. ಬೆಂಗಳೂರು ರೂರಲ್. ಇಲ್ಲಿ ಬೇರೆ ಕಡೆ ಆದ್ರೆ 6 ತಿಂಗಳು 9 ತಿಂಗಳು ಕೊಡ್ಬೋದು. ಬೆಂಗಳೂರಲ್ಲಿ ಅದು ರೂರಲ್.
ಅಲ್ಲ ಇದು ಅಲ್ಲ ಒಂದು written statement. I'll read that written statement para. I extracted the
ಕೌನ್ಸಿಲ್ ಮತ್ತೆ why you are going back?
ಅಲ್ಲ ಗೋಯಿಂಗ್ ಬ್ಯಾಕ್ ಅಲ್ಲ. ಅಲ್ಲ ಯಾಕೆ ಅಂತಂದ್ರೆ ಅವ್ರಿಗೆ ಇವರು ಡಿಪೆಂಡೆಂಟ್ ಒಂದು 5,000 ರೂಪಾಯಿ ಕೊಟ್ಟು 20 ಗುಂಟೆ ಜಮೀನ ಅವರೇ ಡಿಪೆಂಡೆಂಟ್ ಕೊಂಡಿದ್ದಾರೆ.
ಅದೆಲ್ಲ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.
ಅಲ್ಲ ಇಟ್ ಇಸ್ ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್ ಇನ್ ಡಾಕ್ಯುಮೆಂಟ್. ಅವ್ರು ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಒಪ್ಕೊಳ್ತಾ ಇದಾರೋ ಅದನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಅದನ್ನ ತಿರ್ಗಾ ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಲ್ಲಿ ತಿರ್ಗಾ ಇವರು 1/5 ಶೇರ್ ಕೇಳಿದ್ರೆ ಹೆಂಗ್ ಬರುತ್ತೆ ಸ್ವಾಮಿ?
ನಾವೀಗ now we are not going to decide whether she is entitled for 1/5.
ಅಲ್ಲ ನಾವು ಅಲ್ಲ plain pleadings ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಓದ್ಬಿಡ್ತೀನಿ. ಇದು ಪ್ಯಾರಾ
I'll address my learned friends concerned that the suit will drag on. Within 1 year, let the suit be disposed of.
ಅಲ್ಲ page 57 ಅಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. One defendant further submit that the suit schedule item mentioned in the plaint B schedule property of the partition deed, the said share was fallen to his share in the partition deed. The clear recital by all the sharers or uncles of the defendant that ನಮ್ಮ ಹಿರಿಯರು ತಳವಾರಿ ನೌಕರಿ ಹಕ್ಕುದಾರರಾಗಿ ಇದ್ದುದರಿಂದ ತಳವಾರಿ ನೌಕರರಿಗೆ ಸೇರಿದ ಮೇಲ್ಕಂಡ ಕಟ್ಟಗುಲಲಿ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 7, 20, 23, 59 ಈ ಸರ್ವೆ ನಂಬರ್ಗಳು ಜಮೀನುಗಳು ತಳವಾರ ಇನಾಮತಿ ನೌಕರಿ ಜಮೀನುಗಳಾಗಿದ್ದು ಸರ್ಕಾರ ತಳವಾರ ನೌಕರಿ ರದ್ದುಪಡಿಸಿ ತಳವಾರ ಸರ್ಕಾರಿ ನೌಕರಿ ಜಮೀನನ್ನು ಗ್ರೀಗ್ರಾಂಟ್ ಮೂಲಕ ವಂಶಸ್ಥರೇ ಅನುಭವಿಸಿಕೊಂಡು ಬರಬಹುದು ಎಂಬ ಸರ್ಕಾರಿ ಆದೇಶದ ಪ್ರಕಾರ ಮೇಲ್ಕಂಡ ರೀಗ್ರಾಂಟ್ ಜಮೀನುಗಳನ್ನು 1938-39 ಸಾಲಿನಲ್ಲಿಯೇ ರೀಗ್ರಾಂಟ್ ರೆಕಾರ್ಡ್ ಆಗಿದ್ದು ಇದುವರೆಗೂ ಮಂಜೂರಾಗದೆ ನಿಂತಿದ್ದ ರೆಕಾರ್ಡ್ಗಳನ್ನು ನಮ್ಮಗಳ ಪೈಕಿ ದೊಡ್ಡ ಮುದ್ದಪ್ಪನ ಮಗ ಆಂಜಿನಪ್ಪ ಈ ರೆಕಾರ್ಡ್ ಸಂಬಂಧಪಟ್ಟ ಕಚೇರಿಯಿಂದ
go to the reasoning of the trial court itself. Paragraph number 12. From the version of the plaintiff and defendant, it is observed that there is a dispute with regard to the existence of joint family status as on the date of filing of the above suit. The plaintiff has admitted the partition deed dated 6/8/2006. Admittedly, the said partition deed is between the defendant and the uncles of defendant and their children with respect to the ancestral and joint family properties. Admittedly, the plaintiff is not the party in the said partition deed. ಇಷ್ಟೆಲ್ಲ ಬರೆದ್ಬಿಟ್ಟು ಕೊನೆಗೆ ಅಯ್ಯ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. said partition is executed on 6/8/2006 subsequent to the amendment of ಅದು ಬರ್ದವ್ರೆ Succession Act. However, the defendant has contended that if at all the plaintiff is entitled for any share, that would be in the notional portion, that is out of the share of the plaintiff's father. Plaintiff would get 1/30 share in the property of her father, Dodmudappa. If it is pertinent to note that as per the defendant, some of the suit properties are self-acquired property. Ishalla helputtu IA is rejected.
ಅಲ್ಲ self-acquired property
error apparent on record.
ಅಲ್ಲ self-acquired property of the defendant. ಅದ್ರ ಮೇಲೆ ಹೆಂಗ್ ಮಾಡಕ್
I told, heard the appellant counsel and also the counsel appearing for the respondent. This appeal is filed against the rejection of IA filed under Order 39 Rule 1 and 2 of CPC, where the plaintiff has sought for the relief, restraining the defendant from alienating the suitable property pending disposal of the suit. It is the case of the plaintiff that suitable properties are ancestral and joint family properties, and there was a partition between the father and their uncle. And the property properties are allotted as per the registered partition deed dated 5/8/2006. Under the said partition, some of the suitable properties have been allotted to the share of defendant herein. Further, the house properties have been acquired by the defendant by way of succession, and all the revenue records are transferred in the name of defendant. The plaintiff, being the younger sister of the defendant, is in joint possession and enjoyment of the suitable properties, which are the joint family and ancestral properties. Plaintiff has requested to effect the partition, and the same was postponed by the defendant one or the other pretext, but ultimately he rejected the request, and hence without any other alternative filed the suit for the relief of partition. And also inter-alia sought for the relief of temporary injunction restrain the defendant from alienating the property. The defendant appeared and filed a written statement and took the specific contention that she is the sister of defendant and daughter of late Doda Muddappa. However, contend that mother of the plaintiff is also, plaintiff and defendant is also alive, and the said fact has been suppressed. The suit is bad for non-gender of necessary party, and also admitted the earlier partition dated 5/6/2006. It is contended that suit is barred by limitation, since she has abandoned her right ever since the time of marriage. And also contend that defendant has spent money by raising loan. It is also contended that the said Doda Muddappa died, and his brother one Sri Doda Batappa. ಅವನ ಇನ್ನೊಬ್ರು ಅಂಕಲ್ ಹೆಸರೇನು?
ಚಿಕ್ಕಮುದ್ದಪ್ಪ.
ಚಿಕ್ಕ
ಮುದ್ದಪ್ಪ also died, and he was not having any issues, and his share is also allotted in favor of the defendant. And also property devolves on the class 1 heirs of Doda Muddappa as per section 6 of the Hindu Succession Act 1956. However, it is contended that on the demise of said Muddappa, the plaintiff, defendant and their mother got their share in property at the rate of 1/3 of 1/5 each. And also contend that it is a self-acquired property of defendant. The trial court, having considered the grounds which have been urged in the application as well as in the written statement, also taken note of the contentions of the parties. In paragraph number 12 comes to the conclusion that admittedly the said partition deed between the defendant and the uncles of defendant and their children with respect to the joint family properties. Decision. ಹೇಳಿ.
2017 ಕೊಡ್ತೀನಿ. 2017 5 KCCR 576. The Civil Procedure Code, Order 39 1 and 2. Temporary injunction. Plaintiff has admitted certain transactions among members of family in absence of any specific details and absence of any challenges to original registered documents and absence of any prayer to that effect. It is not possible to grant temporary injunction. There is no clarity as to which property is intact and which property is already executed as on the date of suit. Any transaction took place subsequent to filing of suit.
How this principle is applicable?
Principle means that
there is no any
there is no
transaction at all.
pleadings in the plaint. There is no pleadings in the plaint.
ಇಲ್ಲಿ ಏನಿದೆ transactions ಏನಿದೆ?
Registered partition deed ಅಲ್ಲಿ
Partition between only the brother and other uncles.
uncles, ಆ ರಿಜಿಸ್ಟರ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ದೇ ಆರ್ ಡಿಪೆಂಡ್ ಅದರಲ್ಲಿರೋ ಏನೇನ್ ಟರ್ಮ್ಸ್ ಅಂಡ್ ಕಂಡೀಷನ್ಸ್ ಇದೆಯೋ ಪ್ರೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದಿರಾನೆ ಎಂಟೈರ್ ಸಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಏನ್ ಬಂದಿದೆ ಡಿಪೆಂಡೆಂಟ್ ಗೆ ಅದೆಲ್ಲ ಪ್ರಾಪರ್ಟಿನ ಸೇರಿಸ್ಬಿಟ್ಟು ಮಾಡೋದ್ರಿಂದ ಬರೋದಿಲ್ಲ ಅಂತ ನಾನು
ಆಯ್ತು ಹೇಳೋಣ. And also made an observation that property, there was a partition between the defendant and his uncles, and also properties are ancestral and joint family properties. And also taken note of the said partition is executed on 6/8/2006. And also made an observation that in view of the defense taken by the defendant, she is entitled for notional partition, that is 1/30th share in the property of her father Dodamuddappa. Having considered all this aspect, but IA is rejected and hence the present appeal is filed. The counsel appearing for the appellant would contend that when there is a partition between the first defendant and his uncles, and also when there is no dispute with relation to the parties, and also the nature of the properties also, and also when there is a clear admission on the part of the defendant in the written statement itself that she is entitled for 1/3 share out of 1/5 share of their father, and trial court ought not to have rejected the application. And prayer is also sought only to protect the property and in order to avoid multiplicity of proceedings. And hence trial court committed an error and also brought to notice of this court observation made in paragraph number 12 of the order of the trial court. Per contra, the counsel appearing for the respondent would contend that the defendant number one not dispute the relationship between the parties. However, he contend that in the earlier partition of the year 2006 with regard to another uncle who is not having any issues, and his property was allotted in favor of the first defendant since he had taken care of the uncle and also not entitled for any share in that property. And also counsel would contend that she kept quiet even though father died in the year 1965 itself, and now making the claim, and hence suit is also barred by limitation. The counsel also relies upon the judgment reported in 2017 within bracket 5 KCCR 578 and brought to notice of this court rejection of IA, wherein an observation is made that the certain transactions among members of the family was taken place, and there is no any specific details and absence of any challenge to alleged registered documents and absence of any prayer to that effect. It is not possible to grant temporary injunctions. The counsel relying upon this judgment would contend that when there is already a partition, wherein the defendant number one was a party to the said partition, the same has not been challenged. In question of granting any temporary injunction does not arise. Having heard the appellant counsel and also the counsel appearing for the respondent, and also taking into note of material available on record, it is not in dispute that there was a partition between the first defendant and his uncles. It is also not in dispute that plaintiff is the sister of the first defendant. And also it is the contention that the mother has not been made as party to the proceedings. Not in dispute that suit is filed for the relief of partition. And also the very contention was taken that non-joinder of necessary party. But the relief is sought not to alienate the property during the pendency of the suit, or otherwise it will amount to a multiplicity of proceedings. Having perused the defense taken in the written statement itself that the defendant took the contention that only the plaintiff is entitled for portion of the property and not in entirety as claimed, and not entitled for the relief as sought. And the same is a matter of trial, whether she is entitled for share or not. But admittedly, there is an admission with regard to the property was acquired through a partition wherein the plaintiff is not a party to the said partition, and defendant number one entered. Defendant number one is a party to the said partition deed, and which discloses dividing the property of the father as 1/5 share out of the entire property. There is a reference of the trial court that property is an ancestral property, and also there is a defense in the written statement itself that property devolves under section 6 of the Hindu Succession Act. When such admission is given in the written statement, as well as the trial court also in paragraph number 12 discussed in each aspect, it also comes to the conclusion that plaintiff is also entitled for share in the property. But in the written statement also contended that 1/3 of 1/5 share of Dodda Muddappa. And when such contention is taken, and also when the trial court comes to the conclusion that plaintiff is entitled for share in the property also, ought not to have rejected the application wherein relief is sought. On rejection of the application, it will leads to multiplicity of proceedings if the properties are sold. And hence trial court committed an error in
Extent of
rejecting the
that share, the extent of that share, I'm not able to.
rejecting the application, and hence it requires interference of this court. In view of the discussions made above, I pass the following order. Appeal is allowed. The order passed by the trial court on IA is set aside, and consequently IA filed by the appellant is allowed in restraining the defendant in alienating the suit settled property as sought in the IA till the disposal of the suit. The trial court is also directed to dispose of the suit within a time bound period of 1 year, and both the plaintiffs and defendants are directed to assist the trial court in disposal of the suit within a time bound period of 1 year.
Grateful.
Your mother ನೀವು ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗತ್ರಿ without the mother. you
I've
cannot-
advised,
ಹಾ.
I've advised that, but do it. Grateful, man.
48. Shravan S. Lokre, Chukka Reddy.
Notice was not served.
ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ವ ನಿಮ್ಗೆ ಕೇವಿಟಾರ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾವಾಗ
Copies served and filed.
ಕೊಡ್ರಿ
Copies served acknowledgement.
ಏನ್ ಸರ್ವ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀರಾ?
Respondent number 17.
ಹಾ?
Respondent number 17.
ಯು ಆರ್ ಫಾರ್ 17 ಕೇವೇಟರ್. ಅಪೀಲ್ ಕಾಪಿ ಕೊಡ್ರಿ ಅವರಿಗೆ ಕೇವೇಟರ್ಗೆ. ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ ಹೇಳಿ?
Objections ಇತ್ತು.
ಹಾ?
Office objection ಇತ್ತಂತೆ, ಕಂಪ್ಲೈ ಮಾಡಿದಾರಂತೆ.
ಯಾವಾಗ ತಗೊಳ್ರಿ?
ಅಲ್ಲ ನಮಗ್ ಕಾಪಿ.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡುವ ನೋಡ್ರಿ, ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್. ಹಾಕಿದಿರಿ ಅಕ್ನಾಲ್ಮೆಂಟ್.
In this matter, my lord,
ಹಾ,
I am the purchaser. Before filing the.
ಅದಾಯ್ತು. ಫಸ್ಟ್ ಹೇಳಿ ನೀವು ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೇಳಿ. ಕೇವೇಟಾರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನೀವ್ ಅಂದ್ರಿ. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ಯಾ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇತ್ತ ಮೇಡಮ್? ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ? ಮತ್ತೆ ಹೆಂಗ್ರಿ ಕೇಳ್ತೀರಿ ನೀವು ಕಾಪಿನ? ಕೇವೇಟಾರ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತಾನೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು. ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಕಂಪ್ಲೈಡ್. Then how you can seek one more copy? ಯಾವತ್ ಸರ್ವ್ ಮಾಡಿದ್ರಿ ಹೇಳ್ರಿ? ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆಯೇನ್ರಿ ನಿಮ್ಮ ಹತ್ರ?
Acknowledgement ಆಫೀಸ್ಗೆ ಹಾಕ್ಬಿಟ್ಟಿದಾರ.
ಇದೆಯಾ? ಕೊಡಿ. Memo of the petitioner having served the copy. Stubbornness, okay. Kindly accept this memo on record. ಎಲ್ಲಿದ್ದಾರೆ ಅಕ್ನಾಲ್ಮೆಂಟ್ ಇದ್ರಲ್ಲಿ? ನೀವು ಬರೀ ಮೆಮೋ ಹೇಳಿದ್ರೆ I have served the copy of the appeal memo along with annexures in the above appeal to the counsel for the caveator representing the respondents in the above appeal in compliance of the office objections ಅಂತಿದೆ. ಎಲ್ಲಿದೆ ಅಕ್ನಾಲ್ಮೆಂಟ್? ಎಲ್ಲಿದೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ಕೆ? ಮೆಮೋ ಹಾಕಿದಿರಿ. ವೇರ್ ಇಸ್ ದಿ ಅಕ್ನಾಲ್ಮೆಂಟ್ ಫಾರ್ ಇರ್ಬೇಕು ಮೋಸ್ಟ್ಲಿ. ಇದೆ ನೋಡಿ, ಇದೆಯಲ್ರಿ 7-8 ಅಲ್ಲಿ?
ಇಲ್ಲ ಸರ್.
ಇದು ನಿಮ್ದಲ್ವ ಸಿಗ್ನೇಚರ್?
ಅಲ್ಲ ನಮಗ್ ಸರ್ವ್
7/8/2024 ಅಲ್ಲಿ ತೋರಿಸಿ ಅವರಿಗೆ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ಮೇಲೆ ನಿಮಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ.
ಇದು ನಮ್ ಸೈನೇ ಅಲ್ಲ ಇದು. ಇದು ನಮ್ ಸೈನೇ ಅಲ್ಲ ಇದು. ನಮ್ ವಕಾಲತ್ ನೋಡಿ ಸರ್.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಈ ಕೋರ್ಟಲ್ಲಿ ಇನ್ಮೇಲೆ ನಾವೊಂದು ಕಮಿಷನ್
ನಮ್ದು ವಕಾಲತ್ ನೋಡಿ. ಎನಿ ಆಫ್ ದಿ ಕಾಪಿ ಇಸ್ ರಿಸೀವ್ಡ್ ಮೇಡಮ್.
ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಇದೇ ಆಗ್ತಿರೋದು.
Copy is received.
The copies were also served. You have contacted them as far as.
ನಿಮ್ಮ ಆಫೀಸ್ ಸೀಲು ಇದೆಯಲ್ರಿ? ಸಿಗ್ನೇಚರ್ ವಿತ್ ಸೀಲು?
ಅಲ್ಲ ಅದು
ಅವರ ಸಿಗ್ನೇಚರ್ ಮಾಡಿಸ್ಕೊಂಡು ಸೀಲ್ ಹೊಡೆದ್ಬಿಟ್ರಾ?
In all fairness, it was served.
ನಮ್ಮ ಸಿಗ್ನೇಟರಿ ಅಲ್ಲ, ನಮ್ ವಕಾಲತ್ ನೋಡಿ.
ಅಲ್ಲ ರೀ, ನಿಮ್ ಸೀಲ್ ಹಾಕಿ ಸಿಗ್ನೇಚರ್ ಇದೆ. ನಿಮ್ಮ ಆಫೀಸ್ ಸೀಲ್ ಹೌದಾ ಅಲ್ಲ ಇದು ಹೇಳಿ? ನಿಮ್ ಕೊಲೀಗ್ಸ್ ಯಾರು ತಗೊಂಡಿರ್ತಾರೆ? ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಯಾರು ಇಲ್ವಾ?
ಆಫೀಸರ್ ಬೇರೆ ಇದಾರೆ.
ನೋಡಿ ಮತ್ತೆ ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಹೌದಾ ಇಲ್ಲ ನೋಡಿ. ತೋರ್ಸ್ರಿ ಅವರಿಗೆ. ಅವ್ರು ಬೇರೆ ಕೊಲೀಗ್ ಸಿಗ್ನೇಚರ್ ಹೌದಾ ಅಲ್ಲ ನೋಡಿ ಹೇಳಿ. ಡೋಂಟ್ ಮೇಕ್ ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ನಿಮ್ ಸೀಲ್ ಇದೆ. ನಿಮ್ಮ ಆಫೀಸ್ ಸೀಲ್ ಹೌದಾ ಅಲ್ಲ ಅದು?
ಸೀಲ್
ಅವರೇ ಬಂದು ಸೀಲ್ ಹೊಡ್ಕೊಂಡು ಸೈನ್
ಸೀಲ್ ನಮ್ದೇ ಇದೆ.
ನಿಮ್ದೇನೆ?
ನಮ್ದೇ
ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ ನಿಮ್ದು?
ಸಿಗ್ನೇಚರ್
ಆಯ್ತು, anyhow ready ಇದ್ರೆ?
I was ready.
ಹಾ,
If you want time, you could have asked why all these submissions.
ಅದನ್ನೇ ಹೇಳುದು. If really you
I
have
am
need
not
of,
asking any time, my lord. It is
That's the
only.
meaning of all this.
ಮತ್ತೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿರ್ರಿ. ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ಏನ್ ಮಾಡೋಣ? 1:33. ಲಾಂಗ್ ಬ್ಯಾಕ್ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು ಕಾಪಿ ನಿಮ್ಗೆ.
Please.
ಮತ್ತೆ ಇನ್ನೊಂದು
ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ at 2:30. ಇನ್ನೊಂದು ಕಾಪಿ ಯಾಕೆ ಮತ್ತೆ ನಿಮ್ಗೆ? ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನನ್ನ ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ ಅಂತವ್ರು.
ಏನೇನೋ submission open
ಅಲ್ಲ.
court ಅಲ್ಲಿ. ಏನೋ ಆಚೆ ಹೇಳಿದ್ರೆ ಒಂದು
Junior sir
Counsel,
ತಗೊಂಡಿದ್ದಾರೆ.
Being the senior counsel, not venture to this.
My junior sir ತಗೊಂಡಿದ್ದಾರೆ. ಫೈಲ್ ಇರದೆ ಇದ್ದಕ್ಕೆ. Yes,
ಹೇಳು.
received the copy.
ನಿಮ್ ಜೂನಿಯರ್ ತಪ್ಪು ಮಾಡ್ದ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವು ಇಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತೆಲ್ಲ ಸುಳ್ಳು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ
ಅಲ್ಲ, ಫೈಲ್ ಸಿಕ್ಕಿಲ್ಲ ನಮ್ಮ ಆಫೀಸ್ ನಲ್ಲಿ ಅದಕ್ಕೆ.
ಫೈಲಲ್ಲಿ ಸಿಗುತ್ತೆ. 7-8 ಕಾಪಿ ಸರ್ವಾಗಿರೋದು. ಆಯ್ತು, ಎನಿ ಸಬ್ಮಿಷನ್ಸ್ ಎನಿವನ್? 51 ಹೇಳಿ ಏನಾಗಬೇಕು? ಅನಿಲ್ ಕುಮಾರ್, ವಿಶ್ವನಾಥ್ ಶೆಟ್ಟಿ ಇದಾರೆ. Appellant counsel seeks time and counsel for respondent says no objection. List this matter on 10-12.
Serial number 50 minutes.
D2 restrained ಏನೋ ಇದು? Alienating the property. ನಾ ಏನಿದು?
But serial
Next.
number 50 minutes.
50.
ಅರ್ಧ ಗಂಟೆ, but there is a matter at 2:30 minutes.
50. ಹಾ ಹೇಳಿ.
So I'll be here by 3 o'clock minutes.
ಹಾ.
Just
Order 9 rule 13. ಯಾರು ಅದರ್ ಸೈಡ್ ಇದಾರಾ? ಹಾ.
I'll be here by 3 o'clock minutes.
3 o'clock ಒಂದು ಟೈಮ್ ಕೊಡಲ್ಲ, ಯಾವಾಗ ರೀಚ್ ಆಗುತ್ತೋ ಅವಾಗ.
ನನ್ಗೆ ಅಕಸ್ಮಾತ್ ಅಷ್ಟೊಳಗೆ ರೀಚ್ ಆದ್ರೆ
ಆಯ್ತು.
ಪಾಸ್ ಓವರ್
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್. ಎನಿ ಅದರ್ ಸಬ್ಮಿಷನ್ಸ್? ಇಲ್ಲ, ಇಬ್ರು ಇದ್ದೀರಾ ಬೋತ್ ಸೈಡ್ಸ್? ಇಲ್ಲ, ಆಯ್ತು.
ಅದನ್ನ ಮಾರ್ಕ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಆಯ್ತು.
ಮೇಡಮ್ 59 ಏನಾರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ರೆ ನೋಡಿ. ಸರಿ. Kalburgi.
229, 230. Kalaburgi bench.
Matter pertains to Kalburgi bench. Serial number 1, Mahantesh Patil.
Minutes. I have filed the charge sheet along with minutes memo and I have produced the earlier judgment passed by this honorable court. And along with memo minutes, I produced the first order minutes 2000524 of 2022 pertains to accused number 2 minutes. And the next 200703 bar 2022 pertains to the accused number 1 petitioner, which is produced at page number 8 minutes. And the next is accused number 3, that is your lordship's order, criminal petition number 201651 of 2021 minutes, accused number 3. And the present petitioner is accused number 1 minutes. And he is not in judicial custody from 5/9/2021. And there are eyewitnesses, not CW4, 12 and 13 are the eyewitnesses. But since he is in custody and charge sheet is filed, my lords, the prosecution, my lords, not examined the witnesses and it is posted for the evidence of CW1 to CW4. And accused number 2 and 3. The accused number 2, the allegation is that he has poured the chili powder in the eye of the deceased, and thereafter the present petitioner, accused number 1, committed the murder of the deceased. This is the allegation. And accused number.
What is the overt act allegation against this petitioner?
This petitioner, he has used the dragger and committed the murder by assaulting the deceased. And the accused number 2, who poured the chili in the eyes of the deceased. And accused number 3, who has instigated before earlier to the 1 day of the incident. But my submission, since he is in custody from 5/9/2021, and there is no progress in the trial, and already the charge sheet is filed, and accused number 2, who is brother of the present petitioner. That is why my request is not at least if he has enlarged on bail, and the no prejudice would be caused to the prosecution. Already he has spent nearly about 3 years in judicial custody.
Order sheet kodi, madam.
And while granting the bail to the accused number 1, this court observed that not since already charge sheet is filed, the continuation of judicial custody would amount to pre-trial detention.
Who appears for state? HCGP? Last time ಇದ್ದಂಗಿಲ್ವಾ? ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇದೆ, ಸೇಮ್ ಅಡ್ವೊಕೇಟ್.
ಹೌದು.
ಇಲ್ಲ ಫೈಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ 6/11 ಅಲ್ಲಿ.
ಅದಾದ್ಮೇಲೆ they did not appear 2 times. In the connected matter, your lordships have observed that because of their non-appearance, it is urgent.
Third. Heard the petitioner counsel and HCGP was absent in the previous occasion and today no representation, and though took time to file the statement of objection on (6/11/24), till date objections not filed, not pursuing the matter. The factual matrix of case of the prosecution that this petitioner, the accused number 3,
The accused number 1. Accused number 1.
on 39/21 went and scolded him to open the garage and caused the life threat. And when accused number 1 caused the life threat, accused number 3 instigated him not to leave him. And once again on 4/9/2021, at around 1:25 p.m, when the deceased and CW4 proceeding in the motorcycle, at that time accused number 1 and came in their motorcycle and scolded him. And when the CW4 came forward to pacify the galata, caused the life threat to him. And immediately accused number 2 poured chili powder on him, and accused number 1 inflicted injury with the dragon which he brought along with him mercilessly and caused the injury. As a result, he succumbed to the injuries. The police investigated the matter and filed the charge sheet invoking the offense punishment section 341, 504, 506, 302, Red View section 34 of IPC, and also invoked 114 and 506 Red View section 34 of IPC against accused number 3. The counsel appearing for the petitioner would submit that this petitioner earlier approached the court and the same was rejected. In criminal petition number 200703 of 2022, with order dated 27th day of July 2022, wherein a specific reason was given that this petitioner assaulted the deceased brutally, which has resulted in death. Now the petitioner counsel would vehemently contend that this petitioner, who is an accused number 1 and he is in custody from 3 years, and only summons has been issued to the witnesses CW1 to 4, and other accused have been enlarged on bail, that is accused number 2 and 3. And this petitioner is also entitled for bail. Counsel also submits that the investigation has been completed and charge sheet is filed and already trial has been fixed. No need to continue him in the custody. And any condition may be imposed. And he is ready to obey the condition that may be imposed. The HCGP representing the state not filed statement of objections. However, taking into note of the material available on record and specific court act allegation is made against this petitioner in the charge sheet in column number 17 that he himself and accused number 2 came in the motorcycle and wrongfully restrained the deceased. And when the accused number 2 poured the chili powder, this petitioner inflicted injury with the dragon, which he brought along with him. And also there is a reference of a previous day incident on 3/9/21 and accused number 3 instigated this petitioner to take off the life of the deceased. Having perused the material on record, incident was taken place on 3/9/21 and thereafter on 4/9/21 this incident was taken and this petitioner came along with accused number 2. And no doubt the counsel appearing for the petitioner would submit that accused number 3 is enlarged on bail and the allegation against him is only that he instigated this petitioner to commit the murder. The accused number 2 also allegation is only he had poured the chili powder, but specific court act allegation made against this petitioner that he came with the weapon, that is dragon, and inflicted the injury 3 to 4 times on his head. And also when the deceased tried to ward off the blow, made him to fell on the ground and assaulted all over the body. As a result, he sustained the grievous injuries. PM report ಎಲ್ಲ ಹಾಕಿದಿರ್ರಿ?
PM report is at
Page number?
Is at page number 70.
And the PM report which discloses cause of death is due to hypothalamic shock, secondary due to loss of blood, and also there are cut lacerate wound. All over the body, and having taken note of the injuries found on the PM report, injuries found in the PM report, and also the specific court act allegation made against this petitioner and specific court act allegation also made against this petitioner. And apart from that, CW4 is an eyewitness and he was very much present at the time of the incident. And when the CW4 came forward to safeguard the deceased, caused life threat to him, and when there is a eyewitness evidence against this petitioner and question of exercising the discretion doesn't arise, having found the material against the petitioner, and hence petitioner has not made out any ground to enlarge him on bail. The very contention that he has been in custody from last 3 years is not a ground to enlarge him on bail when the serious offense of taking of life is alleged against the petitioner, and also punishment provided for the same is life imprisonment or death, and hence no ground is made out.
Maybe of-
In view of the discussions made up, I pass the following order. Bail petition is rejected.
maybe after the examination of eyewitnesses, if for.
No, counsel, let other witnesses also required.
Serial number 2.
Mantesh Patil, ಹೇಳ್ರಿ ಏನಿದೆ?
Lords, this matter, this honorable court earlier allowed the writ petition, partly allowed the writ petition and directed to conduct the
Further
first
investigation.
to file it.
Further investigation, now only after the further investigation, some of the cylinders are seized and not.
Seized and recovered. And further, my lords, in the charge sheet, the one of the person has been named as a witness, which is at page number, my lords.
Only one witness.
There are other witnesses, my lords. The one witness statement was recorded.
Subsequent to the ordering for further investigation.
ಹೌದು ಅಲ್ಲಿ ಅವರು the accused have confessed that they have given the one he runs in Ambadevi Bharat Gas, my lords, in the nearby village. The accused have specifically stated that they used to give the another gas agency, that is, my lords, Ambadevi Bharat Gas. The statement was recorded, and he stated in his statement that he ought to have been, my lords, implicated as an accused at page number 15 of the, my lords, along with charge sheet. But they only taken the statement, and there is no any further investigation, my lords, in respect to that effect. Because the accused of
again you are seeking for further investigation.
But this is the material after your lordships have directed to hold an investigation and conduct
Further investigation, yes.
Then the further statement was obtained from the accused persons, wherein the accused person stated that they used to give to the one Sharanappa who is not running a Ambadevi Bharat Gas. Then, my lords, when there is a confessional statement by the accused, the further there should be some investigation, not to that effect. Only they obtained the statement of the Ambadevi who stated before the police that I am not receiving the statement as alleged by the accused. Therefore, there is no nothing remains until there that is closed. At page number 15, along with the charge sheet. ಅದರಲ್ಲಿ ಫೋರ್ತ್ ಪ್ಯಾರಾ ಸದರಿ ರಾಜಶೇಖರನ ಫಿರ್ಯಾದಿ ದೂರಿನಂತೆ ಇವರ ಗುಮಾಸ್ತರು ಮಣಿಕಂಠ ಸತೀಶ್ ರವರು ತಮ್ಮ ಮಹೇಂದ್ರ 407ರಲ್ಲಿ 70 ಖಾಲಿ ಸಿಲಿಂಡರ್ಗಳನ್ನು ಲೋಡ್ ಮಾಡಿಕೊಂಡು ನಮ್ಮ ಅಂಬಾದೇವಿ ಭಾರತ್ ಗ್ಯಾಸ್ ಏಜೆನ್ಸಿ ಕೊಟ್ಟು ಬಂದಿರುವುದಾಗಿ ತಿಳಿಸಿದಿರುತ್ತದೆ. ನಾನು ಸದರಿಯವರ ಗುಮಾಸ್ತರಿಂದ ಯಾವುದೇ ಖಾಲಿ ಸಿಲಿಂಡರ್ಗಳನ್ನು ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. But the state, my lords, though we have contended several grounds, unless they file the statement or the manner in which the investigation, further investigation is carried,
Madam, why your HCGP is not appearing at Gulbarga? Shall I call SPP or an intimate matter? Last time also he was absent. Get your SPP, then we'll see. Is it the way of safeguarding the interest of the state? Get your SPP.
We'll instruct him. Now we'll take care.
Last time ಬಂದಿಲ್ಲ. Get your SPP. ನಿಮ್ಮ ಮಾತಲ್ಲಿ ಕೇಳ್ತಾರೋ? ಕೇಳಂಗಿದ್ರೆ ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ರು ಇವತ್ತು.
I'll communicate. I'll communicate. ಮಾಡ್ತೇನೆ.
Told. Court heard the petitioner counsel in the earlier occasion, and when the HCGP did not appear before this court.
it is urgent to next date. The court proceedings are muted.
27/11 counsel.
Obelisk.
27-11.
Mobilized.
List one, matter at 2:30, non-compliance at first time, 70, Sunita H.
First time, petitioner counsel, yes, madam.
Yes.
Petitioner counsel seeks 2 weeks time to comply with office objection and hence list this matter after compliance.
71,
Second
second
time.
time non-compliance. Anne ko-
Time. Petitioner counsel seeks time. Yes, is a week.
1 week, madam.
And hence 1 week time granted and post the matter after compliance.
Great, madam.
Fourth time non-compliance, 72,
Basavaraju TA.
Basavaraju TA.
Fourth time,
For respondent.
Huh.
My lord, this is earlier, my lord had rejected the bail petition. Now this is a fresh bail petition, second bail petition on the health grounds. My lord, the offense is under NDPS Act. 1,382 grams of cocaine. Found, my lord, in body of the accused. Now,
Personal.
my lord,
Section-
yes,
section
rectal
50
concealment.
Section 50 of NDPS Act attracts on that.
Well, section 23, my lord, is punishment is up to 20 years, minimum 10
for
years,
Commercial quantity.
commercial quantity. Now, my lord, he has made a request for bail on the medical grounds, but no supporting documents have been produced. And if at all it is, my lord, this thing is there, my lord, jail authorities may be directed to, my lord, to subject her to.
Petitioner counsel is absent, matter is listed for fourth time for non-compliance and records also discloses that bail petition was filed on 13/9/24 and thereafter matter was listed on 16/10/24 and counsel sought 1 week time to comply with office objection but not complied and hence once again listed on 23/10/24 and again sought time and this court granted time and in spite of it the petitioner counsel is not pursuing the matter. Henry? Huh?
This matter.
ಇದೆಯಲ್ಲ ಲಾಸ್ಟ್ 2 occasions ಟೈಮ್ ತಗೊಂಡಿದಾರಲ್ಲ ಅದೇನು
Malarship
ಹೇಳ್ರಿ
submission, ಇದರಲ್ಲಿ ಕ್ರೈಮ್ ನಂಬರ್ 7 ಅದು ರಿಜೆಕ್ಟೆಡ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ವ್ಯತ್ಯಾಸ ಆಗಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಪ್ರಕಾರ ನಾನು ಕರೆಕ್ಟ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡಿ ಅದನ್ನ ಓವರ್
ಏನ್ ಒಂದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇರೋದು
ಅದೊಂದೇ
ಏನ್ರಿ ಏನ್ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ
ನಾನು ಸಬ್ಮಿಷನ್ ಬರ್ದಿದ್ದೆ
ಕೌನ್ಸಲ್ ಸಬ್ಮಿಷನ್ ಇದೆಯಾ ಏನಾಗಿದೆ ಕ್ರೈಮ್ ನಂಬರ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆಯಾ
ಕ್ರೈಮ್ ನಂಬರ್ ಅಲ್ಲಿ ರೋಮನ್ ಸಂಖ್ಯೆ 8
ಕ್ರೈಮ್ ನಂಬರ್ ಸ್ಟೇಟೆಡ್ ಇನ್ ಪ್ರಿಯಂಬಲ್ ಪೋರ್ಷನ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್ ಕಾಪಿ ಡಸ್ ನಾಟ್ ಟ್ಯಾಲಿ ವಿತ್ ಬೇಲ್ ರಿಜೆಕ್ಟೆಡ್ ಆರ್ಡರ್
ಹೌದು
ಹಾ
ಅದರಲ್ಲಿ ಕ್ಲರಿಕಲ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಕರೆಕ್ಟ್ as per page number 9 and 68 the bail rejected order in page number 42 is clerical mistake bail rejected order
ಹೌದು
mistake
ಚಾರ್ಜ್ ಶೀಟ್ ಪ್ರಕಾರ ನಾನು ಕರೆಕ್ಟ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀನಿ ಪಿಟಿಷನ್
ಆಗಿದೆ
ಹೌದು
sorry the counsel appearing for the petitioner would submits that ಅದೆಲ್ಲ ತೆಗೆದುಬಿಡಿ ಮೇಡಮ್ ಹಿಂದಿಂದಲ್ಲ submits that there was an error in mentioning the claim number in page number 42 of the rejection order and claim number is correctly mentioned as per the charge sheet and hence counsel submission is accepted. Respondent counsel is also present and directed to file any objections. ಎಷ್ಟು ದಿವಸ ಬೇಕು
10 days.
10 days and hence list this matter on ಎಷ್ಟು 27th bit ಬೇರೆ ಡೇಟ್ ಕೊಡಿ
4/12.
4/12
Please. First time orders 73.
First time matters 230 B Siddeshwara. Ilva? Petitioner counsel absent, additional SPP is present, list this matter on 27/11. Prasanna
74.
Kumar V.
74, Prasanna Kumar V.
Yes, madam.
First time.
First time.
First time.
ಅದು ಹಾಗಾದ್ರೆ ಫಸ್ಟ್ ಟೈಮ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್ ಆಬ್ಸೆಂಟ್ ಅನ್ನೋದು ಬೇಡ
To the notice, my lord, sir.
additional SPP is directed to take notice ನೀವೇ ತಗೋತಿರಲ್ಲ ನೋಟಿಸ್ and file objections if any list this matter on 27/11 same ಎರಡರಲ್ಲೂ ಸೇಮ್ ಆರ್ಡರ್
My lord, respondent number 2.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ನು ಇದಾರಾ
Yes, my lord.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ
Yes, my lord.
issue notice through IO to respond number 2 madam ನೀವೇ ತಗೋಬಿಡಿ additional SPP is directed to serve the notice on the respond number 2 through additional SPP IO through IO.
My lord, Timma
List this matter on 4/12.
Orders matter
75.
75. Anand Muttali.
Compliance of office objection raised on IA 1/24 for direction.
I
Real
have a-
direction?
My lord, I have a simple request, my lord. This petition came to be dismissed. This petition came to be dismissed, my lord, by the order of, dated 24th of, this month, October, 25th of October. My lord, I am ready to face the trial as per the directions of this honorable court. My only submission before the court is, let the observation of this court should not come in the way of a trial. For that purpose, I have filed an IA, because that portion is not there in the order.
What is the observation made by this court?
My lord, there is a clear allegations against accused number 3, because this honorable court relying upon the previous order of this.
Against this petitioner ಏನ್ರಿ ನಾವೇನ್ observation ಮಾಡಿದ್ವಿ ಹೇಳಿ ಹಿಂದೆ.
My lord, there is it is in the order, in the previous order of the High Court. Which is
Previous
filed by-
order ಈಗ 25th day of order.
Because this order came to be passed based on the previous order where there was a direct allegation against accused number 3 anta.
ಆಯ್ತು.
See, I am the accused number 3, my lord. My only submission is, my lord, there is intention to cheat is there from the inception and the finding bandide. So that's the reason, my lord. I am ready to face the trial. So let this observation should not come in the way of the trial. That's the only my submission, my lord.
Third. Heard on IA number 1/24. Direction ಅಂತಾನೆ ಕೇಳಿದ್ರಿ. Wherein a direction is sought. The observation made by this court while passing an order shall not influence the trial court while considering the matter on merits.
Yes, my lord.
And having taken note of the grounds urged in the application and also the oral submission of the counsel, it is made it clear that the observation made by this court while considering the criminal petition shall not influence the trial court while considering the matter on merits. And accordingly, IA is disposed of.
Much obliged.
76. Kumar?
Your lordships producing the notification, your lordships. Your lordships had asked for the notification in respect of
Notification.
BMTF, your lordships.
Here notification?
BMTF powers, your lordships, if they had exceeded. Extension of the BMTF powers, your lordships. Police station.
No.
Is what is questioned, your lordships.
Police station.
Please, your lordships. Producing the.
Karnataka High Court government pleader seeks 2 days time to produce the documents. Hence 2 days time is granted. Learned High Court government pleader is directed to serve a copy of the said document which is going to produce before the court on the other side. ಈಗ copy ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Go through them and make a submission.
Your lordships, PI is at serial number 7, your lordships, police inspector. In the
Serial number?
notification.
So ಇರ್ಲೇನೋ last time ಏನೋ with regard to the jurisdiction, police station. Police
ಅದರಲ್ಲಿ
station.
Not
ಅದು
extended.
18/3/2013 ಇಂದ ಸ್ವಾಮಿ.
ಹಾ.
ಅದರಲ್ಲಿ BMTF ಗೆ ಕೇಸ್ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡೋ ರಿಜಿಸ್ಟರ್ ಮಾಡೋಂತ ಪವರ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಲ್ಲಿಂದ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಮ್ಮ ಸಬ್ಮಿಷನ್.
ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಹೌದು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಜಜ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ವಿ. ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಅವರ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗಿರೋದ್ರ ಬಗ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ.
ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈಗ ಅದು ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಗೋ ಥ್ರೂ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂಡ್ ಸಬ್ಮಿಷನ್.
The additional SPP filed memo along with a document. And copy is also served on the other side. And counsel for the petitioner seeks time. This matter on 27/11? 27/11, yes. Next appearing.
Much obliged.
Admission matter 77.
Kindly pass over, my lord. Pass over. I'm filing some documents along with the synopsis, my lord.
ಯಾವ ಈ ಕೇಸ್ ಅಲ್ಲ?
ಹೌದು ನೋಡು. Grace in injustice has done to the respondent, my lord. Let me to file. Just pass over.
Injustice.
ಹೌದು, ಅವರು petitioner is nowhere related to the respondent. ಅದು ಪಾಳಪತ್ರಿಕೆ ಅಂತ ಹೇಳಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಲ್ಲಿ ಒಂದು ಲೆಟರ್ ಮಾಡಿ they have transferred the mutation and subsequently they continued.
Documents ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ದೆ.
Kindly pass over. I'll file everything. Just kindly.
But I am fast the counsel.
ತರ್ಲಿಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ.
Here is not feeling well today.
ಏನ್ ಮಾಡ್ಬೇಕು?
Next week in a date.
ಅವ್ರೇನೋ ಕೊಡ್ಲಿ ಫಸ್ಟ್
Documents.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಿ, ಅದರ್ ಸೈಡ್ ಸರ್ವ್ ಮಾಡಿ.
ಮಾಡ್ತೀವಿ ಈಗಲೇ.
Then we'll take a pass over.
Please.
78.
For the respondent.
This case.
ನಿಮ್ ಕಂಪ್ಲೀಟ್ ಆಯ್ತಾ?
Yes, my side was completed.
Completed.
They said they will want to give a reply.
Sir, my senior is held up in video conference.
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಅಲ್ಲ next week.
ಡೇಟ್ ಬೇಕಾ? ತಗೊಳ್ಳಿ. Petitioner counsel. Petitioner counsel seeks time. List this matter on 27/11. 27/11. Next Wednesday.
ಸರಿ.
ನಿಮ್ ಮ್ಯಾಟರ್ ಬಂತೇನ್ರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಅಲ್ವೇರಿ.
ಹಾ? ಇಲ್ಲ. ಕೋರ್ಟ್ ನೆನಪಿಸ್ಬೇಕಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ.
Daily and contacting with the.
List this matter on 27/11.
Have no information about it.
Huh?
Till now, we have
ಅವ್ರೇನೋ
not.
ಫೈಲ್ ಮಾಡಿ ಏನೋ ನಂಬರ್ ಕೊಡ್ತಾರೆ ನೋಡಿ, ಏನೋ ಡೈರಿ ನಂಬರ್ ಎಲ್ಲ ಕೊಡ್ತಾರೆ ನೋಡಿ.
ಅವ್ರು ಕಾಮನ್ ಆಗಿ ಕೆಲವು ಕೇಸ್ಗಳು ಅದು ಸಾಮಾನ್ಯವಾಗಿ ಅಲ್ಲಿ ಬರೋದು ಇಲ್ಲ ಅಲ್ಲ. ಈಗ ಟಿಲ್ ದೆನ್ ಅದು ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ತನಕ ಇದು ಸ್ಟೇ ಮಾಡ್ಬಿಟ್ಟು ಅಡ್ಮಿಟ್ ಮಾಡೋದು.
ಅಲ್ಲ ರೀ, ಆಲ್ರೆಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದೀವ್ರಿ, ನೀವು ಬರೀ ರಿಪ್ಲೈ ಕೊಡ್ಬೇಕು ಅಷ್ಟೇನೆ. ಅದರ್ ಸೈಡ್ ಆಲ್ಸೋ ಗಿವನ್ ಸಮ್ ಸೈಟೇಷನ್ಸ್.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ರಿಗಾರ್ಡಿಂಗ್ ದಿ ಸ್ಕೋಪ್ ಆಫ್ ರಿವಿಷನ್ ದೇ ಹ್ಯಾವ್ ಸೈಟೆಡ್ ಸಮ್ ಸೈಟೇಷನ್ಸ್. ಹೌದಾ? ಅದ್ರ ಮೇಲೆ ನೀವು ರಿಪ್ಲೈ ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ. ಡಿಸ್ಚಾರ್ಜ್ ಕ್ವಾಶಿಂಗ್ ಬಂದ್ರಿ, ಕ್ವಾಶಿಂಗ್ ರಿಜೆಕ್ಟ್ ಆಯ್ತು. ಆಮೇಲೆ ಡಿಸ್ಚಾರ್ಜ್ ಹೋದ್ರಿ, ಡಿಸ್ಚಾರ್ಜ್ ಈಗ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಅದ್ರ ಮೇಲೆ ಬಂದಿದ್ದೀರಿ. ಈಗ ರಿವಿಷನ್ ಸ್ಕೋಪ್ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್, ಯು ಕೆನಾಟ್ ಟೇಕ್ ಎನಿ ಡಿಫೆನ್ಸ್.
ವಾಷಿಂಗ್ ನಮ್ದು ವಾಷಿಂಗ್
ಅರ್ಲಿಯರ್ ಕ್ವಾಶಿಂಗ್ ಬಂದಿದ್ರಲ್ಲ?
ಇಲ್ಲ, ನಾವು ಬಂದಿಲ್ಲ.
ನೀವು ಬಂದಿಲ್ವಾ?
ಡಿಸ್ಚಾರ್ಜ್
ಬಂದಿಲ್ಲೇನ್ರಿ?
Other accused.
ಡಿಸ್ಚಾರ್ಜ್ ಅದರ್ ಅಕ್ಯೂಸ್ಡ್.
Accused number 5 is concerned was dismissed.
ಡಿಸ್ಚಾರ್ಜ್ ಆಯ್ತು.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 5
Has approached under 482, that was dismissed. Then accused number 1 was filed under 482, that was allowed. And other 2 accused are filed an application for discharge.
ಅದ್ರಲ್ಲಿ
ನಮ್ದು
ಒಬ್ರದ್ದು ಇಬ್ರದ್ದು ಅಲೋ ಆಯ್ತು, ಇನ್ ಬಾಕಿ ಅವ್ರು ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಹೌದು. 2 and 4 are dismissed.
ಅದ್ರ ಮೇಲೆ ಇವ್ರು ಬಂದಿದ್ದಾರೆ.
ಅಲ್ಲ A1 both quashing of the entire charge sheet as well as the ED also allowed. A1 ಎಲ್ಲ ಅಲೋ ಆಗ್ಬಿಟ್ಟಿದೆ ಎಂಟೈರ್. ಸೊ ವಿ ಆರ್ ಓನ್ಲಿ ದಿ ಕೋ ಅಕ್ಯೂಸ್ಡ್.
ಈಗ ನೌ ದೇರ್ ಆರ್ 2 cases, one is ED, another is ಲೋಕಾಯುಕ್ತ.
ಎರಡನ್ನೂ ಅಲೋ ಆಗಿದೆ.
Against A1.
Against A1 both are quashed.
That is predicate offense was quashed. That on that ground the ED, the other offense was quashed. Then so far as this PC Act is concerned, we went up to Supreme Court. It is not attained finality. You cannot claim the parity of
PC Act. You have challenged before the Supreme Court.
Supreme Court.
Now same is pending for consideration.
Please.
What about ED matter? According to him, ED also quashed.
I have produced.
That is on the ground that not predicate offenses, main offense was quashed. That ground only in the technicalities was quashed, not on the merits.
Merits. Right, ನೋಡೋಣ 27/11.
ಅದಕ್ಕೆ ಸೊ ಟಿಲ್ ದೆನ್
ಟಿಲ್ ದೆನ್ ಏನ್ರಿ ಇರೋದು ಒಂದು ವಾರ. ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ, ರೈಟ್ ಆರ್ಡರ್
ಮೇನ್ ಕೇಸ್ ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಾಕಿದೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ, ಗಿವ್ ಮಿ 2 or 3 days, ಐ ವಿಲ್ ಪಾಸ್ ಎನ್ ಆರ್ಡರ್. ನಮ್ಮ ಯಾವ್ದು ಒಂದು ವಾರದ ಮೇಲೆ ಯಾವ್ದು ಇರಲ್ಲ ಪೆಂಡಿಂಗ್. ಎಲ್ಲ ಡಿಕ್ಟೇಷನ್ ಆ ವಾರದಲ್ಲೇ ಮುಗ್ದೋಗ್ತದೆ. ವೀಕೆಂಡ್ ಇವತ್ತು ಕಂಪ್ಲೀಟ್ ಮಾಡ್ರೆ ನೀವು ಸಾಟರ್ಡೆ ಕೂಡ ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್ ಮೈ ಆರ್ಡರ್.
ಫೈನಲ್ ಆರ್ಡರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಟಿಲ್ ದೆನ್ ದಿಸ್ ಆಲ್ಸೋ ಟು
ಅದಕ್ಕೂ ಇದಕ್ಕೇನು ಸಂಬಂಧ? ಇಲ್ಲಿ ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಅದು ಎಗೇನೆಸ್ಟ್ ಅದರ್ ಅಕ್ಯೂಸ್ಡ್, ನಿಮ್ಮ ಅಕ್ಯೂಸ್ ಮೇಲೆ ಏನು ಇಲ್ಲ. ಅದಕ್ಕೂ ಇದಕ್ಕೇನು ಸಂಬಂಧ?
ಅಲ್ಲ ಬಟ್ A1 ಹೋದ್ರೆ
ಆಯ್ತ್ರಿ. ನೀವು 25 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೀರಿ PWD ಇಂಜಿನಿಯರ್ಗೆ, ಮಗಳಿಗೆ MBBS ಸೀಟ್ ಕೊಡ್ಸಕ್ಕೆ. ನಿಮ್ ಡಿಕ್ಲರೇಷನ್ ಅಲ್ಲಿ ಬರೀ 1.5 ಲಕ್ಷ 2 ಲಕ್ಷ ಇನ್ಕಮ್ ಇರೋದು, ನಿಮ್ಗೆ 25 ಲಕ್ಷ ಎಲ್ಲಿಂದ ಬಂತು ಅನ್ನೋ ಪ್ರಶ್ನೆ ಅಲ್ವಾ?
Cash deposit ಆಗಿದೆ. 30 lakhs cash deposit was received by him. ಹೌದು.
ಅಲ್ಲಲ್ಲ, ದಿಸ್ ಅಕ್ಯೂಸ್ಡ್
25 ಲಕ್ಷ 30 ಲಕ್ಷ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿದಿರಿ.
ಇಲ್ಲ ಹಂಗಲ್ಲ. ಈಗ FD ಕೂಡ 10 ಲಕ್ಷ ಚಿಲ್ರೆ, ಇದು 17.5 ಲಕ್ಷ ನಾವು
ಆ ಕಡೆಯಿಂದ ಬಾರೋ ಮಾಡೋದು, ಈ ಕಡೆಯಿಂದ ಕೊಡಲ್ಲ, ಅದನ್ನ ಮಾಡಿದಿರಿ ನೀವು.
ಹಂಗಲ್ಲ, ದಟ್ ಈಸ್ ನಾಟ್ ದಿ ಪಾಯಿಂಟ್.
ಹೌದ್ರಿ, ನಿಮ್ಮ ಡಾಕ್ಟರ್ ಇನ್ಕಮ್ ಇರೋದೇ ವರ್ಷಕ್ಕೆ ಬರೀ 1.5 ಲಕ್ಷ. ನಿಮ್ ಡಿಕ್ಲೇರ್ ಮಾಡ್ಕೊಂಡ್ರ ಪ್ರಕಾರ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್
ರಿಟರ್ನ್ಸ್ ಎಲ್ಲ ಫೈಲ್
ಮಾಡಿದೀವಿ. ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ನಿಮ್ ಡಿಕ್ಲರೇಷನ್ ಪ್ರಕಾರ ಇರೋದೇ 1.5 ಲಕ್ಷ ಪರ್ ಇಯರ್ ಇನ್ಕಮ್. ಹೌ ಕುಡ್ ಯು ಮೇಕ್ ದಿ ಪೇಮೆಂಟ್ ಆಫ್ ₹25 lakh to a government servant to get the medical seat in a college?
That is a different aspect.
Different aspect ಅದು.
Different aspect, but
different aspect ಅದು.
So 70
giving an amount of ₹25 lakh even though no income, that is also a different aspect.
See, one point, so we have sold the property So 55 lakhs and other.
ಅದ್ನೇ ಕೊಡಿ ಅಂತ ಕೇಳಿ ನೀವು ಕೊಡಲ್ಲ ಅದನ್ನ ರೆಕಾರ್ಡ್ನ.
Those
But
property,
ಅದು-
they have
ಅದರಲ್ಲಿ-
produced the sale deeds, those
ಅದರಲ್ಲಿ
the
ಏನಾಗಿದೆ ಅಂದ್ರೆ-
consideration amount was received by check.
ಅದರಲ್ಲಿ
The DD numbers were mentioned in the sale deed. But
ಅದರಲ್ಲಿ
here it is the cash deposit of 30 lakhs.
ಏನ್ ಸಾಹೇಬ್ everybody doctor can doctors can earn and deposit. His father was a doctor, he is a doctor.
ಆಗ್ಲಿ ರೀ, ಅಪ್ಪನು ಡಾಕ್ಟ್ರು ಮಗನು ಡಾಕ್ಟ್ರು. ವೈ ಇನ್ಕಮ್ ಆಫ್ ರುಪೀಸ್ ಓನ್ಲಿ 1.5 lakh per every year in your income tax returns.
Even
ಯಾವ್ದೋ ಆಪರೇಷನಲ್ ಮೋಸ್ಟ್ಲಿ ಒಟ್ಟಿಗೆ 30 ಲಕ್ಷ ಬಂದಿರ್ಬೇಕು.
when the first accused as charge sheet was
ಆಯ್ತು ವಿಲ್ ಎಕ್ಸಾಮಿನ್ ದಿ
question of
ಮೆಟೀರಿಯಲ್.
framing charge particularly to this person does not raise.
ಆಯ್ತು 27th ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಹೇಳಿ. ಆಲ್ಮೋಸ್ಟ್ 2 ಗಂಟೆ ಕೇಳಿದ್ದೀನಿ ಆರ್ಗ್ಯುಮೆಂಟ್ 2 ಸರಿ 2 occasion. ಇನ್ ಜುಲೈ ಒಂದ್ಸರಿ, ಈಗ ಮೊನ್ನೆ ಒಂದ್ಸರಿ, ಈಗ ಮತ್ತೆ ಇನ್ನೊಂದು ಏನಾರು ಇದ್ರೆ ಹೇಳಿ ಕೇಳೋಣ ಆರ್ಡರ್ ಬರೆಯೋಣ.
ಅದಕ್ಕೆ
4th, my lord. 4/12.
4th ಬೇಕಾ?
Please.
4/12 ಆಯ್ತು 4/12. ಅಷ್ಟ್ರೊಳಗೆ ನೋಡ್ರಿ ನೀವು. ಆನೆನೆ ಹೋದ್ಮೇಲೆ ಆನೆ ಬಾಲ ಹಿಡ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ? ಅಲ್ವಾ? ಹೌದಲ್ಲ?
Yes, my lord. There are as many, more than 20 cases are going to list, my lord, together.
20 cases?
Almost more than 20 cases are similar on that ground it was passed.
ಸೇಮ್ ಗ್ರೌಂಡ್.
Same.
ಅದ್ರ ಮೇಲೆ ಈಗ ಹೋಗಿದ್ದೀರಾ?
How, yes, it will, all together it will post it before the court.
Maybe A1 is those, maybe powerful.
Yes.
ಅಲ್ಲ A1 ಪವರ್ಫುಲ್ ಏನಿಲ್ಲ ಅಲ್ಲ, ಅದರ್ ನಾಟ್ 20 cases belong to A1.
More than 400.
Similar ground ಅಂತ. The grounds which have been given for quashing in total 20 cases. That's why they approached the
other
Supreme
persons,
Court ಅಂತ.
not other persons, not this person.
ಅಲ್ಲ accused ಬೇರೆ.
ಬೇರೆ
Similar ground ಮೇಲೆ different accused cases are quashed ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. ಹೌದೇನ್ರಿ?
ಹೌದು.
What I understood in view of your submission.
And percentage of.
ನಮ್ಗೇನ್ ಗೊತ್ತಿಲ್ಲ.
Percentage.
So we have no information.
ಆಯ್ತಾಯ್ತು, don't waste the time. 4/12.
77 ಬಂದಿದೆ.
77 ಏನಾಯ್ತು ನೋಡಿ.
Marks over ಅದು.
Please.
Then a document.
Portal.
I'm filing the synopsis and documents, my lord.
ಏನು? ಸಿನಾಪ್ಸಿಸ್.
And the documents also. Original documents ಇದೆ, ತಾವ್ಯಾಗ ಹೇಳ್ತೀರಾ ಕೊಡಿ. Only this 10 ರೂಪಾಯಿ ಸ್ಟಾಂಪ್ ಪೇಪರ್ ಮೇಲೆ 4 acres 9 ಗುಂಟ ಟ್ರಾನ್ಸ್ಫರ್ಡ್.
AGA files synopsis and also files memo along with documents. ಇದು MR ಸಂಬಂಧಪಟ್ಟಿದೆ.
ಎಲ್ಲ MR.
In respect of MR number 1/55-56. ಏನಿದು 67, 68 ಅಂತ ಏನೇನೋ ಬರೀತೀರಲ್ರಿ? RTC ನ ಅದು.
Kindly synopsis ಅಲ್ಲಿ ಒಂದ್ ಮಾತು ನೋಡಿ. Kindly see the synopsis. 2 minutes.
ಆಯ್ತು ನೋಡೋಣ, ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ನೋಡಿ.
ಅಲ್ಲಿ ಪಾಲು ಪಂಚಾಯತ್ ಅಂತೇಳಿ ಒಂದು ಇದು ಮಾಡಿದ್ದಾರೆ 10 ರೂಪಾಯಿ ಸ್ಟಾಂಪ್ ಪೇಪರ್ ಮೇಲೆ. ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಅದ್ರ ಮೇಲೆ ಇವರು 4 acre 9 ಗುಂಟ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ದ ಮೇನ್ ಇಶ್ಯೂ. ಅಂಡ್ ಈವನ್ ದಿ ಯಾರ ಹೆಸರಲ್ಲಿ ಮಾಡಿದ್ರು ಅವರೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದವ್ರು ಯಾರ್ರಿ? ನಿಮ್ಮವ್ರೆ?
ಪ್ಲೀಸ್ ಮಿಲ್.
ಹೌದಲ್ಲ? ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲ, ರೆವಿನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಷ್ಟೇ.
ಗ್ರಾಸ್ ಇದನ್ನ ಅವಾಗಿದ್ದವ್ರು ಮಾಡಿರೋದು. ಅವಾಗಿರೋರು
ಬೇಕು ಅಂದ್ರೆ ಅವ್ರನ್ನು ಕರ್ಸೋಣ, ನಿಮ್ ಏಜ್ ಕರ್ಸೋಣ ಬಿಡಿ. ದೇ ರೆಪ್ರೆಸೆಂಟ್ ರೆವಿನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
ಅವ್ರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿ ಅಕ್ಯೂಸ್ಡ್ ಮಾಡ್ಬೇಕು ಮೇಲೆ. ದಟ್ ಇಸ್ ಹಾನೆಸ್ಟ್ಲಿ ದೇ ಹ್ಯಾವ್ ಟು ಬಿ
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಫೈಲ್ಡ್ ಅಂಡ್ ಕಾಪೀಸ್ ಆಲ್ಸೋ ಸರ್ವ್ಡ್ ಆನ್ ದಿ ಅದರ್ ಸೈಡ್. ಕಾಪೀಸ್ ಕೊಟ್ರಾ? ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 4/12.
ಅಪ್ಲೈಡ್.
This one.
ಎಂಟ್ರಿ ಮಾಡಿರ್ಬೇಕಿದ್ರಲ್ಲಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನ ಹೌದಲ್ಲ?
This one, passport matter.
Passport matters.
18. Anu Bharadwaj.
Serial number is
18.
18.
Flush plan for the appellant. Have carried out amendment.
Appellant counsel submits that he has carried out the amendment and also filed amended cast title. ಅಷ್ಟೇನಾ ಮೇಡಮ್?
ಸೆಕೆಂಡ್
ಇತ್ತಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ?
ಕರೆಕ್ಟ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಕರೆಕ್ಟ್ ಮಾಡಿ.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಮಾಡಿದಿರಾ? PF
ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ದೀನಿ ಸರ್.
ತಗೊಂಡಿದ್ದೀರಿ. The counsel for the appellant in connected matter submits that he has carried out the amendment and also paid the PF and hence issued notice to R11, B and C. ಅಷ್ಟೇನಾ? B and C. This matter on ಹೋಗ್ಬರ್ಬೇಕು ವಾಪಸ್ 10-12 ಹೋಗ್ಬರುತ್ತಾ 16-12
20, much of this. 20, T. Sheshgiri Rao.
20. Yes, madam, non-amendment of cost title ಮಾಡಿದಾರಾ?
Amendment by law.
Apparent counsel submits that amendment is carried out and also filed the amended cost title. In respect of sole appellant, ಬೇರೆ ಇನ್ನೂ ಏನಿದೆಯಲ್ಲ ಚರಿತ್ರೆ ನೋಡ್ರಿ, ಅದು ಒಂದ್ ಪೇಜು
ಸರ್ ಅದು 500 ಕಾಸ್ಟ್ ಕಟ್ಬೇಕಾಗಿತ್ತು.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಾ?
Cost is being paid, acknowledgement is been filed minutes.
ಈಗ ಕಟ್ತಾ ಇದೀರಾ?
ಮಧ್ಯಾಹ್ನ ಕಟ್ಟಿ ಹಾಕಿದ್ದಾರೆ.
ಕಟ್ಟಿದಿರಿ ಈಗ ಆಲ್ರೆಡಿ. The council submits that already paid the cost of rupees 500. With order dated 4/11/24. ಮತ್ತೇನು ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲ್ಜ್ಮೆಂಟ್ ಫಾರ್ ಎಂಟೈರ್ ಕೇಸ್ ಪೇಪರ್ಸ್ ಅಲಾಂಗ್ ವಿತ್ ಪೇಪರ್ ಬುಕ್. ಏನು ಪೇಪರ್ ಬುಕ್ ಏನೈತಿಲ್ರಿ? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲ್ಜ್ಮೆಂಟ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಸರ್ವ್ಡ್ ಎಂಟೈರ್ ಕೇಸ್ ಪೇಪರ್ಸ್ ಅಲಾಂಗ್ ವಿತ್ ಪೇಪರ್ ಬುಕ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡಿದಿರಾ?
It is been served, my lords. Regarding the acknowledgement, I'll have to check, my lords, but the copies has been served.
ಕಾಪೀಸೇ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತಲೇ ಇರೋದು ಆಫೀಸ್
Serve
ಸಬ್ಜೆಕ್ಟ್.
ಮಾಡಿದೀವಿ, acknowledgement file ಆಗಿದೆಯಾ ಇಲ್ವಾ?
ಆಯ್ತು. The council submits that copies are also served on the respondent council. Second one ನಿಮ್ದೇನ ಸೇಮಾ?
ಹಾ.
ಎಲ್ಲ ಸೇಮಾ?
ಹೌದು.
ಆಯ್ತು. Post the matter for final hearing 2008 ಅಲ್ಲ? Date ಕೊಡಿ. This matter
10-12.
10-12.
21.
21 ಇದೆಯಾ?
ಮಿಲಾರ್ಡ್ ಇದರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಮಿಲಾರ್ಡ್.
Non compliance of office objection.
ಮಿಲಾರ್ಡ್ ಅದರಲ್ಲಿ there are two objections ಮಿಲಾರ್ಡ್. One is ಮಿಲಾರ್ಡ್ respondent number 3 and 5
Not signed by all the parties and seal not affixed in both ವಕಾಲತ್ and
seal ಹಾಕಿದೀನಿ ಸರ್. Seal has been affixed right away ಮಿಲಾರ್ಡ್.
ಯಾರು
Respondent number 3 and 5 ಮಿಲಾರ್ಡ್ they have not affixed the signature in the compromise petition ಮಿಲಾರ್ಡ್.
ಆಯ್ತು.
Reason ಏನು ಅಂತ ಹೇಳಿದ್ರೆ ಮಿಲಾರ್ಡ್ they have already executed the sale deed in favor of third party. Now, my lord, the appellant also do not want to pursue the matter because, my lord, he has executed a confirmation deed against the third party.
Executed the confirmation.
Yes, my lord. Appellant has also.
ನಿಮ್ಮ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅವ್ರನ್ನ ಬಿಟ್ ಮಾಡ್ಕೋತಾ ಇದೀರಲ್ಲ, ಯಾರನ್ನ ಈಗ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3
and 5, my lord. My lord,
ಅದನ್ನ ಹೇಳಿದೀರಾ ನಿಮ್ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್?
ಹೇಳಿದೀನಿ.
ಆಲ್ರೆಡಿ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಅಂತ.
ಹೇಳಿದೀನಿ. My lord, your lordship may kindly.
ಮೊದಲು ಕೌನ್ಸಿಲ್ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರು.
ಅವ್ರಿಗೆ ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ?
3 ಕೌನ್ಸಿಲ್ ಇದಾರಲ್ಲ, ಕುಮಾರ್ ಅಂತೇನೋ ಇದೆ ಫಾರ್ R3 NOC.
That is NOC.
5 ಈಶ್ವರಿ ಸರ್ವ್ಡ್ ಅಂತಿದೆ.
My lord, the rest of the respondents and the appellant are present before the
court. What is the challenge made in this appeal?
My lord, there is a suit for declaration and injunction which being agreed by the same, my lord. Appellant has preferred the RFM. For declaration declaring that the appellant is the absolute owner of the scheduled property.
Declare ಆಯ್ತಾ?
Declare ಆಗ್ಲಿಲ್ಲ. Injunction ಮಾತ್ರ ಕೊಟ್ರು trial court ಅಲ್ಲಿ. By which, my lord, he being agreed, he has filed an appeal before this honorable court. Respondent also being agreed by the same, my lord, they have preferred the
Injunction against ಅವ್ರು ಬಂದ್ರು, ನೀವು ಡಿಕ್ಲರೇಷನ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿಕ್ ನೀವು ಬಂದ್ರಿ.
ಹೌದು.
ಹೇಳಿ.
My lord, during the pendency of the said suit, my lord, respondent number 1, 2, 3 have executed a sale deed in favor of one person called as Prachi Yadav.
ಆಯ್ತು.
ಆಮೇಲೆ respondent number 4 ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ ವಿತ್ ಹರ್
ಅವ್ರ ಪರವಾಗಿ
ಪ್ರಾಚಿ ಯಾದವ್ಗೆ. respondent number 5 ಏನ್ ಮಾಡಿದ್ದಾರೆ, respondent number 2 and 3 ಡೀಡ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರ ಶೇರ್ದು ಆ scheduled property 2 and 3 ಗೆ. ಆಮೇಲೆ 1, 2, 3 ಮಾಡಿಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಪ್ರಾಚಿ ಯಾದವ್ಗೆ. Now, my lord, appellant has also executed a confirmation deed saying that I don't have any objections. I have handed over the possession to Prachi Yadav and I'm confirming that he is the absolute owner of the property. Purchaser ಗೆ.
ಈಗ ನೀವು R5 ಏನೋ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಯಾರಿಗೋ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಯಾರಿಗೆ ಅದು ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದೀರಾ ಇಲ್ಲಿ?
ಹಾಕಿದೀನಿ. Lordship may kindly come to
ಇದು ಮೇನಾ ಯಾವಾಗ ಹಾಕಿದಿರಿ? ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಜೊತೆಲಿ ಹಾಕಿದಿರಾ?
ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಜೊತೆನೇ ಇದೆ ಸ್ವಾಮಿ. ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಜೊತೆನೇ ಇದೆ. Lordship may kindly come to annexure E, my lord. Page number 47.
47. Sale deed.
My lord, this is executed by respondent number 4, my lord.
4 in favor of subsequent purchaser.
Subsequent purchaser. Page number 40.
Subsequent purchaser total idara?
ಇಲ್ಲ. ಅವ್ರ ಪಾರ್ಟಿ ಇಲ್ಲ. ಅವ್ರ ಮೇಲೆ ಏನು grievances ಇಲ್ಲ.
ಆಯ್ತು.
My lord, next, my lord, respondent.
This is by R4.
This is by R4, my lord.
ಆಯ್ತು.
Page number 34, my lord.
ಅಲ್ಲ,
Sale deed-
page number 65 annexure F ಇದೆಯಲ್ಲ, ರಾಮಕೃಷ್ಣ
ಅದು
ದತ್ತ
ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಮಾಡಿರೋದು. ದಟ್ ಈಸ್ ಮೇಡ್ ಬೈ ದಿ ಅಪಿಲೆಂಟ್ ಇನ್ ಫೇವರ್ ಆಫ್ ಪ್ರಾಚಿ ಯಾದವ್.
appellant.
ಹೌದು.
ಆಯ್ತು.
ಮಿಲಾರ್ಡ್, ಪೇಜ್ ನಂಬರ್ 34 ಮಿಲಾರ್ಡ್.
ಹಾ.
Sale deed executed by respondent number 1 to 3 in favor of Prachi Yadav.
1 to 3.
1 to 3.
1 2 3 4 ಆಯ್ತು.
My lord, page number 13, my lord. This is by respondent number 5 in favor of respondent number 2 and 3. She has executed a gift deed.
ಅದೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಗಿಫ್ಟ್ ಡೀಡ್?
First gift deed ಆಗತ್ತೆ. Respondent number 5 ಅವರು respondent number 2 and 3 gift ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ 1 2 3 ಸೇರ್ಕೊಂಡು
2 and 3 ಗೆ.
2 and 3 ಗೆ.
ನೋಡಿ.
Thereafter, that's all, my lord.
The appellants in both ಒಬ್ರೇನಾ ಬೇರೆನಾ?
My lord, 403 of 2009 ಅಲ್ಲಿ respondent appellant is the trust, my lord.
ಆಯ್ತು. appellants
109 ಅಲ್ಲಿ
in both the appeal and also the respondents in respond number ಯಾರು ಈಗ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೋತಾ ಇರೋದು 1
2 and 4, my lord.
1 2 and 4.
2 and 4
Yes, ma'am.
1 2 and 4 have filed compromise petition before this court. Along with, they also produce the document of R3, R1 and
R1 2 3 4 5.
jointly executed the sale deed in favor of the subsequent purchaser.
Please, my lord.
And so also produce the document of R5 executed gift deed in favor of R2 and 3.
And 3. Please, my lord.
And in turn R2 and R3
R1 2 and 3.
R2 ಅಲ್ಲ ಅವ್ರಿಗೆ ಗಿಫ್ಟ್ ಡೀಡ್ ಮಾಡಿರೋದು 1 2 3 ನಾ ಅಥವಾ 2 and 3 ಮಾತ್ರನಾ? R5
2 and 3 ಮಾತ್ರ ಸ್ವಾಮಿ.
R5 2 and 3 and in turn on the basis of the gift deed R2 and 3 as well as R1 have executed the sale deed in favor of the subsequent purchaser.
Please, my lord.
The appellants have also executed the confirmation deed. The appellant in alva?
Appellant in RFA 403.
716.
403.
403 of 2009, my lord. 403 of
403 of 2009
2009.
also executed deed of confirmation in favor of the subsequent purchaser and not claiming any interest in the subject matter of the appeal.
Please, my lord. Please.
Both the council also submits. ನೀವು ಯಾರಿಗೆ ಅಪೇರ್ ಆಗ್ತೀರಿ ಮೇಡಮ್? ಪಾರ್ಟೀಸ್ ಇದಾರಾ?
Parties.
1 2 4.
1 2 and 4 are present.
4. What about appellants?
Appellant ಇದ್ದಾರೆ represented.
ಕರೀರವ್ರು ಯಾರು?
Please.
Appellant in 403.
403, my lord.
ರಾಮಕೃಷ್ಣ ದತ್ತ ಟ್ರಸ್ಟ್. ಅದಕ್ಕೆ ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು?
Your
ಹೆಸರೇನು? ರಾಮಕೃಷ್ಣ. ರಾಮಕೃಷ್ಣ ದಿ ಅಪಲೆಂಟ್. ಏನು ನೀವು ಅಲ್ಲಿ ಏನಾಗಿದ್ದೀರಿ ಟ್ರಸ್ಟ್ ಅಲ್ಲಿ? ಟ್ರಸ್ಟಿನಾ? The managing trustee Ramakrishna is also present before the court, who is the appellant in RFA 403 of 2009. What about in 109 ಅಲ್ಲಿ ಯಾರು appellant?
Your is the representative.
109 ಅಲ್ಲಿ ಅವರೇನಾ?
Respondent.
Respondent ಬೇಡ. First 109 appellants ಯಾರು?
Appellants.
ಅವರಿಬ್ರೇನಾ?
3 ಜನ.
Appellants in RFA 109 of 2009 also present before the court. And respond number 1 to 4 ಇವರೇನಾ ಅದರಲ್ಲಿ ಯಾರು?
1 2 and 4.
Appellants ಅದ್ರಲ್ಲಿ 1 to 4
ಹೌದು, appellants ಅದ್ರಲ್ಲಿ 104 ಅಲ್ಲಿ 109 ಅಲ್ಲಿ.
Respond number 4 ಅವರು?
Yes, my lord.
Abhishankar. Respondent number 2.
Respondent number 2.
Respondent number 2.
And ಇವರು
Respondent number 1.
Respond number 1 2 and 4
Madhavi. Respondent number 4.
4. Who are the appellants in RFA 109 of 2009? Correct?
Correct.
Also present before the court. Parties admits the terms of compromise. ಓದಿ ತಿಳ್ಕೊಂಡಿದ್ದೀರಾ? ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲ ಮಾಡ್ಕೊಟ್ರದ್ ನೀವು, ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡು ನೀವುಗಳು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಟ್ರದು ಗೊತ್ತಿದೆಯಾ?
They understand Telugu, my lord.
They understand only Telugu and English, my lord.
Telugu and English?
Yes, my lord.
She knows only Telugu.
Only knows Telugu. Right. And also admits the terms of compromise. The respond number 5 is absent since he has already executed a gift deed in favor of respond number 1 to 3.
2 and 3.
2 and 3. R3 also, R3 also already
R4, my lord.
executed,
R3 also is.
also executed the sale deed in favor of the subsequent purchaser.
Subsequent purchaser,
And
please.
both of them are not present before the court, but the documents of the document of registered gift deed as well as the absolute sale deed are placed before this court along with the compromise petition.
Please, my lord.
Howda? In view of compromise petition entered between the parties, same is accepted and appeals are disposed of.
Please,
ಅಷ್ಟೇನಾ?
my lord. Please.
Sign.
Signature ಮಾಡ್ಬೇಕು ಎಲ್ಲಾರು. ಯಾವ್ದು ಮೇಡಮ್?
27.
ಹೇಳ್ರಿ 27 ಹೇಳಿ.
Lord, I was directed to produce the Khata certificate. Lord, it is marked as exhibit P11 in the trial court. I have also produced the.
ಈಗ ಕೇಳಿರೋ ರಿಲೀಫಿಗೆ ಸಪೋರ್ಟಿಂಗ್ ಏನ್ ದಾಖಲೆ ಇದೆ ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳಿ.
Exhibit D, the exhibit P11 is the Khata certificate. my lord.
ಎಕ್ಸಿಬಿಟ್
P11.
ಅದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಮಾರ್ಕ್ ಮಾಡಿದಿರಿ.
ಹೌದು, mark ಮಾಡಿ.
ನಾವು ವೈ ಯು ಆರ್ ಸೀಕಿಂಗ್ ನೌ ಫಾರ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್
No, what has happened?
ಆಫ್ ಆರ್ಗ್ಯೂಯಿಂಗ್ ದಿ ಮ್ಯಾಟರ್ ಆನ್ ಮೆರಿಟ್ಸ್.
Lord, I am ready to argue, my lord. Now what has happened? No.
ಮಾಡೋಣ, ಹಿಯರ್ ಮಾಡೋಣ ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್.
ಅಲ್ಲ, ಇವಾಗ ಅವರು ಮಾರ್ಗೇಜ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಪ್ರಾಪರ್ಟಿ ಅಂಡ್ ದಟ್ ಬ್ಯಾಂಕ್ ದಟ್
ಆಲ್ರೆಡಿ ಮಾರ್ಗೇಜ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಸರ್. ಅಲ್ಲ, when I have also filed the execution petition, it was dismissed for non-prosecution, then it was restored.
ಏನ್ ಮಾಡ್ಬೇಕು ಆವಾಗ ರಿಲೀಫ್ ಕೇಳ್ಬೇಕಾದ್ರೆ ನಾಟ್ ಟು ಎಕ್ಸಿಕ್ಯೂಟ್ ಎನಿ ಅದರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇನ್ ಫ್ಯೂಚರ್ ಅಂತ ಕೇಳ್ಬೇಕಿತ್ತು. ರೆಸ್ಟೋರಿಂಗ್ ಆಫ್ ಖಾತಾ ಬದಲು ನಾವು ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು ಅರ್ಲಿಯರ್ ದೇ have obtained an amount of rupees 12 lakhs.
12 lakhs.
And now also again once
35
again
lakhs.
taken the amount.
Yes.
ಅಂತ ಹೇಳಿ ಫರ್ದರ್ ಏನು ಮಾಡಬೇಡಿ ಅಂತ ಕೇಳ್ಬೇಕಲ್ವಾ ರಿಲೀಫ್ ನ, ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ರೆಸ್ಟೋರಿಂಗ್ ದಿ
ಅಲ್ಲ, ನಮ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಗೆ ತೊಂದರೆ ಆಗ್ಬಾರ್ದು ಅಂತ
ಇಂಟ್ರೆಸ್ಟ್ ನ ರೆಸ್ಟೋರ್ ಮಾಡಿದ್ರೆ ಬ್ಯಾಂಕ್ ನವರಿಗೆ ಆಲ್ರೆಡಿ ಅಡ್ವಾನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಲೋನ್ ನ.
ಹೌದು.
It will affect the bank interest also. Instead of you have to seek an relief, not to further pledge or
I will file I will file necessary application.
My lord, the idea is to delay the final hearing.
ನಾವ್ ಇಲ್ಲಿ ಕುತ್ಕೊಂಡು ನಿಮಗೆ ಲೀಗಲ್ ಅಡ್ವೈಸ್
I'm
ಮಾಡ್ಬೇಕು.
sorry.
That is your job.
I'm sorry.
ಮತ್ತೆ
My lord, kindly give a date for final hearing next week.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
For last 4 years.
ತೊಗೊಳ್ಳಿ. This is the matter of the year 2010
10
and almost more than 14 years old. And hence list this matter for final hearing on ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 212 312 212 ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇರ್ಬೋದು. 212 for final hearing and IA 1 of 24 will be considered along with main appeal.
35.
ನೀವೇನಾದ್ರು ಮತ್ತೊಂದು IA ಹಾಕೊಳ್ಳೋದಾರ ಹಾಕೋಬಹುದು.
ಆಯ್ತು ಸರ್.
35.
Vaibhavyam.
Hearing for the respondent, my lord. Yes.
This is a appeal filed by the union against the judgment passed by the Railway Claims Tribunal. The tribunal, my lords, has allowed the claim for compensation filed by the respondents. The accident took place in the year 2013, much prior to the amendment. Therefore, my lord, the
Much prior to the amendment, what amendment?
the 2017 amendment, where there was an enhancement of compensation from
Yes,
4 lakhs
yes,
to 8 lakhs.
Yes.
This position in law has not been taken into consideration by the
While
tribunal.
passing an order.
Yes, if your lordship may kindly take para 15
With interest 9%,
with interest at 6% till date of the
ought to
award.
have been made as 4 lakh. And if any accrued interest not exceeds the 8 lakh, then it would be 8 lakhs.
Yes,
That has to be modified in view of the judgment of the apex.
pass over a note, my lords, it will
Ah.
become easier.
That is the ground.
Yes. That is
Instead
what-
of awarding 8 lakhs with interest of 9%,
Yes,
ought to have awarded 4 lakh with interest not to exceed 8 lakh. That is the judgment of Supreme Court, recent judgment.
Supreme Court says is,
The
Date
4
of-
years interest 96 lakh. 1 month
96,000,
interest
my lords.
4,000.
principal would be 4 lakhs 98,000. Then it is awarded 9% from the date of the order till date of actual payment. We have deposited a check on 34/2018, about 1 year, 19 days after the date of the award. So 9% has been awarded. So my lord, the total compensation which can be allowed to the respondent is 5 lakhs 35,966. As per the judgment of Reena Devi, my lords, a maximum of 8 lakhs can only be granted to them.
That's what I am
Yes,
saying.
yes.
8 lakhs ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ ಅಷ್ಟೇ
ಅಷ್ಟೇ,
ಅಂತ.
ಅಷ್ಟೇ, my lords.
ಹಾ.
But one.
They are entitled for 8 lakhs, that's all.
Yes.
It should not exceed the 8 lakhs.
But after passing the, after allowing the application, the respondents are entitled to get the interest from the date of passing the order, my lordship.
Sir?
This case has disposed on after amendment 12th April 2017, this matter has been allowed. 8 lakh is okay, my lordship.
ಈಗ ಲೀನಾದೇವಿ ಕೇಸ್ ಪ್ರಕಾರ
Yes, madam.
4 ಲಕ್ಷ ಕೊಟ್ಟು, even if the interest not accrue
Yes.
more than another 4 lakhs,
Yes.
then entitled for maximum 8 lakhs.
8 lakhs.
You are entitled for only 8 lakhs. That's
8
all.
lakhs, when my lordship, at the time, when the order was passed on 12 April 2017, your lordship is correct.
ಹೌದು.
I am entitled to,
ಈಗ್ಲೂ ಅಷ್ಟೇ.
my lordship, because
ಈಗ ನಿಮ್ಗೆ ಎಕ್ಸೀಡ್ ಆಗುತ್ತಾ?
17 from
4 ಲಕ್ಷದಿಂದ 4 ಲಕ್ಷ ಎಕ್ಸೀಡ್ ಆಗುತ್ತೇನ್ರಿ ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್?
9% calculation ಮಾಡಿ ಇದು
It
ಮಾಡ್ಬೇಕು.
does not exceed, my lords.
ಅಲ್ಲಿಗೆ ಅಷ್ಟೇ ಬರೋದು 8 lakhs. It has to be modified, that's all.
But from the date of order 2017 till today, these respondents have been suffering.
ನೀವು ಆಯ್ತು, ನಿಮ್ಮ ಪಿಟಿಷನ್ ಪ್ರಕಾರ ಆಕ್ಚುಲಿ 4 ಲಕ್ಷ ಕೊಡಬೇಕಿತ್ತು ವಿತ್ 9% ಇಂಟ್ರೆಸ್ಟ್ ಆರ್ಡರ್ ಮಾಡುವಾಗ 2017 ಅಲ್ಲಿ. ಬಟ್ ನಾವು ಇನ್ ವ್ಯೂ ಆಫ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್,
Yes.
ಇಟ್ ಶುಡ್ ನಾಟ್ ಎಕ್ಸೀಡ್ 8 lakhs. 4 lakhs plus 4 lakhs. ಈಗ ನಾವು ನಿಮಗೆ ಬರತಕ್ಕಂಥದ್ದು ಈವನ್ ಲೆಸ್ ದೆನ್ 4 lakhs ಆದ್ರೂ ಯು ಆರ್ ಎಂಟೈಟಲ್ ಫಾರ್ ಅಪ್ ಟು 8 lakhs, ದಟ್ಸ್ ಆಲ್.
Technicalities. They could have filed the review petition before the tribunal also. It could have been such.
ವಕೀಲಲ್ಲೂ ಏನು ಗ್ರೌಂಡ್ ಅರ್ಜ್ ಮಾಡಬಾರ್ದ?
ಅಲ್ಲ, ಇಲ್ಲಿ ಏನು technicalities, unnecessary,
That's all.
7 years have been lapsed. 7 years.
Heard the appellant counsel and also the counsel.
My lords, one more
7 years ನಿಮ್ಗೆ ಲೀನಾದೇವಿ ಕೇಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವಾಗ ಬಂದಿದೆ?
19, 2019.
ಆ ಬೆನಿಫಿಟ್ ಸಿಗ್ಬೇಕಾದ್ರೆ ನಿಮ್ಗೆ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇರೋ ಹೊತ್ತಿಗೆ ಸಿಗೋದು. ಇಲ್ದವ್ರು ಎಲ್ಲಿ ನಿಮಗೆ ಸಿಗುತ್ತಾ?
ಇಲ್ಲ, ನನಗೆ 8 lakhs ಗೆ 1/1/2017 ನಾಗೆ ಸಿಕ್ತಿತ್ತು. 1/1/2017. This is the 2013 accidents.
ಸರಿ ರೀ, ಅಮೆಂಡ್ ಆಗಿರೋ 2017 ಅಲ್ವಾ?
ಹೌದು.
17 ನಂತರದಲ್ಲಿ ನಿಮಗೆ 8 lakhs ಕೊಡ್ಬೇಕು.
17 ನಂತರದಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಪಾಸ್ ಆಗಿರೋದು.
ಜಡ್ಜ್ಮೆಂಟ್ ಪಾಸ್ ಆಗ್ಲಿ ರೀ, ನಿಮಗೆ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಯಾವತ್ತಿಗೆ ಹೋಗುತ್ತ್ರಿ?
ಅಲ್ಲ,
ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅರೈಸ್ ಆಗೋದೇ ಆಕ್ಸಿಡೆಂಟ್ 2013.
ಇಲ್ಲ ಸುಮ್ಮನೆ from the award fixed when the case is disposing.
I have a judgment on this point, my lords. If he is sad.
ಅವ್ರು ಹೇಳ್ತಾರ ಅಷ್ಟೇ.
ಇಲ್ಲ ಸುಮ್ಮನೆ
ಈಗೇನ್ ನಿಮ್ಗೆ 8 ಲಕ್ಷಕ್ಕಿಂತ ಜಾಸ್ತಿ ಬೇಕಾದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. 8 ಲಕ್ಷ ಈಗ ನಿಮಗೆ ಬರೋದು 8 ಲಕ್ಷ ಮಾತ್ರ. ಲೀನಾದೇವಿ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರನೇ. ಹೌದಲ್ವಾ? ತೊಗೊಳ್ಳಿ.
My lords, one more issue. In 2018, we deposited a check for 10,000, my lords, 10 lakhs,
ಈ
6,130.
ಅಪೀಲ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀರಾ?
Yes, my lords.
ಆಯ್ತು.
So that whatever is beyond 8 lakhs has to be returned back to the Union of India.
ಅದು ವಾಪಸ್ ಬಂದೇ ಬರುತ್ತೆ ನಿಮ್ಗೆ. ಈಗ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು?
10 lakhs,
10 lakhs
6,130.
ಕಟ್ಟಿದ್ದೀರಾ?
Yes, my lords.
ಆಯ್ತು, ಆರ್ಡರ್ ಮಾಡೋಣ. ತೊಗೊಳ್ಳಿ. Heard the appellant counsel and also the counsel appearing for the respondent. This appeal is filed challenging the award passed by the Railway Tribunal granting statutory compensation of rupees 8 lakh along with interest thereon at 6% per annum from 16/7/2014 to till the date of award, and thereafter 9% per annum till the date of actual payment of the same. The main contention of the appellant counsel before this court is that the tribunal committed an error in passing and awarding an amount of rupees 8 lakh. And date of award was 12/4/2017 and date of filing of appeal 16/11/2017 and date of judicial deposit made before this court is 30/4/2018. And also counsel would submit that date of accident was on 23/2/2013 and amendment was brought in 2017.
11/2017.
11/2017, enhancing the from 4 lakhs to 8 lakhs.
8 lakhs.
And the tribunal ought not to have awarded 8 lakhs with the interest at 6% and thereafter also 9% as per the award. and committed an error, and hence this court has to interfere with the findings of the trial court and modify the award passed by the tribunal. Per contra, the counsel appearing for the respondent would submit that award was also passed subsequent to the amendment on 12/4/2017, and trial court not committed any error. Having heard the appellant counsel and also the counsel appearing for the respondent, it is not in dispute that accident was taken place on 23/2/2013. And though award was passed on 12/4/2017, subsequent to the amendment enhancing from 4 lakh to 8 lakh, and the very contention of the respondent cannot be accepted, and the amendment is only a prospective and not retrospective. The apex court also discussed the same in Leena Devi case and also held even if the accidents are earlier to amendment and made it clear that the maximum amount would be 8 lakhs and not more than 8 lakhs, even if the interest accrued not up to 8 lakhs. And when such being the case, the appellants, the respondents are entitled for total amount of rupees 8 lakhs and not more than that. And the tribunal committed an error in awarding the 8 lakhs, taking into note of the same as retrospective, and that is, and the same is not correct and committed an error, and hence the order impugned is liable to be modified. In view of the discussions made above, I pass the following order. The appeal is allowed. The impugned judgment and award of the tribunal is modified, granting compensation of rupees 4 lakh with interest and maximum amount of rupees 8 lakh inclusive of interest. Inclusive of interest in view of the judgment of the Leena Devi case. The appellant counsel submits that they have deposited the amount of rupees 10 lakh.
10 lakh 6,130.
6,130, and excess amount of rupees 8 lakh has to be refunded in favor of the appellant on proper identification. And accordingly, appeal is disposed of.
With respectful submission, my lordship. Here, 5 respondents are there. The apportionment of their award given by the trial court. Wife and children of the deceased.
Apportionment ಮಾಡಿದ್ರು.
ಈಗ
ಯಾರ್ಯಾರು ಹೇಳಿ ಇರೋದು?
Respondent number 1 has been allotted 2 lakhs, remaining
ಅದ್ ಬಿಟ್ಬಿಡಿ, ಈಗ ನಾವ್ 8 lakhs ಅಲ್ಲಿ modify ಮಾಡೋಣ. ಯಾರ್ಯಾರು ಹೇಳಿ?
Respondent number 1, deceased wife.
ಎಲ್ಲ ಮಕ್ಳಿದ್ದಂಗಿದಾರ್ರಿ.
ಎಲ್ಲ ಮಕ್ಕಳು ಹೆಂಡತಿ ಮಕ್ಕಳು.
4 ಜನ ಮೈನರ್ ಮಕ್ಕಳು.
ಈಗ ಎಲ್ಲರೂ ಮೇಜರ್ ಆಗಿದ್ದಾರೆ ಸುಮ್ಮನೆ. ಅಟ್ ದಿ
2013 ಅಂತಂದ್ರೆ ಈಗ ಎಲ್ಲ ಆಗಿರುತ್ತೆ.
ಎಲ್ಲರೂ
ಮೇಜರ್.
ಮೇಜರ್.
On deposit of the amount of rupees 8 lakh. 5 ಜನ ಇದಾರ?
ಹೌದು ಸುಮ್ಮನೆ 5 ಜನ ಇದ್ದಾರೆ. ವಿಡೋಗೆ ಸ್ವಲ್ಪ ಹೆಚ್ಚಿಗೆ ಮಾಡೋಣ.
3 lakh is awarded in favor of the wife, that is the first respondent.
Yes.
And claimant number 1.
ಹೌದು.
2, 3, 4. Remaining 5 ಲಕ್ಷ ಅಂದ್ರೆ 1.25 ಲಕ್ಷ ಬರುತ್ತೆ ಒಬ್ಬೊಬ್ಬರಿಗೆ. And remaining amount of rupees 1,25,000 is awarded in favor of the respondent number 2 to 5.
Equally.
And claimant number 2, 3, 4, 5 equally.
Yes.
Aste.
Please.
On proper identification.
Much obliged.
44. I may be permitted to file my wakalat, my lords, and
ಯಾಕೆ ನೀವು ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ? MA not filed ಅಂತಿದೆ. ಹಾಕ್ಬಿಡಿ. In the meanwhile, counsel for the appellant is permitted to file MA. MA or ವಕಾಲತ್. ಯಾವ್ದಾರ ಆಯ್ತು.
44.
In this matter, my lord, I am the plaintiff for the trial court. Filed an application order 13/1 and 2, seeking the prayer has not to alienate the properties concerned. It is issued for partition, my lord. It is of joint family properties of the appellants as well as respondent number 2 to 14. Kyle may pursue page number 4 of the appeal memo, please.
Page number
4. Here, para number 2, it is submitted that as per the family tree, plaintiffs and appellants along with the dependent 2 to 14, respondent 2 to 14 are joint possession and ancestral property of lands such as survey number 36/1, 36/2, 36/4, 31/13 and 40.
ಎಲ್ಲಾರ್ದೂನು ancestral property ಅಂತ plead ಮಾಡಿದಿರಿ.
ಹೌದು.
ಆಯ್ತು.
ಆಮೇಲೆ page number 19. G, it is a glance of Z tree. Here, the ಒರಿಜಿನಲ್ ಪ್ರಪೋಸಿಟರ್ ಮುನ್ಸಾಮಪ್ಪ
ಇಲ್ಲಿ ಯಾವ ಪೇಜ್ ಓದ್ತಾ ಇದ್ದೀರಿ?
19.
19. ಹಾ.
ಪ್ರಪೋಸಿಟರ್ ಮುನ್ಸಾಮಪ್ಪ, ಮುನ್ಸಾಮಪ್ಪ ಡೆಡ್ ಲಿವಿಂಗ್ ಬಿಹೈಂಡ್ ಮುನಿಯಪ್ಪ ಅಂಡ್ ರಾಮಯ್ಯ. ಇಲ್ಲಿ ಮುನಿಯಪ್ಪ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಕೆಳಗಡೆ ಬರುವುದು ಅಪ್ಲೈನ್ 1 and 2. ಅಂಡ್ ರಾಮಯ್ಯ ಹ್ಯಾಡ್ 2 wives. ಫಸ್ಟ್ ವೈಫ್ ಬರುವುದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
ಗಿರಿಜಮ್ಮ.
ಗಿರಿಜಮ್ಮ ರೆಸ್ಪಾಂಡ್ 2 to 14. ಅಂಡ್ ಸೆಕೆಂಡ್ ವೈಫ್ಗೆ ಅಪ್ಲೈನ್ ನಂಬರ್ 3 and 4.
ಮುನಿಯಮ್ಮ.
ಹೌದು ಸರ್. ಮುನಿಯಮ್ ಅಂಡ್ ಮಹೇಶ್ ಬಾಬು.
ಆಯ್ತು.
Kindly may pursue the page number 31, please. This is the consent date, please. 131. It's of a document. This is the document.
Page number ಎಷ್ಟು?
131.
131.
This is the consent date.
Consent
executed by Girjamma and all the respondents. 2 to 14.
Respond number 2 to 14.
Oh, yes, please. Here, in page number 137, wherein ಇದು ಬಹಳ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ.
137.
ಹೌದು ಸರ್, 137. ಮೂಲ ಪುರುಷ ಬೈ ನೇಮ್ ಡಿಸೀಸ್ ಮುನ್ಸಾಮಪ್ಪ, ಆಲ್ರೆಡಿ ಸಬ್ಮಿಟೆಡ್. Dead by leaving behind 2 sons, respectively deceased Muniappa and deceased Ramaya. The said land is joint possession of both legal heirs Ramaya and Muniappa. Here, the appellants are the legal heirs of the Muniappa and respond 2 to 14 are the legal heirs of the Ramaya. Hence, the first party joined as consenting party by making consent joint possession of both the deceased persons by name late Ramaya and late Muniappa.
Consent deed in favor of whom?
In favor of purchaser. Here is the respond number 1 is the purchaser.
Here respond number
Yes,
1.
1. This is the property sold by the appellant side. Survey number 36/1. While making this consent deed, they are admitting that is a joint family property. Kindly may pursue the page number 158, please. In 158, it's of a sale agreement. It is of a registered agreement in the year 2019, wherein respondent 2 to 14 are the parties. To my survey number, this is appellant survey number 36/1. Without noticing to the appellants, they registered the document in respect of survey number 36/1 is concerned. Wherein the kindly may pursue the page number 164, please. Wherein Akkulappa was the owner of the scheduled property, which is an ancestral property. The above said Akkulappa was not married and he was taken take away by Ramaya and his legal heirs. He was residing with then till his death. Whereas the above said Akkulappa is reported to the dead, and after his death, the legal heirs of Ramaya who have become the owners of the scheduled property, that is the vendors are the joint owners. Here in this agreement, the appellant number 2, appellant number 4 and 3 and 4 is available here. According to them, this survey number 36/1 is an ancestral property. It is the document, registered document says. Kindly may pursue the page number 338, please. In 338,
deed of confirmation.
awesome. ಇದರಲ್ಲಿ ಕನ್ಫರ್ಮೇಶನ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೈಡ್ ಕನ್ಫರ್ಮೇಶನ್ ಮಾಡಿ ಡೀಡ್ ಯಾವ್ದಕ್ಕೆ 136/1ಗೆ ನಮ್ ಪ್ರಾಪರ್ಟಿಗೆ. ಕೈಂಡ್ ಮೇ ಪರ್ಸ್ಯೂ ದ ಪೇಜ್ ನಂಬರ್ 340. ಇದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 36 ಕನ್ವರ್ಟೆಡ್ ದ ಅಫಿಷಿಯಲ್ ಮೆಮೊರಂಡಮ್ ಡೇಟೆಡ್ 5/8/2001 ಕನ್ವರ್ಟ್ ಮಾಡಿ ಇದ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಇದಕ್ಕೆ ಕನ್ಸೆಂಟೆಡ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿ. ಸ್ವಾಮಿ ನಾನು ಲೇಟೆಸ್ಟ್ ಆಗಿ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ. ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಏನಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಒನ್ ಆಫ್ ದ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಅದರಲ್ಲಿ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸ್ವಾಮಿ.
And what date you have filed?
On 15th November. I served the copy on the other side also, please.
15 November ಯಾವ್ದಿಲ್ಲ ಅಲ್ಲ? ಇಷ್ಟೇ ಇದು. ಪುಟ್ ಅಪ್ ಮಾಡಿಲ್ಲ ಇರ್ಬೋದು ಆಫೀಸರ್ ನೋಡಿ. ಇಲ್ಲ ಏನದು ಡಾಕ್ಯುಮೆಂಟ್?
ಅದರಲ್ಲಿ ಒನ್ ಆಫ್ ದ ಕೇಸ್ ಫೈಲ್ಡ್ ಬೈ ದ ಅಪಲೆಂಟ್ಸ್, ಅದ್ರಲ್ಲಿ ಬಂದು ಅವರು ಅಯ್ಯ ಹಾಕಿದ್ದಾರೆ. ಅಯ್ಯನಲ್ಲಿ ಏನ್ ಹಾಕಿದ್ದಾರೆ? ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ, ನಮಗೂ ಭಾಗ ಇದೆ, ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ.
Who filed impleading
ದಿಸ್
application?
ರೆಸ್ಪಾನ್ಸ್ ಸೈಡ್.
Respondent.
ಎಸ್ ಪ್ಲೀಸ್.
ಆಯ್ತು.
ಆಮೇಲೆ ರಿಜಿಸ್ಟರ್ ಸೇಲ್ ಡೀಡ್ ಇದೆ ಯಾವಾಗ 2020 ನಲ್ಲಿ. ಆ ಸೇಲ್ ಡೀಡ್ 31/13.
ಆಯ್ತು. What is the error committed by the trial court?
The trial court committed by error.
Documents ಇದ್ರೂನು ಕೂಡ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಹೌದು ಸ್ವಾಮಿ, ದಟ್ ಈಸ್ ಮೈ.
That is your argument.
Please.
Crux of argument.
Please.
ಹೇಳಿ. What is the reasoning?
Therefore, these are joint properties. No, so far, no any partitions took place in between the family members of the joint owners. That is why the trial court committed in errors. Under these circumstances, I filed this appeal before this honorable court seeking relief from this honorable court. Kindly make my appeal may be allowed.
Reasons are assigned, my lord.
In paragraph number 8,
Para 6 onwards, my lord, the learned judge has given reason. But may I permit me to read the reasonings? Survey number 36/2 measuring 1 acre 2 guntas situated at Gatali village, Anekal.
which para you are reading?
Para 6, my lord. Para 6.
Measuring 1 acre 2 guntas.
2 guntas, so and so. Plaintiffs have also sought that sale deed dated 21/2/23 executed by defendant 2 to 14 in favor of defendant 1 in respect of the suit schedule property is not binding on them. Plaintiffs have specifically contended that Muni Shamappa is the propositors of their family. He died by leaving behind Yalagappa and 2 sons, Muniappa and Ramaya. Plaintiffs are contended that now Yalagamma, Muniappa, Ramaya are no more. Plaintiffs are contended plaintiff 1 Pillamma is the wife, plaintiff 2 Hanumantappa is the son of Muniappa. Plaintiffs are contended that Ramaya has died leaving behind 2 wives, first wife Girijamma, second wife Muniamma. Plaintiff 3. Plaintiffs are contended that Ramaya through his wife Girijamma had 2 sons, Muniraju and Kumar, 2 daughters Varalakshmamma and Renuka. Defendant 2 to 14 here are the sons and daughters and legal heirs of Ramaya through his first wife Girijamma. Plaintiffs have specifically contended that defendants 2 to 12 are living in undivided joint family and their joint family earlier was owned 36/1, 36/2. Plaintiff 2 executed sale deed on 28/10/2020. This is one aspect that has to be gone into. And he then files the suit in respect of 36/1 in favor of third parties. Later, defendant 2 to 14 have executed confirmation deed on 6/11/2020, confirming the sale executed by plaintiff 2. Plaintiffs are contended that suit schedule property 36/2 measuring 1 acre 2 guntas is their ancestral joint family property, but defendants 2 to 14 behind the back of plaintiffs succeeded in mutating MR number so and so based on illegal records. They have alienated suit property in favor of defendant 1 through sale deed on 21/2/23. The same is not binding on them. Plaintiff on these grounds have come up with the suit seeking partition and separate possession of their share and also seeking declaration. Sale deed executed in favor of defendant 1 is not binding. Suit summons are.
That is in respect of survey number 36/2.
Yes.
That is in respect of survey.
As 36/1 is concerned, they have executed the sale deed.
Yes.
You have confirmed the sale deed.
Yes, ma'am. That is what one contention.
Yes.
That property, the family is in this way only, ma'am. Then turn to page 10. Defendant 1 has specifically contended, third line there. Page 10.
Para?
Para 7. After the suit summons, etc. Defendant 1 has specifically contended, Ramaya, son of Muni Shamappa, husband of defendant 1, purchased the suit property through sale deed dated 15/10/68 from one Jayamma. After the death of Ramaya, defendant 1 being the wife, got revenue entries in her name. Defendant 2 has further contended that defendant 2 got conversion of the suit land for non-agriculture residential purpose, sold the same along with their other family members in favor of defendant 1 through registered sale deed on 21/2/23. Defendant 1 has contended suit schedule property was the absolute property of Ramaya, and as such, after his death, defendants 2 to 14 being the owners have alienated the same in their favor. Defendant 1 has further contended plaintiff have come up with the and come up with
Unclean hand.
not come up with clean hands. And in the plaint, they have not revealed about other joint family properties. As such, they have sought for dismissing IA1 seeking order of temporary injunction. Plaintiffs themselves are contended that 36/1 measuring 2 acres 3 guntas in their joint family property, but plaintiff 2 alienated the same in favor of third parties. Defendant 2 to 14 have executed confirmation deed. Plaintiff side have furnished the sale deed of 28/10/20 executed by Hanumappa, the plaintiff 2 in their favor of Prakash, Chetan, Manjunath into 36/1, 2 acres 3 guntas, 36/4, 20 guntas. Plaintiffs are contended defendant 2 to 14 have executed confirmation deed so and so. It is on record that plaintiffs 3 and 4 have also executed confirmation deed confirming the sale deed. The plaintiffs have also furnished one more sale deed on 12/8/2020 executed by plaintiffs 3 and 4 and some of the legal heirs of Ramaya through his wife Girjama, alienating 31/13, 2.35 in favor of third parties. In the sale deed, it is recited 31/13 was owned by Ramaya. Plaintiffs also with their plaint have furnished G-tree. It makes out clear that Ramaya through his second wife Muniamma has one son Mahesh Babu, the plaintiff number 2, herein 2 daughters namely Shanta Kumari and Vasanta Kumari. Plaintiff in their entire plaint nowhere has revealed how 2 daughters of Ramaya through second wife Muniamma don't have any right in the suit properties. Certainly, as per the case of plaintiff, if the suit schedule properties are their ancestral joint family properties or absolute properties of Ramaya, his 2 daughters Shanta Kumari, Vasanta Kumari are necessary parties. In their absence, the dispute here cannot be adjudicated on merit. Parties who come to court seeking equitable relief of injunction should come to court with clean hands, detailing their available properties by hiring all necessary parties. In view of these, I am of the opinion plaintiffs are not made out a prima facie case. This is all what the findings is. But the suit is only targeting a certain property. But the entire suit for partition is filed, not revealing the alienations of the properties. All parties are not made as parties to the proceedings. Of course, the alienation made insofar as the first defendant is concerned before the trial court, but the confirmations are made by plaintiffs 3 and 4 also on record. Some plaintiffs.
That is in respect of survey number 36/1 only.
36/1. And it is on record that plaintiffs 3 and 4 have also executed confirmation deed confirming
Survey
sale
number
deed.
31/13.
Yes, Manoj. Insofar as these are concerned. Insofar as this property is concerned, they have filed the suit for partition. Now the family is one and the same. One time when they want the property
Defendant number 1 purchased the property of survey number
of 36/1.
36/1.
Yes.
36/1 already sold.
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 Confirmation deed also executed.
Yes.
36/2. 2 acres. 2 acres.
Survey number 36/2.
Yes.
Family property in ತೋರ್ಸಕ್ಕೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
ನಮ್ಮ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ, ಅವ್ರು ಒಪ್ಕೊಂಡಿದಾರಲ್ಲ ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಅಲ್ಲಿ ನಮ್ ಸರ್ವೆ ನಂಬರ್ಗೆ. ದಿಸ್ ಇಸ್ ದ ರಿಸಿಟಲ್ಸ್ ಅವೈಲೇಬಲ್ ಇನ್ ದ ರಿಜಿಸ್ಟರ್.
ಅವ್ರೇನ ರಾಮಯ್ಯ ಪರ್ಚೇಸ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಆನ್ 15/10/1968 ಅಂತ ಹೇಳ್ತಾರಲ್ಲ,
ಅವರು ಈ ಕನ್ಸರ್ನ್ ಡೀಡು ಮತ್ತು ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ಗಳಲ್ಲಿ ಕೂಡ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಪ್ರಾಪರ್ಟಿ ಥ್ರೂ ದಿ ಸೇಲ್ ಡೀಡ್ ಡೇಟೆಡ್ 15/10/1968 ಫ್ರಮ್ ಜಯಮ್ಮ ಅಂಡ್ ಆಫ್ಟರ್ ಡೆತ್ ಆಫ್ ರಾಮಯ್ಯ ದ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಬೀಯಿಂಗ್ ದಿ ವೈಫ್ ಗಾಟ್ ದಿ ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಇನ್ ಹರ್ ನೇಮ್ ಅಂತಿದೆ. ಅದ್ಯಾವ್ದು ಸೇಲ್ ಡೀಡ್? ಯಾವ್ದು ಯಾವ ಸರ್ವೆ ನಂಬರು? 36/2 ಏನಾದ್ರು ಅಡ್ಮಿಷನ್ ಇದೆಯಾ? ಇಟ್ ಈಸ್ ಅನ್ ಆನ್ಸೆಸ್ಟ್ರಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ
ಅಡ್ಮಿಷನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಇದೆ. ಕನ್ಸರ್ನ್ ಡೀಡು ಮತ್ತು ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಅಲ್ಲಿ ರಿವೀಲ್ ಆಗಿದೆ. ಅದರಲ್ಲಿ
ಯಾವ್ದನ್ನ ರೆಫರ್ ಮಾಡ್ತಾರೆ? 36/1
36/1 ಸೈಡ್ 36/2
ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ರಿ. ಅವ್ರಿಗೆ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಪರ್ಚೇಸ್ ಮಾಡಿರೋ 36/2 ಮಾತ್ರ ಅಲ್ವಾ? ನೀವು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿರೋದು ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್
36/2
ಮಾತ್ರ.
2 ಮಾತ್ರ.
ಹೌದು.
ಅದಕ್ಕೋಸ್ಕರ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ನಾನು ಅನೆಕ್ಜರ್ ಎ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದರಲ್ಲಿ ದಿಸ್ ಇಸ್ ದ ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೀಡ್.
ಸೇಲ್ ಡೀಡ್ ಆಫ್
ರಿಜಿಸ್ಟರ್ ಸೇಲ್ ಡೀಡ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಸರ್ವೆ ನಂಬರ್ 31/13.
31/13.
ಇದು ಕೂಡ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿ
ಸೂಟ್ ಹಾಕಿರೋದು ಯಾವ ಸರ್ವೆ ನಂಬರ್?
36/2
ಮಾತ್ರ.
ಹೌದು.
2 ಇಟ್ ಈಸ್ ಅನ್ ಆನ್ಸೆಸ್ಟ್ರಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಕೊಟ್ಟಿದ್ರಿ ದಾಖಲೆ?
ಅದಕ್ಕೆ ಸಪೋರ್ಟಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅನೆಕ್ಜರ್ ಎ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ ಮೊನ್ನೆ.
ಅನೆಕ್ಷರ್ ಏನ
ಎ
ಬಂತ ಮೇಡಮ್? ಅದೇನ
Annex JA.
Statement of objections ಅಲ್ರಿ ಅವ್ರೇನ ಹಾಕಿದೀನಿ ಅಂತಾರಲ್ಲ ಅದ್ಯಾವ್ದು
ನಾನು
document?
ಹಾಕಿಲ್ಲ.
Additional document, copy also served on the other side ಅಂತಾರಲ್ಲ. ಅಕ್ನಾಲ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ. ಹೈಕೋರ್ಟ್ 19th ಏನ್ ಹಾಕಿದಾರ ನೋಡಿ, 19th ನವೆಂಬರ್ ನಿನ್ನೆ ಹಾಕಿರ್ಬೇಕ್ರಿ. ಅದ್ ನಿನ್ನೆ ಹಾಕಿರೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್.
ನಿನ್ನೆ ಹಾಕಿರೋದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಒಬ್ಜೆಕ್ಷನ್.
15th ಹಾಕಿರೋದೇನ ಇದೆ?
15th.
ಮತ್ತೆ ಇದು ಮಾತ್ರ ಕೊಡ್ತಾರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್?
ರಿಟರ್ನ್ ಆಗಿರ್ಬೇಕು ಅವ್ರು.
Well, heard in part, appellant counsel submits that he has filed additional documents on 15/11/24 and hence registry is directed to put up the same and list this matter on. Other date ಕೊಡಿ ಮೇಡಮ್. Incomplete. ನಿನ್ನೆ ಕೊಡ್ತಾರೆ, ಈಗ 15 ಯಾಕೆ ಕೊಡಲ್ಲ ಆಫೀಸ್ನವರು? ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅವ್ರು ಹಾಕಿರೋದಂತಂದವ್ರಲ್ಲ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 23/11 ನಾಡಿದ್ದು ಹಾಕಿರಿ ಸ್ಯಾಟರ್ಡೆ ನೋಡೋಣ. ಸಾಟರ್ಡೆ
48.
ಶ್ರವಣ ಶ್ಲೋಕ್ರೆ ಹೇಳಿ.
Suit is for specific performance. I am the plaintiff's appeal. And what has happened is that the defendants 1 to 17 completed 1 to 17 executed an agreement in my favor on 10/7/2017. I paid an advance sale consideration of ₹10 lakhs. The sale consideration was agreed at 61,75,000. There is no dispute about the fact that there is an agreement of sale. When I issued a legal notice to them, they have given a reply also. And in the reply also, they term it as a loan transaction and they don't dispute the existence of an agreement.
Agreement dispute ಮಾಡಿಲ್ಲ, but content that is
Yes.
sale agreement.
Usual defenses, usual defense.
ಆಯ್ತು.
Now, my lord, what has happened is, since they did not come forward and I was ready and willing to perform my part of the contract, and there was a refusal to execute sale deed, I instituted the suit for specific performance on 16/4/2018. Right, on 16/4/2018, after which there was an office objection. The office objection was compliant. What the office objection is found in the order sheet, my lord, which I have furnished. The agreement of sale was impounded by the Honorable Court, Trial Court, and directed me to pay duty and penalty. That order sheet is produced.
Why it was impounded, whether any recital of delivery of possession?
ಇಲ್ಲ
ಮತ್ತೆ
ಮತ್ತೆ ಹಂಗೂ ಇಂಪೌಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಪೇಜ್ 62 ಅಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ.
500 rupees stamp.
One minute, sir. On perusal of the agreement of sale dated 18/6/2012, it is written on each stamp paper of ₹500. The sale consideration is shown as 61,75,000. There is no recital about delivery of possession. As on the date of execution of agreement of sale, Karnataka Act 16 of 2011 Stamp Act Amendment is applicable. As per Article 5E2 of the Karnataka Stamp Act, proper stamp duty of rupees is 10 paise per every 100 rupees, etc. Then, my lord, office, the plaintiff is directed to pay deficit stamp duty of 6,175 and 10 times penalty of 56,750, 62,925. I paid, my lord. I paid and argued once again on IA1. And my lord, on 5/12/2018, my lord, 67th page number, an order was passed, my lord. An interim order was passed, restraining the defendants from alienating or encumbering the suit schedule property in any manner whatsoever till the next date of hearing. That was extended every date of hearing. This order, my lord, was passed on 5/12/2018. My lord, now what has happened is, kindly see the impugned order. What happened was, subsequently, a person comes on record. That is subsequent to the passing of impugned order, ex parte interim order of injunction. An impleading application is made on 6/7/2022 by the 18th respondent, claiming to be the GP holder of all the other defendants and claiming that he has purchased this property. And on the behalf of everybody, he files return statement also, denying the contentions, denying taking rival contentions. 15/3/2023 his impleading application is allowed. Amendment also is carried out. On 8/9/2023, defendants, all defendants through this defendant number 18 filed return statement. Matter was posted for issues. Right, when the matter is posted for issues on 8/9/23 after lapse of several years, not to alienate ಅಷ್ಟೇ. ಅದು subsequent purchaser ಬೇರೆ ಬರ್ತಾರೆ ಮುಂದೆ, though there is no mention about his purchase in the legal notice and all that. 6/1/2024, the court, trial court holds hearing on IA number 1 and on 23/4/24 rejects the application on the ground that stamp duty is not paid. Again, stamp duty is not paid on the agreement. And kindly see the reasons at page number 21, ink page 20. This is a suit filed, I'm reading the reasons, point number 1. This is a suit filed by the plaintiff against defendant number 1 and so on. So application is filed against defendant 1 and seeking interim order, restraining them from creating third party right in respect to the suit property. Subsequently, defendant 18 was impleaded. D18 is the person who has purchased the suit scheduled property from D1 to 17, registered sale deed dated 21/9/17. It is pertinent to note that no injunction is sought against D18 in this application. It is appearing that the defendants 1 to 17 have already executed sale deed on 21/9/17 in favor of defendant 18, and they are no more owners of the suit property. As observed supra, no injunction is sought against defendant 18, and the defendants 1 to 17 have presently no title over the suit property to alienate the same. In view of the same, IA1 has become infructuous. As on date of filing of the suit, no injunction can be granted against D1 and to 17. Then again, on careful perusal of the documents placed on record, suit document, that is agreement of sale dated 10/7/17, is an unregistered document. Sale consideration is shown as 61,75,000. Agreement was prepared on stamp paper of 512. Prima facie, it appearing that the agreement has been prepared on a stamp paper which is less than the stamp duty payable on the instrument. There is clearly deficiency of stamp duty payable in respect of the suit document. It is settled law that no injunction shall be granted on the basis of the agreement which is not sufficiently stamped. In this case, it is prima facie appearing that the suit document is not only unregistered but also insufficiently stamped. Plaintiff has not produced even a single piece of paper to show readiness and willingness to perform his part of the contract. He has financial capacity to pay balance sale consideration amount. And the defendant number 1 died during course of proceedings. No injunction can be granted against him. However, there is no evidence to establish financial capacity of the plaintiff to pay the balance sale consideration amount. Plaintiff has neither deposited the balance sale consideration nor produced any statement of account, and that he was ready and willing to perform, etc., etc. So, not 3 grounds are made out while passing the order. The circumstances indicate suit document is unregistered, insufficiently stamped, plaintiff has not produced statement of account and pay balance sale consideration. There is no prima facie case. But my humble submission is, here is a suit filed for specific performance. In the beginning itself, I paid the stamp duty and narrated the events. But this man comes into the picture on his own, not through me. I didn't implead him. So he has stepped into the shoes of the defendants. Actually, automatically the injunction order which was passed earlier binds him. It is not his case that the injunction order is not binding.
Injunction order ನಿಮಗೆ temporary ಯಾವಾಗ ಸಿಕ್ಕಿದ್ದು?
5/12 months. 18 ಅಲ್ಲಿ.
5/12/2018.
18. ಅದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರೆ ದಾವೇನೆ ಮುಗಿಸ್ಬಿಡಬಹುದಾಗಿತ್ತು ಇವಾಗ. It would have been clear whether that without any agreement, he doesn't plead any
agreement ಅಲ್ಲ, ಸೇಲ್ ಡೀಡ್ ಅಂತ ಏನು ಅಬ್ಸರ್ವ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, straight away sale deed. There is no prior agreement also.
ಬೇಕೇ ಬೇಕು ಅಂತ ಏನಿಲ್ವಲ್ಲ.
ಬೇಕೇ ಬೇಕು. That is all matter of trial. And my lord, as far as readiness,
anyhow, you would have sought the relief against them, him also, when he comes up before the court, saying that already sale deed is executed in favor of me. You would have sought the relief not to further alienate the property by defendant number 18.
That's why I mentioned the court posted the matter for issues. Suddenly took it up and wants to.
ಆಯ್ತ್ರಿ, ನೀವ್ ಯಾಕೆ ಕೈಯೇ ಹಾಕ್ಲಿಲ್ಲ against 18 when he comes with written statement stating that property was already sold in favor of accused number 18, respond number 18, defendant number 18. That's why the trial court made an observation. Maybe some error are also there on the record, reasoning. But you have not sought any relief against.
We have the injunction, the suit binds him because he's also himself a party. He himself came on record. If I had made him party, that is a different issue.
Anyhow, he comes.
I'll file application, my lord. Question is, my lord, now the injunction is vacated on wrong grounds. One is stamp duty, which is already
Stamp
paid.
duty kattidiri.
Then the prima facie case illa you do what I must show in the main trial under section 20. I should, how can I show it now?
What is there to restrain the other defendants when already they have sold the property?
My lord, they have sold subsequent to their legal notice.
Legal notice ಆಯ್ತು ಅದಕ್ಕಿಂತ ಮುಂಚೆನೆ ಸೇಲ್ ಆಗೋಗ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು ಎಂಟ್ರಿ ಮಾಡೋರು ತಗೊಳಕ್ಕಿಂತ ಮುಂಚೆ.
That is the only problem. Now that he is on record, I must seek fresh application.
Fresh application, that's all. ಮತ್ತೇನಿದೆ ಬೇರೆ ಏನಿಲ್ಲ. You can seek the order, that's all.
Party.
Heard the appellant.
But as far as that observation may be made, I have already
That is
paid.
not correct, that is not correct.
That may be set aside.
The appellant counsel and also the counsel appearing for the respondent. The impugned order challenge before this court rejection of IA filed against defendant number 1 to 17 to restrain them from alienating the property. And trial court granted ex parte ad interim injunction in favor of the plaintiff on 5/12/2018. The defendant number 18 appears and files written statement on becoming a party to the suit as defendant number 18, contending that he had already purchased the property on 21/9/2017 and sale deed was executed.
18 minute.
Huh?
18.
Allah, sale deed dated 21/9/2017.
7.
Our favor ಆಗಿರೋದು.
Yes.
Agreement ಆಗಿ 2 ತಿಂಗಳಿಗೆ ಆಗಿರೋದು ಅವ್ರಿಗೆ.
Yes.
Sale deed.
ಆಮೇಲೆ ಹೇಳ್ತಾರ ಅವ್ರು.
21/9/2017 and contend that already property was sold and question of restraining defendant number 1 to 17 doesn't arise. The trial court also taken note of the said fact while assigning the reasons. However, made an observation that document of sale agreement was prepared on stamp paper of rupees 512 and not paid the proper stamp duty, but on perusal of the records and also the counsel brought to notice of this court already paid the deficit stamp duty in view of the order passed by the trial court, and observation made by the trial court in paragraph number 8 is erroneous.
And also determination regarding readiness and willingness at prima facie stage.
The other reason given by the trial court that ready and willingness to perform is part of contract ought not to have been discussed at the time of considering the IA while granting the relief of temporary injunction. And reason assigned by the trial court that no stamp duty is paid and also the willingness to perform is part of contract is erroneous. However, taking into note of the fact that already property was sold in favor of defendant number 18, and the appellants are given liberty to seek the appropriate relief against the defendant number 18. Since already there is a sale deed even prior to the filing of the suit against defendant number 1, that is 21/9/2017. No doubt there is an agreement of sale dated 10/7/2017. And the subsequent sale deed in favor of defendant number 18 is on 21/9/2017. And court has to consider the right based on the sale agreement of the plaintiff of public appellant dated 10/7/2017. And also take note of if any multiplicity of proceedings render injustice to the parties. And keeping this aspect also, consider the application to be filed by the appellant plaintiff before the trial court while seeking the relief of defendant number 18.
Till such time, let the
Accordingly, the
parties
same is
maintain.
disposed of.
Till such time, let them maintain status quo. They are about to sell it to third parties.
That I am allowed, filed only the defendant number
Yeah,
1
is
to
against
17.
The defendant number
You
1
have
to
to
18.
have filed the IA
Status
against.
file ಮಾಡಿ ನೀವು ಅಷ್ಟೇ ಅಲ್ಲಿ. You file an application, they're there. Already defendant number 18 party ಇದ್ದಾನೆ.
Party ಇದ್ದಾರೆ,
ಹೇಳಿ.
statement ಹಾಕಿದ್ದಾರೆ.
50. Srivatsava HK,
ಇವತ್ಸವ.
V Anand,
Order 9 rule 13 dismissed. ಕರ್ಕೊಬರ್ಬೇಕು 4 ಗಂಟೆ. ಇಲ್ವಾ? ಬಸವ, next.
51 Hudson,
Anil Kumar Hutchesson.
52. 51 Hudson ಆಗಿದೆ.
This is. Defendant's appeal, my lord. Defendant's appeal, my lord. Kindly pass it over, my lord. Senior.
ಅವ್ರಿಗೆ senior ಇಲ್ಲ. ಕಳ್ಸರಿ ನೀವೇ ಟೈಮ್ ಕೇಳಿದಿರಿ.
Same ನಾನೇ time table. We are ready.
ಎರಡೇ ದಿನ. ಇಲ್ಲಿ ಕೋರ್ಟಿಗೆ ಟೈಮ್ ಇರ್ಬೇಕಲ್ಲ, 2 ದಿನ ಕೊಡಕ್. ತಗೊಳ್ಳಿ. Appellant counsel seeks for passover and counsel for the respondent submits that senior counsel is not in station. List this matter on ಯಾವಾಗ್ಲಾರು ಕೊಡಿ ಮೇಡಮ್, next week ಅಲ್ಲಿ.
2711.
2711.
53 Vijay Kumar K.
A1 allowed.
Appellants, my lord.
ಏನ್ರಿ not to
This-
alienate ಅಲ್ವ ಇರೋದು?
Lord, not to alienate. Earlier, my lord, is
Urgency ಏನು?
plaintiff's mother earlier.
ಸರ್ವ್ ಮಾಡ್ಕೊ ಬನ್ನಿ ಅಷ್ಟೇ.
Urgency is only one regard, trial court committed an error. Earlier, mother of the plaintiff filed a suit for partition. It was compromised. Property share was allotted. Again, the son has come and after demise of mother, son has come and filed this partition suit suppressing of and saying that the compromise is not,
Whether he was a party to the compromise or.
mother is a party to the compromise.
Mother.
Mother,
Ah.
because mother share because plaintiff mother, my lord, is claiming as a daughter of their, her father, claim a suit for partition has filed. In the partition suit, the parties have entered into a
ಡಾಟರ್ ಹಾಕ್ದಾಗ ಸೂಟಲ್ಲಿ ಯಾಕೆ ಇವನ್ ಯಾಕೆ ಪಟ್ಟಿ ಮಾಡ್ಲಿಲ್ಲ?
ಅಲ್ಲ ಇವ್ರು ಅವ್ರ ಮಕ್ಕಳಿಗೆ ರೈಟ್ ಇಲ್ಲ, ಡಾಕ್ಟರ್ ಬದುಕಿರುವಾಗ ಅವ್ರಿಗೆ ಸನ್ಸ್ ಬರೋದಿಲ್ಲ. Because
ಡಾಕ್ಟರ್ ಮಕ್ಕಳ.
daughter sons, the plaintiffs are the daughter sons.
ಮದರ್ ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್.
Mother already filed a suit for partition.
Ah.
Compromise was entered.
Ah.
Certain properties were allotted to the share of the mother. That was compromise was ended. It
Ah.
is acted upon.
Now son comes.
Son saying that the compromise is not null and void and not binding on them.
Not binding.
Not binding on them.
ಅದೇ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು, ಸಪರೇಟ್ ಸೂಟ್ ಹಾಕಕ್.
That is one of the legal aspect I took a ground. That was not considered. Court held that my lord is not to alienate the property.
The appellant counsel and counsel would submit that the mother of the plaintiff already filed a suit and obtained an order of suit filed for partition and the same has been compromised. And now the respondent oblique plaintiff challenging the earlier judgment and decree of compromise. And also submits that he cannot file an independent suit. He can file necessary application before the very same court in view of the judgment of Trilokinath case of the apex court reported in 2020. And taking into note of the said the judgment as well as the grounds which have been urged in the appeal memo, interim order granted by the trial court not to alienate is state till next state of hearing. Appellant counsel is directed to serve the copy of this appeal memo on the counsel who appeared on behalf of the respondent before the trial court and also pay the process. And
Notice, my lord, is
issue notice against respondents.
respondent 2 to 8 and 10 kindly may be dispensed. I have stated in my appeal memo notice.
Appellant counsel in the appeal memo itself stated that a notice may be dispensed against
Respondent 2 to 8 and 10.
2 to 8 and 10.
10 because plaintiff is only respondent number 1.
2 to 8. 2
And
to
10th.
8 and 10.
10th respondent.
10.
Yes, ma'am.
And hence the notice against them is dispensed. Issue notice against R1 and R9.
R9 only, my lord.
R1 and R9.
They are sons of that. Grateful.
This date ಕೊಡಿ ಹೋಗಿ ಬರಲ್ಲ ಇಲ್ಲ ಬರೋದೇ ಇಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರ ತಗೊಂಡ್ಮೇಲೆ 16/12.
54.
ಇವೇನ್ರಿ
Yes, my lord. Yes, ma'am.
ಎಂಟ್ರಿ ಮಾಡ್ರ ತಗೊಂಡ್ಮೇಲೆ
Correct,
ಬರೋದಿಲ್ಲ.
yes. It is great, always so.
54.
Hmm.
Rangaswamy MD.
I'm appearing for appellant. Your
Swami MD B Pramod ಹೇಳಿ.
Appearing for respondent,
Huh?
please,
ASI dismissed ಹೇಳಿ ಮೇಡಮ್.
the short accommodations. My senior is
Okay.
engaged in court.
Respondent counsel seeks time. Finally 2 weeks time granted.
pay for stay order, my lord.
Stay order. ಏನ್
Because
stay
the-
ಮಾಡ್ಬೇಕು?
Because the bankers have already freezed the account. My client
Freeze
is
ಆದ್ಮೇಲೆ
not able
ಮತ್ತೇನಿದೆ?
to operate
stay
the account,
ಮಾಡಕ್ಕೆ?
your honor.
ಫ್ರೀಸ್ ಆದ್ಮೇಲೆ ಸ್ಟೇ ಮಾಡಕ್ ಏನಿದೆ ರೀ?
ಇಲ್ಲ, so that,
ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೇನಿದೆ ಸ್ಟೇ ಮಾಡಕ್ಕೆ?
so that honorable court give direction to the ESIC to reopen the account. my lord.
Appellant filed by the applicant and is hereby dismissed. ಹಾ. ಏನ್ ಸ್ಟೇ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
To stay the operation of the ESI 56 of 2000.
ESI court order
Yes, my lord.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅದನ್ನ ಸ್ಟೇ ಮಾಡಿ ಏನ್ ಮಾಡೋದು ಅಂದೆ?
ಇಲ್ಲ, so that we can operate the bank account, my lord.
Next week. Respondent counsel seeks time and counsel for the appellant present list this matter on Next week, next week, 6/12,
6/12.
6/12.
55, Murthy came, which is Ramamurthy.
Last time when appellant counsel settlement ಅಂತ ಏನೋ ಹೇಳಿದ್ರು, ಏನಾಗಿದೆ ನೋಡ್ರಿ?
Settlement.
Allowed putting up of construction, ಆಗ್ಲಿಲ್ವಾ settlement? ಆಗ್ಲಿಲ್ಲ?
Settlement.
ಆಗ್ಲಿಲ್ಲ, ಹೇಳಿ. ರೆಡಿ ಇದೀರಲ್ಲ? ಹಾ.
But the appeal. The plaintiffs.
Not to put up construction ಅಂತಿದೆ.
Not to both higher number 1.
ಎರಡು ಇದೆಯಾ?
ಎರಡು ಇದೆ.
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡೋದು ಒಂದೇ ಅಲ್ವಾ?
Common order ಆಗಿದೆ,
ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀರಾ, ಆಯ್ತು, ಹಾ. ಬಟ್ ಅಲೋ ಆಗಿರೋದು ಒಂದೇ ಅಲ್ಲ?
ಐ ನಂಬರ್ 2 only.
ಐ ನಂಬರ್ 2 ಒಂದೇ ಅಲೋ ಆಗಿರೋದು. ಮತ್ತೆ ನಮಗೆ ಡೌಟು, ನಾನು ಬರ್ಕೊ ಬಂದಿದ್ದೀನಿ ಅದಕ್ಕೆ ನೋಡಿ ಆರ್ಡರ್ನ. ಹಾ.
While between order it is considered both the areas. It's taken up number 1 and 2 for consideration.
ಇಲ್ಲ ರೀ, ಐ 2 ಮಾತ್ರ ಕನ್ಸಿಡರೇಷನ್ ತಗೊಂಡಿರೋದು. ನಿಮ್ಮ ರಿಲೀಫ್ ಏನಂದ್ರೆ ನಾಟ್ ಟು ಪುಟ್ ಅಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್. ಹೌದಾ? ಅದೊಂದೇ ಐ
ಅನಕ್ಷರ ಡಿ
ಆರ್ಡರ್ ಇರೋದು ಒಂದೇ.
ಹೌದು.
ಅನಕ್ಷರ ಎ.
That the plaintiff filed the suit for declaration. To declare page number 36 my lord. Yes. Thank you, my lord. Both father and the son have filed a suit against the defendants number 1 and 2. And sought to declare that the Alice will be dated 22/6/2020 executed by defendant number 1 in favor of defendant number 2 declared as null and void. And further to grant mandatory injunction directly to police not to demolish illegal structure made by them in the true property at the cost of own. And or the alternative permit the plaintiff to demolish illegal structure put up by the defendants defendant. And for permanent injunction such as the relief they sought. Contention of the plaintiff, my lord, page number.
You have purchased the property in the year 1988 ಅಂತ.
88. ಅವ್ರ ಪ್ರಕಾರ ಅವ್ರು ಖರೀದಿ ಮಾಡಿದ್ರೆ from my father and my uncle, my senior uncle. That is the contention.
ಅಂದ್ರೆ purchase made by the father and senior uncle.
Father and uncle of first defendant. The defendant number 1 and 2 are the husband and wife. They are narrated in page number, my lord, number 4 of the frame, page number 24. That the land in survey number 145/1 measuring 1 acre 17 kuntas belongs to.
Originally it was a grant.
Yes, no, it is purchased. It's purchased by A.K. Venkatappa. A.K. Venkatappa having 2 children, my lord. Muniyappa and Krishnamurthy. Both divided under the registered partition in 1970, my lord. That is on 7/6/1974, car number 7 in the frame. So under the said partition, both got 28% of kuntas each. And thereafter, both Muniyappa and Krishnamurthy separated way back in 1974, my lord. Thereafter, the plaintiff claims that they purchased the property, para number 8, my lord, on 20th July 1988 from both the persons. From Muniyappa and Krishnamurthy. But after they claims that after the partition in 1970, between 2 brothers, the plaintiffs claims to have purchased the property in the year 1988. Because after the partition between both brothers, my lord, both cannot join and sell the property. And according to the plaintiffs, my lord, from 20th July 1988 till date, till filing the suit, my lord, in 23, they are in possession of the property by putting up construction and doing some business. They period, etc., etc. And in the meantime, my lord, the partition suit between the LRs of Muniyappa, 2 brothers, that also pending in 4/9/2015.
ಅಂದ್ರೆ subsequent to the selling of the property, they filed a suit for partition. 15. Though they sold the property in the year 1988 itself.
They have not sold the property, they have set up a sale deed because they pleads in the plaint, my lord, 88 in the Iliver, till filing the suit 23. They are in possession of the property.
ಅದೇ plaintiffs ಅದು.
Plaintiff's case.
ಆಯ್ತು.
They are not at all in possession of the property, my lord, but it is some 13 kuntas of land has been acquired for the purpose of formation of road in the area measuring 1 acre 17 kuntas. And the remaining portion is in the possession of the defendants, my lord. Defendant number 1 is the son, 2 is the wife.
he gifted the portion of the property, which that is the suit property they have made. So under, no, the suit property has been, according to them, the suit property has been purchased in the year 1988, according to them. From 1988, my lord, till 2023, my lord, they are not at all in possession of the property. Nothing is placed before the court to prove their possession, either electricity bill or any other document. And also for, they have stated they are doing business in the premises. Nothing is placed before the court. So just they rely upon the sale deed of the year 1988 and files a suit for declaration to declare this gift deed without seeking possession. To declare that the gift deed is 2020 is null.
Gift deed executed by D1.
Even in
Favor of D2. What was the rate D1 was having?
D1 is the son of Krishnamurthy, my lord.
Son of Krishnamurthy.
Ancestral property, Kata is standing in the name of the first defendant.
But already Krishnamurthy executed the sale deed in the year 1988 itself.
ಅವರು 1974 ನಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ತಾರೆ ಕೃಷ್ಣಮೂರ್ತಿ ಮತ್ತೆ ಮುನಿಯಪ್ಪನಿಗೆ.
ಹೌದು.
ಮುನಿಯಪ್ಪ ಮತ್ತೆ ಕೃಷ್ಣಮೂರ್ತಿ ಅಣ್ಣ ತಮ್ಮಗಳು ಭಾಗ ಆದ್ಮೇಲೆ 88 ಅಲ್ಲಿ how can both join for sale transaction in favor of the plaintiff, my lord?
But there is a sale deed.
There is a sale deed, it is created, sale deed, no possession, no document. You are in possession, admittedly the plaintiffs admit my possession from 1970, my lord. Day one A.K. Venkatappa acquired the property.
How they admits? Where is the admission? Admission?
Yes.
Plaint itself.
Yes, my lord. Plaintiff car number, my lord, 3-4, my lord.
Page number?
Page number 24, my lord.
24
ನಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇದು A.K. Venkatappa ಸೇರಿರ್ತಕ್ಕಂಥದ್ದು. He acquired the property through abolition. Thereafter, my lord, car number 5 ನಲ್ಲಿ A.K. Venkatappa having 2 children. And in car number 7 ನಲ್ಲಿ Swami, fourth line, they plead partition between A.K. Venkatappa and wicked persons A.K. Krishnamurthy and V. Muniyappa. They plead partition on 7/6/1974. Under the said partition, my lord, 28 ವರೆಗೂ ವೆಂಕಟಪ್ಪನವರಿಗೆ 28 ವರೆಗೂ ಕೃಷ್ಣಮೂರ್ತಿ ಅವರು ಬಂದು ಹೇಳ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ ನಂಬರ್ 8 ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಇದು ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡಾದ್ಮೇಲೆ ಇವರು 45
is it registered partition?
Yes, my lord. ಅವರೇ ಹೇಳ್ತಾರೆ ರಿಜಿಸ್ಟರ್ಡ್ ಕರೆಕ್ಟ್ ಮೇಲೆ ಇಟ್ ಇಸ್ ರಿಜಿಸ್ಟರ್ಡ್, ಇಟ್ ವಾಸ್ ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟಿಷನ್. ಆಮೇಲೆ ಅವರು ಇನ್ನೊಂದು ಹೇಳ್ತಾರೆ ಕನ್ವರ್ಷನ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಕನ್ವರ್ಷನ್ ಇಸ್ ಬಿಕಾಸ್ ತಹಸೀಲ್ದಾರ್ ಕನ್ವರ್ಷನ್ ಕೊಟ್ಟರು ಅಂತ ಹೇಳ್ತಾರೆ. ಇಟ್ ಇಸ್ ಇನ್ಕರೆಕ್ಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ನಾನು ನಂಬರ್ 8 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅವರು 27/28 ಖರೀದಿ ಮಾಡಿದೆ A.K. ವೆಂಕಟಪ್ಪ ಮತ್ತೆ A.K. ಮುನಿಯಪ್ಪನವರಿಂದ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವರೇ ಹೇಳ್ತಾರೆ ಪಾರ್ಟಿಷನ್ ಆಗಿ 74ರಲ್ಲಿ ಹಿಂದಿನ ಪ್ಯಾರಾದಲ್ಲಿ. ಒಂದ್ಸರಿ ಪಾರ್ಟಿಷನ್ ಆಗಿ 28 ಗುಂಟೆ ತಗೊಂಡಾದ್ಮೇಲೆ ಮುನಿಯಪ್ಪ ಮತ್ತೆ Krishnamurthy. Again, how can they join both the plaintiff and Muniyappa
together?
Sell the property in favor of plaintiff. So that is my very contention that that sale deed, whatever the sale deed of the year 1988 is not at all acted upon.
Created anta.
Yes, we are in possession of the property admittedly, and they are not sought for any possession and declaration. Based on the sale deed of the year 1988, they have set up twice a suit in 23. For my family necessities, my lord, because except this land, there is no other property. So only in order to build up a land to avail a loan and all other document purpose, we gifted the property. The first defendant gifted the property to second defendant, his wife, my lord. We are in possession. It is an electricity connection and revenue documents are in the name of the first defendant.
Electricity connection ಅಂದ್ರೆ ಏನು? ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಏನ್ ಮಾಡಿದಿರಿ ನೀವು? ಶೆಡ್ ಇದೆಯಾ? ಯಾವಾಗ ತಗೊಂಡಿದ್ದದ್ ನೀವು? ನೀವ್ ಯಾವಾಗ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್ ತಗೊಂಡಿದ್ದು ಅಂತ ಕೇಳಿದ್ರೆ
taken back long back, my lord, after partition, because our by the first defendant born and part of there itself. Even his parents were staying there. So no, my lord, the granting of the temporary injunction, because except this property, there are no other property, not to put up construction and the ಕೊಟ್ಟಿದ್ದಾರೆ. So it is totally incorrect. Because now the construction existing in the suit property is in relapilation condition. Because I have to put up, put up construction for residential purpose.
Yes, consolidate.
Sheet money ಇದೆ.
Right.
I would like to, I would like to take minutes, para number 9 of the minutes, trial court order minutes, page number 18.
Inter
Order of the trial court.
trial court, my lords.
Paragraph number
9, my lords.
9.
Nine. Running page, my lords, 18. Shall I read, my lords? The documents produced by the plaintiff show that the Krishnamurti and his brother Muniappa undisputed at the point of time executed a register sale deed in favor of 27/1988. In respect of the suit scheduled property in favor of the plaintiff, the recitals of the sale deed would shows that the survey number 45/1 was converted to the residential purpose by so and so on 15/7/1997, and defendant disputed this document stating that the father and uncle have not executed any signatures or belongs to them. Mere denial of the execution of the sale deed prima facie does not take away the effect of the rights registered document under section 49 of the Registration Act. The sale deed is still in force. It is not being set aside. It is in 30 years old document. It is researchers of the presumed to be presumed true under section 90 of the Evidence Act. Next, insofar as position is concerned, it is made clear. Para number 2. The plaintiff is based on the sale deeds. The kata was been expected from the obtained from the from and then the Banaswadi Group Panchayat and RTC in respect of the survey number 45/1 for year 1987-19 would be show that the endorsement in column number 11 regarding to the conversion of the land in question was converted in the
property convert agir matte RTC bartade.
Yeah, group
record recitals of the sale deed would show that in 1988 sale deed
1988 sale deed
there was a reference that property was converted for residential purpose with order dated ALN SR 1662 of 1970-71 dated 15/7/1970. Alva?
The reference would be
Nimma prakara sale deed property was converted long back in the year 1970 itself. Then how once again it will be RTC
it is indicated in the RTC and ತೋರಿಸಿದೆ.
RTC ಬರುತ್ತೆ ಅಂದೆ.
There was that point of time there was a group panchayati malars.
Right.
And so endorsement column number so soon. The plaintiff is appraised to be in a position of the scheduled property. Based on the sale deed, have leased property on 4/4/2017 in favor of the Narayana Education Society for subsequently the extent of the BBMP limits. The suit scheduled properties comes on within the jurisdiction of the BBMP. The BBMP kata is in name of the plaintiffs. The taxpayer receipts would shows the names.
Property lease ಮಾಡಿದಕ್ಕೆ ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ?
ಹಾಕಿದೆ 4/4/2017 we have entered into
registered unregistered
and unregistered lease agreement and taxpayer receipts would shows the names of the the defendant number 1 and 22/6/2020 executed a gift deed in favor of the Srimati Roja, that is defendant number 2 and minutes. The defendant number 1 has also filed suit invoice number 429 for 2020 for partition in which the plaintiff is got implicated in the suit. The suit is internal matters only in the family members of this the defendant number matters. That suit is also came to be dismissed recently matters. And matters para number 11 matters. The defendants produce the documents with the list of the document on 29/7/2024. The copy of the complaint and taxpayer receipts. They have also relayed the photographs. The endorsement issued by the revenue authorities. In respect of the non-existing the kata in the name of the plaintiffs. However, it is also observed that in the year 1988, when the sale deed is executed by the defendant number 1, the father and uncle in favor of the plaintiffs, the defendant was not at all born. As per the cast title, the age of the first defendant and the defendant is 30 years in the year 2022. Prima facie, the plaintiffs are owners in position in suit scheduled property. The defendants are claiming right on the basis of the revenue records, which are not at all the title document. The father of the defendant number 1 has already parted with the suit scheduled property in favor of the plaintiff. The prima facie defendant have no right over the scheduled property. The defendant in written statement have not stated subsequent sale deed executed in favor of the Manoharas. Let's do in the pendings of the suit. The defendant number 1 and 2 has jointly executed a sale deed in favor of the third party. In Manohar, there is clear suppression of the sale deed. The written statement was filed by the defendants on 16/11/2023, whereas the sale deed as executed in the year 12/10/2023 was executed by the defendant number 1, 2 and Roja P in favor of the Manohar. Yes, therefore, if the said sale deed is taken into consideration, defendant number 1 and 2 prima facie has no right over the scheduled property. During the pendings of the suit, the suit is came to be dismissed. Even during the pendings of this suit, without there being any right over this property, the defendant number 1 and 2 have created a gift deed in basis of the saying that they are the owners of the property. Behind the back, they have been entered into the sale deed with the Manohar without there being a made them as a party. And more so, my lords, when they're supposed to be filed a written statement before the trial court, they did purposefully suppress the material facts, my lords. And my lords, conclusion para, my lords. The affidavit of plaintiff a document which shows the plaintiff was trying to put up a construction in the suitable property belongs to the plaintiff. During the pendency of the suitable property, it has to be maintained the status quo or else the leads the multiplicity of the proceedings. The plaintiff has made out to prima case, the balance of convenience lies in favor, their favor. If the order temporary is not ordered to be plaintiff would put the ordership, they are also purchased the suit in the year 1988. From the father, defendant number 1, uncle, when the defendant was not at all born. Therefore, the claim of defendant, they are owners of the owners is not acceptable. Hence, the answer is the point of view so and so affirmative. The suit, a property which has been claimed by him was enacted in the 1988 minutes according. He was not at all been born. And second aspect is not they are not in position. From the date of the purchasing of the sale, I was put forth in the position. I was put up a small shed over there. I was residing there only. Now, certain land was lease let out on a lease. That is not in disputed. Now, on the basis of this, creating a multiple litigations, the willfully now they have been executed the sale deed during the pendency of the all these two suits in respect of the one Manohar. Therefore, he has not made out a prima facie case. It's a question of fact which has to be decided by the court below. Therefore, whatever the order has been passed by the court below, there is no infirmity of the order.
You gifted angry execute ಮಾಡ್ಕೊಟ್ರಿ 22/6/2020 in favor of Srimati Roja.
Suit is came to be decided.
Purpose is to in order to avail loan to build a construction to purpose of availing loan to improve the property. But it is they have produced 3 documents before the court. One is sale deed of year 1988. Another may not group panchayat Pata certificate. Another one is conversion order.
Again, right here, first gift ಮಾಡ್ಕೊಡಕ್ಕೆ. Already there is a sale deed ಅಲ್ಲ.
Sale deed
88.
ಅಲ್ಲ sale deed ಅವ್ರು ಮಾಡ್ಕೊಂಡಿರ್ತಕ್ಕಂಥದ್ದು ಅವ್ರು ಗೊತ್ತೇ ಇಲ್ಲ.
ಮಾಡ್ಕೊಂಡಿರತ್ತ ಅಂದ್ರೆ 88 ಸೇಲ್ ಡೀಡ್ ಈಗ ನೀವು 30 ವರ್ಷದ ಮೇಲೆ
88 ಇಂದ ಇಲ್ಲಿವರೆಗೂ
ಕ್ರಿಯೇಟೆಡ್ ಅಂತ ಹೇಳೋದು ಏನ್ರಿ ಇದು
Suit is dismissed.
ಅವ್ರು ಹಾಕಿದ ಸೂಟ್
That is only internal family matters.
He was admitted to the hospital. He could not appear before the court to render his evidence. Dismissed for default. But now sale deed now 88 sale deed ಪ್ರಕಾರ ಅವರು they are not at all exercise their right, my lord. 98 ರಿಂದ 23 ವರೆಗೂ admittedly the impugned order refers only 3 documents: sale deed, group panchayat khata, 1 single khata, my lord, and another conversion order. Tahsildar issue ಮಾಡಿರೋದು. In fact, Tahsildar has no power to issue such conversion order for agriculture property. And moreover, non ಮಾಡ್ಕೊಡ್ತಕ್ಕಂಥ ಉದ್ದೇಶ if they only to develop the property. ಅನ್ನೆಸರಿಗಿದ್ರೆ ಇದು ಬ್ಯಾಂಕ್ ಲೋನ್ ಕೊಡೋದಿಲ್ಲ. ಹಾಗಾಗಿ ನಾನು for my own self occupation ಮೇಲೆ I want to build a residential structure. ಈಗ now there is a small
ಪ್ರಾಪರ್ಟಿ ಲೀಸ್ ಮಾಡಿದ್ರಲ್ಲ 2017 ಅಲ್ಲಿ
2017.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ನಿಮ್ಮ
Lease documents has been placed before the trial court. Lease document has been placed before the trial court. ಹಾಕಿದೆ.
BBMP ಖಾತಾ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಇದೆಯಾ?
BBMP khata is stands in my name. Since from the date of purchasing the property, even till today I have been possession
ಇದೆ ದಾಖಲೆ ಅದು ನೀವು ಹಾಕಿದಿರಾ?
trial court ಅಲ್ಲಿ ಹಾಕಿದೆ. I was placed all the documents.
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರಿ, ಇಲ್ಲ ಹಾಕಿದಿರಾ?
ಇಲ್ಲ ಹಾಕಿದೆ. That's up to date taxpayers also been placed. The khata minutes.
ಖಾತಾ ಬಗ್ಗೆ ಎಲ್ಲ ರೆಫರ್ ಮಾಡ್ತಾನೆ ಇಲ್ಲ impugned order.
That's agreement also been there.
ಎಲ್ಲಿದೆ ನೋಡಿ, ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಇಲ್ಲ ಇದರಲ್ಲಿ
ಖಾತಾಗಳೆಲ್ಲ
khata is there.
heard the appellant counsel and also the counsel appearing for the respondent. This appeal is filed challenging the order passed on A number 2 of 23 wherein in restraint order has been passed against the defendants putting up any construction over the suit shall property in any manner pending disposal of the suit. The main case of the plaintiffs before the trial court that they have purchased the property in the year 1988. And also it is their case that before purchasing the property and the same was also converted and there was a reference in the sale deed order passed by the Tahsildar with order dated ALN SR 1662 of 1970, 71 dated 15/7/1970. That is prior to selling of the property. And also content that defendants are disputing the said document of execution of the sale deed. And also content that the property now comes within the purview of BBMP, and BBMP Kata is also issued in the name of the plaintiffs, and they are paying the tax, and also the tax proceeds, tax paid receipts would shows the name of the plaintiff. And also it is contended that defendant number one created the document of gift deed and also filed a suit in OS number 429 of 2015 for partition. And in that suit also the plaintiff got impleaded in the said suit, and ultimately the said suit dismissed. The counsel contend that the plaintiff also contend that the trial court taking note of dismissed when the defendant tried to interfere with possession and also makes an attempt to put up the construction, filed the suit for the relief of injunction or
Declaration,
declaration, and
by
also
virtue of the matter is sale deed.
inter-alia sought for the relief of temporary injunction not to put up the construction. The defendants appeared and filed their written statement contending that the document of sale deed dated 27/1988 is created document. And the very contention that property was leased in favor of
Narayan Educations.
Narayana Techno School and monthly rent. And property
Portion of the land, my lord.
property stands in the name of the plaintiff is not correct, and nothing on record. And also counsel would submits that once there was a partition long back and divided the same 28.5 kuntas each. Question of executing the sale deed jointly in the year 1988 doesn't arise. The trial court fails to take note of the said fact into consideration and committed an error in passing an order of not to put up the construction. The council also would submit that gift deed also executed in favor of Srimati Roja for the development of the property and ought not to have granted the relief of temporary injunction not to put up the construction. And trial court committed an error in coming to the conclusion that plaintiff has made out the prima facie case. The counsel appearing with the respondent would contend that trial court taking into note of the pleadings as well as sale deed of the year 1988 and also taken note of the said document is a registered document and the same has been questioned now after 30 years, stating that the same is a concocted document. And all the documents which have been placed before the trial court discloses the property stands in the name of the respondent plaintiff, and considering the same comes to the conclusion that there is a prima facie case and it doesn't require any interference. Having heard the appellant counsel and also the counsel appearing for the respondent, it is not in dispute that originally property belongs to one Sri, Venkayan.
Venkatappa.
Venkatappa.
A.K. Venkatappa.
In total area of 1 acre 17 kuntas belongs to him. Thereafter, two children of Venkatappa, that is Krishnamurthy and V. Muniappa, partitioned the same, dividing the same 28.5 kuntas on 7/6/1974. The plaintiff claims that they acquired site number 8 measuring east to west 67 feet and north to south 40 feet from V. Krishnamurthy and V. Muniappa by way of registered sale deed. And also it is their claim that all the property stands in the name of the plaintiff, and the appellants herein made an attempt to put up the construction and hence approach the court. The main contention of the appellant public defendant before the trial court that the said document of the sale deed of the year 1988 is created and concocted, and admittedly the said document was registered. And also the mere denial of the execution of the sale deed is not enough and the document was executed in the year 1988. And the same has not been cancelled. And apart from that, based on the sale deed, the kata also stands in the name of the plaintiff and the same is also taken note of the trial court by in paragraph number 9 and paragraph number 10. And also taken note of the suit filed by the defendant in OS number 429 of 2015, wherein also plaintiff got impleaded as plaintiff in the said suit. And apart from that, counsel appearing for the respondent also placed the submits that OS 429 of 2015 was dismissed when the plaintiff did not lead evidence in the said suit. It is important to note that while granting the relief of temporary injunction, court has to take note of cardinal principles of prima facie case, balance of convenience and hardship. And document of 1988 clearly discloses that there is a sale deed. No doubt, the plaintiff has filed the suit for the relief of declaration and questioning the gift deed executed by the first defendant in favor of defendant number 2 on 22/6/2020. And main contention of the defendant that right is an ancestral property and disputed the earlier sale deed and executed the gift deed and not disputed the same. And also the relief sought by the plaintiff mandatory injunction ಕೇಳಿದಿರಲ್ರಿ
Mandatory injunction.
ಮಾಡಿದಾರಂತ ಅವರು
Mandatory injunction, mandatory injunction.
Huh?
No, not similar. Portion of the land, means now what they are doing, by basis of the means this sale deed, the defendant number 1 and 2 colluded each and other. Now they have subsequent to pending of the suit means they have been entered into sale deed means. That is the only reason which I.
Your own prayer is for
Prior, mandatory injunction came. Portion of the land, now they are trying to,
that you are not in possession of the property.
portion of the land
ಏನಿದೆ
now.
ಪೋರ್ಷನ್ ಅಂತ ನೋಡಿ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ನೀವೇನೋ ಎ ಶೆಡ್ಯೂಲ್ ಬಿ ಶೆಡ್ಯೂಲ್ ಅಂತ ಏನಾದ್ರು ಮಾಡಿದಿರಾ ಇಲ್ಲಲ್ಲ
Whatever the means vacant land which has been left out by me means.
And also sought for the relief of mandatory injunction directing the defendants to demolish the illegal construction made by them in the social property at their cost and risk, and further direct them to hand over the vacant possession to the plaintiffs or in alternatively permit the plaintiffs to demolish the illegal structure put up by the defendants in the plain scheduled property. And having taken note of such relief, it is very clear that the plaintiffs are not in possession of the property and sought for the relief of mandatory injunction. And also the contention of the defendant that they are in possession. But relief is sought not to put up the further construction. And when the document of sale deed is produced before the trial court, that there was a sale deed of the year of 1988, 27/1988. Documents are also stands in the name of the plaintiff. If further construction is permitted, it will leads to the multiplicity of proceedings and whether plaintiff succeeds for the relief of mandatory injunction also to be considered. And if further construction is made, it will affect the rights of the plaintiff also. And trial court also having taken note of the registered document, which is more than 30-year old. Taken note of the registered document and the same has not been cancelled and no such relief is also sought by the defendants disputing the sale deed of the year 1988. And now only contend that the same is a created document. ನೀವೇನು ಸೂಟ್ ಹಾಕಿಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಕ್ಕೆ ಏನು ಹಾಕಿಲ್ಲ. And when such being the case, I do not find any error committed by the trial court in granting the relief not to put up further construction in the suit scheduled property. And when the suit is also filed for the relief of declaration by the plaintiff and it requires trial. And hence I do not find any error committed by the trial court in granting the relief of not to put up the construction in the suit scheduled property. In view of the discussion made up, I pass the following order. Appeal is dismissed.
56. Somshekara came.
Pay for the appellants. Lord, this miscellaneous petition was dismissed for restoration of suit. Exported decree was passed in favor of respondent number 1.
I also dismissed. I dismissed and consequently.
Consequently, miscellaneous petition is also dismissed on the ground that
ಆಯ್ತು original suit ಅಲ್ಲಿ ನಿಮಗೆ ಸರ್ವಿಸ್ ಆಗಿತ್ತಾ ಇಲ್ಲ?
after service he filed return statement also.
ಯಾವಾಗ ಅದು ಯಾವಾಗ ಸರ್ವಿಸ್?
Lord,
ನೀವು ಡಬ್ಲ್ಯೂ ಎಸ್ ಹಾಕಿದ್ದು ಯಾವಾಗ?
Lord, Wakalat filed on 9/3/2011. 9/3/2011.
2011.
Yes, my lord.
ಹಾ.
6/7
ಫೈಲ್ ಮಾಡಿದ್ದು ಯಾವಾಗ?
6/7/2011.
6/7/2011. ಆಮೇಲೆ
9/8/2011 issues are framed.
9/8/2011 issues. ಹಾ.
Thereafter, my lord, D1 to 7 were placed export and 3/7/2012.
D1 to
7, the governments,
export ಏನ?
they were placed.
ನೀವ್ ಎಷ್ಟನೇವ್ರು?
Now 8 and 9.
8 and 9. ಹಾ. ಹಾ.
Lord, then, Lord,
ಎಕ್ಸ್ಪೋರ್ಟ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆನೆ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಆಯ್ತಾ?
now, on the basis of return statement filed by 8 and 9, issues are framed. They are the defendant number 1 to 9 are the governments.
1 to 7 ಇರ್ಬೇಕು.
1 to 7 are the governments.
Ah.
Subsequently, my lord, 6/6/2012 plaintiff examined as PW1.
6/6/2012.
12 million.
ಹಾ.
Again, my lord, 25/1/2014, plaintiff filed application for return of documents exhibit P1 and P2.
ಆಯ್ತು.
Thereafter, my lord, plaintiffs file application on 6/1/2015 for production of additional documents under order 7 rule 14.
ಆಯ್ತ್ರಿ, ನೀವು ಹಾಕಿರೋ WS 2011.
House.
11 ಇಂದ ಸೂಟ್ ಡಿಗ್ರಿ ಆಗಿದೆ ಯಾವಾಗ?
Decree, my lord, 34/2015.
15.
15.
ಮತ್ 15 ಅವ್ರಿಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
Lord, after filing return statement, my lord,
ರೀಸನ್ ಏನ್ ಹೇಳಿ?
some reason due to communications gap between the advocate, my lord,
communication?
after filing return statement, my lord, till return statement, my lord, we are contacted.
Aye.
After, my lord, cross examination
It's
was
not your duty to see that what is
That-
the status of the case. Now you cannot blame an advocate.
we are not blaming, my lord, but he is, whenever he is called, my lord, I will inform the cross examination and presence of the defendant.
ಆಯ್ತು.
Lord, the mother-in-law is filed against the suit, daughter, granddaughter and daughter-in-law.
Whatever may be the parties.
Lord, only one suit is
You have
included.
been served, you represented through counsel and also filed the WS in
Yes.
2011, but did not participate from 2011 to 15. What is
Lord-
the ground for allowing the miscellaneous petition?
Lord, within 1 year, we have filed from the date of.
In 1 year ಪ್ರಶ್ನೆ ಅಲ್ರಿ, what is the ground for not participating from 2011 to 15?
Lord, due to advocate is not communicated to the plaintiff. My lord, other ancestral properties were not included in the suit.
Whatever it may be, counsel, whether it is right
In
or
the
wrong.
return
there is a
statement, we have
judgment
taken specific
decree.
contention.
You have filed the return statement but not participated.
In the return statement specifically taken contention that, my lord, is property, self-accord property of only one property is included. Other ancestral and other sons are not included.
ಈ miscellaneous ಹಾಕುವಾಗ delay ಎಷ್ಟು ದಿವಸ ಇತ್ತು?
1 year, my lord, from the date of judgment. Lord, we have filed miscellaneous on 22/3/2016.
ಆಯ್ತು, ನಿಮ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನೋಡಿ miscellaneous paragraph number 11 ಅಲ್ಲಿ.
She admits. Okay.
There is an admission. She admits that she has not taken any action against the council and since 2010 till November 2016, she was in contact with her counsel and the counsel used to inform her about the stage of the case due to date of the case. PW1 says he came to know about the status of the case through advocate by Sri Devraj and she met her advocate.
If one Prem
she's
Kumar is
not Prem,
representing the case, my lord, she is a village accountant in Ramnagar. The suit was filed in the, before this, the Bangalore City Civil Court.
All admissions are there. What is there?
Lord, it's not in respect of Prem Kumar. Advocate, one advocate is came and that time verified.
ಆಯ್ತ್ರಿ, ಯಾವ್ದಾರು ಅಡ್ವೊಕೇಟ್ ಆಯ್ತು, ನಿಮ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಬಗ್ಗೆ ಹೇಳಿ.
Lord,
If any,
I will admit, my lord, my negligence, my lord, but the suit itself is not.
any
made-
reason for preventing you in not
Lord is,
appearing before the
Lord,
trial court, you show me one,
after the
one
death
piece
of,
of material
after the
before
death of her husband, my lord, she is a small child. So that the second appellant now is a major. At that point of time, she is a minor and she is taking care of her father.
counsel while order 9 rule 13 exercising, you must satisfy the court sufficient reasons. Where is the sufficient reasons?
Lord, till 2015, my lord, 6/1/2015, plaintiff is recalled and re-examined also, my lord.
ಆಯ್ತು, ನೀವು ಹೋಗ್ಲಿಲ್ಲ, ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ರೀಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಾರೆ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ತಾರೆ, ನೀವೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ನೋ ಗ್ರೌಂಡ್ಸ್ ತಗೊಳ್ಳಿ.
My lord,
ಹಾ.
one opportunity, my lord, because
ಏನ್
other
opportunity
ancestral.
ಕೊಡ್ಬೇಕ್ರಿ? Opportunity
Lord,
ಕೊಡ್ಬೇಕಾದ್ರೆ
it's
you
a-
must show
Lord,
some material.
property, B scheduled property is importable, my lord, only one room
ನೋಡ್ರಿ, ಅದೆಲ್ಲ
leaving.
ನೀವೆಲ್ಲ ಬಂದಾಗ ವಿಮ್ಸ್ ಅಂಡ್ ಫ್ಯಾನ್ಸಿ ಬಂದಾಗೆಲ್ಲ ರಿಲೀಫ್ ಕೊಡಕ್ ಆಗಲ್ಲ, ಗೊತ್ತಾಯ್ತಲ್ಲ?
ಅಲ್ಲ, any
You have
cost
been
may be
served
imposed,
with-
one
Notice
opportunity.
ಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ, ಐ ವಿಲ್ ಪಾಸ್ ಎನ್ ಆರ್ಡರ್ ಸೆಟ್ಟಿಂಗ್
As third, my lord, we have filed written statement, we have
ಆ
taken
ರೀತಿ
contention
ಆಗಿದ್ದು,
that, my
ಪೇಪರ್
lord.
ಪಬ್ಲಿಕೇಶನ್ ಆಗಿದ್ದು ಅಥವಾ ಏನಾದ್ರು ಮಾಡಿ
ಇಲ್ಲ, straight away she received and immediately filed a written statement
Right,
also, my
that's
lord,
all, that's all.
contesting, my lord.
Or the appellant counsel and also the counsel appearing with the respondent. This miscellaneous petition is appeal is filed against the dismissal of miscellaneous number 312 of 2016. And the same was filed against the judgment and decree passed by the trial court in OS number 7549 of 2010. The appellant counsel in his argument would vehemently contend that the advocate did not communicate properly the stage of the suit. And also counsel would submit that before the miscellaneous court explained the reason for non-appearance before the trial court. And erroneously rejected the application filed for condonation of delay. The counsel also would submit that the miscellaneous petition is filed within 1 year from the date of judgment and decree. ಗ್ರೌಂಡ್ಸ್ ಏನು ಹೇಳಿಲ್ಲ, ಬರೀ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದಿರಿ ಅದನ್ನೇ ಮಾತ್ರ ಹೇಳೋದು ನೀವು.
She is taking care of her father and minor daughter.
Judgment 16 ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಮ್ಮ. Pen number 16 of the judgment.
ಅವ್ರು ರೀಸನ್ ಕೊಡ್ಲಿರಿ, ಇವ್ರು ಗ್ರೌಂಡ್ ಹುಡುಕ್ತಾ ಇದೀನಿ ನಾನೇ, ಏನಾರು
ಅಲ್ಲ, ಗ್ರೌಂಡ್ಗೂ ಅದಕ್ಕೂ ಅವರು ಫಾದರ್ ನೋಡ್ಕೊಳ್ತಾ ಇದೀನಿ ಅಂತ
ನಾನೇ
ಹೇಳ್ತಾರೆ.
ಹುಡುಕ್ ಬರೆಯೋಣ ಅಂತ ನೋಡ್ತಾ ಇದೀನಿ.
ಅದನ್ನು ಇಲ್ಲ.
And only during the course of argument submits that the appellant is taking care of
Father and daughter, minor.
father and daughter.
Regarding that, page number
The counsel
31.
appearing with the respondent would contend that wakalat was filed
On 9.
behalf of the defendant on 9/3/2011 and WS was filed on 6/11/2011 and thereafter issues were also framed. And the plaintiff was also examined on 6/6/2012. The suit was decreed in the year 2015, even after filing of WS after 4 years, and never participated in the proceedings. And no reasons are assigned for not appearing before the trial court. The counsel also would submit that even though an application is filed for condonation of delay and the same is also not explained and satisfied the reason, and rightly the trial court rejected the application filed on Section 5 of Limitation Act and also the and also consequently the miscellaneous petition. The trial court also elaborately discussed the same in paragraph number 15. 16. And no grounds are made out. Having heard the appellant counsel and also the counsel appearing for the respondent, not in dispute that suit summons was served on the appellant and also appeared through counsel on 9/3/2011. It is also not in dispute that WS also filed on 6/7/2011 and thereafter issues were framed 9/8/2011 itself. And the defendant number 1 to 7 are the government, and The plaintiff also examined in original suit on 6/6/2012, and thereafter an application was filed before the trial court. And even the suit was not disposed of within not disposed of in the year 2011. It was disposed of in the year 2011 after 5 years. And also the trial court, while considering the miscellaneous petition 312 of 2016, taken note of the admission given by the appellant public petitioner before the trial court, and in discussed in paragraph number 11. Each stage of the case. And also admission given by the PW1 before the miscellaneous court. Also extracted in paragraph number 15 and 16. And when considering the case, when the appellant fails to satisfy the court with regard to the non-appearance before the trial court, and question of invoking Order 9 Rule 13 doesn't arise, and appellant oblique the petitioner in miscellaneous number 312 of 2016 satisfy the trial court with sufficient cause, and unless sufficient cause is shown, question of entertaining the petition filed under Order 9 Rule 13 doesn't arise, and hence I do not find any ground to interfere with the order of the trial court.
Yesterday we filed a walkout.
The order passed on IA and rightly dismissed the petition on main petition.
Our name is not showing.
Huh?
Yesterday we filed wakalat, my lord. Yesterday wakalat ಹಾಕಿದ್ರಿ.
ನಿಮ್ಮ
G
ಹೆಸರು
Mani-
ತೋರಿಸಿಲ್ವಾ?
ಇಲ್ಲ my lord. G Manivannan. ನಿನ್ನೆ
ಕೊಡ್ತಾರಾ? ಕೌನ್ಸಲ್ ಶ್ರೀ ಏನ್ ಹೇಳಿ?
G Manivannan.
ಜಿ ಮಣಿವಣ್ಣನ್.
Yes, my lord. For R1.
Case filed ವಕಾಲತ್.
For R1, my lord.
For
Respondent
R1.
one.
And show the name of the Manivan for R1.
57, Abhishek Khuddar.
Lord, for the appellant, my lords. Lord,
Talk
suit
back.
for recovery, my lord.
ಯಾವಾಗ ಬೇಕು for want of time now, 4:52.
My lords, the execution is on 17/12. Any shorter date? Execution
17.
petition 17/12 ಇದೆ sir.
17/12.
12 ಇದೆ.
ಆಯ್ತು.
It's very short date, my kind.
Date ಕೊಡು. ಏನ್ರಿ ಇದ್ರಲ್ಲಿ? ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ನೋಟಿಸ್?
My lords, the address remains the same. He appears in the execution court as well.
Order 9 Rule 13 not served. Left the address ಇಂತ ಬಂದಿದೆ. Left the address ಇಂದಾಗ ನೀವ್ ಹೆಂಗ್ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್
No, my lords, it's not left the address, my lords.
So ನೋಡಿ,
It is out of station ಅಂತ ಬಂದಿರೋದು.
Order sheet, my lords.
Subsequent to that, we file 5 Rule 20 and paper publication is also done, my lords.
20 invoke ಮಾಡ್ಬೇಕಾದ್ರೆ what is the stage? ನೋಡಿ.
My lords, I have objections to.
Judgment also. It also says that he was placed ex parte only on paper publication. Before that notice was issued, it was not served.
My lords, on the same address, my lords, we have executed the warrant also.
The same address. He also admitted in the further proceedings that address is same. But what is the material to show that he has been served?
My lords,
Maybe subsequent admission that both are living in the same address.
we have executed it on the warrant is also executed, my lords.
Suit
When the warrant,
service ಆಗ್ದಲೆ ನೀವು ಡಿಗ್ರಿ ತಗೊಂಡ್ರೆ ಹೆಂಗ್ರಿ?
my lords, may kindly have it on the next date, my lords. I'll submit my argument.
I've read the paper. No service. You
It may be kindly
requested to the service of Order 5 Rule 20 and passed and obtained an order. ನೋಡ್ಕೊಂಡು ಹೇಳಿ ಏನಂತ?
Much of it.
ನೋಡಿ. For want of time, list this matter on
10/12.
Much obliged.
not served. Register post to left the address. ಹೌದಾ?
ಹೌದು, my lords.
Then you invoked Order 5 Rule 20, got an order, placing the appellant as ex parte. ನೋಡಿ, no grounds. Set aside ಮಾಡ್ತೀನಿ next time. ಯಾವ ಡೇಟ್ ನೋಡಿ ಹೇಳಿ. ಯಾವತ್ತು ಹೇಳ್ತೀರಿ ಹೇಳಿ ಬೇಗ.
10/12.
ಹೇಳ್ಬೇಕು, ಅವ್ರದ್ದೇನಿಲ್ಲ.
10/12, my lords. I'll argue on 10/12.
10/12. ಯಾಕೆ ಅಲ್ಲಿವರೆಗೆ ಯಾಕೆ?
Have it on Monday, my lords, 25th.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಆಗ್ಲಾರ ಕೊಡ್ರಿ.
59/11.
Much obliged.
11.
Much obliged.
ರಾಜೇಶ್ವರ್ next.
59. Ajesh Kumar.
IA2 dismissed, IA4 allowed, 39/4 allowed. Interim order was vacated. ಹೌದು, ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ? ಇನ್ನೆಲ್ಲ ಪಾಠ ಆಡಾಗರೆಲ್ಲ ಡೇಟ್ಸ್ ಕೊಟ್ಬಿಡಿ.
59.
Appearing on behalf of the appellant,
59
Yes, my lord.
ಯಾವಾಗ ಬೇಕು?
Next
Pattern.
week, may be heard next week, my lord.
ಪಾಠ ಕೊಡಿ ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಯಾವಾಗ್ಲ?
27/11.
27/11.
60. Vivek Kunna.
Lord, can I request for it to be had on Friday, my lord?
Friday na?
Friday.
This Friday.
This Friday.
ಯಾರು other side ಇದ್ದೀರಾ?
I am ready, my lords.
ತೊಗೊಳ್ಳಿ. Next date Friday? 22. Entry ಮಾಡ್ರೆ ಏನಾರು ಇದೆಯಾ?
ಇನ್ನೂ ಇಲ್ಲ sir.
22/11. 61 final hearing ಆ?
Ejectment, but
Lord, I appear,
CRP ನಮ್ಮ ಮುಂದೆ ಬಂದಿದೆ?
Lord, I appear for the petitioner in the first matter.
ಯಾವಾಗ ಬೇಕು? For want of time.
My lord, in
2014
in two cases,
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
in two cases,
ಎರಡು ವಿಡ್ರಾ ಮಾಡ್ತಿದ್ದೀರಾ?
ಒಂದು ಅವ್ರು ಮಾಡ್ತಾರೆ ಮಿಸ್ಟರ್ ಭಟ್ರು.
ಅವ್ರು ಮಾಡ್ತಾರೆ ಒಂದು ನೀವು ಒಂದು ಮಾಡ್ತೀರಾ?
ನಾವು
ಹೇಳಿ.
ಮಾಡ್ತೇವೆ, ಒಂದು ಅವ್ರು.
ಮೆಮೋ ಹಾಕಿದಾರ ಯಾರು ವಿಡ್ರಾ ಮಾಡಿರೋದು?
ನಾನು
ನಿಮ್ದು ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ನನ್ ಮೆಮೊ ಕೊಡ್ತಿದ್ದಾರೆ.
ಕೊಡಿ ಯಾವ್ದು? CRP ಯಾವ್ದು?
61.1.
Revision petitioner counsel filed memo.
SV but has to unmute. Madam. He is online.
ಅಲ್ಲ ವಿಡ್ರಾ ಮಾಡೋದಾರ ನಿಮ್ದೇನ್ ತಕರಾರು CRP ಅಲ್ಲಿ?
ಇಲ್ಲ ಇವರು SV but is online. He is there.
RFA ನಂದು RFA ನಾನು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಆಗೋಗಿದೆ.
RFA ನೀವು ವಿಡ್ರಾ ಮಾಡ್ತಿದ್ದೀರಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಮೆಮೋ ಹಾಕಿದ್ದೀರಾ?
ಮೆಮೊ ಸಪರೇಟ್ ಹಾಕ್ಲಿಲ್ಲ, ನಾನು ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಕೊಂಡು
ಈಗ ಅವ್ರು CRP 454 ವಿಡ್ರಾ ಮಾಡ್ತಾವ್ರೆ, ನೀವು
I have no objection. It is our compromise term.
memo seeking permission of this court to withdraw the same in view of compromise reported in RFA 146 of 2022 and hence permitted to withdraw. Please.
ಅದೇ RFA 146 ಅಲ್ಲಿ I have undertaken to withdraw the RFA. That may be my submission may be noted.
Oral submission record ಮಾಡಬಹುದಾ? Permission
ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ.
ತೊಗೊಳ್ಳಿ. The appellant counsel in RFA 146 ಅಲ್ಲ?
146 ಅಲ್ಲ, 61.2. 61.2. 2073.
2073 na?
ಹೌದು ಸ್ವಾಮಿ, 2073.
Appellant counsel also submits that in view of the matter settled between the parties may be permitted to withdraw the RFA 2073 of 2012. And counsel for respondent R1 is also not disclosed that there was a settlement between the parties. And in view of the oral submission made by the appellant counsel and the same is taken on record and permitted to withdraw the RFA 2073 of 2012.
Your lordship,
Much
I appear in
CRP may be listed separately.
2076 of 12. I appear for the appellant in the matter, your lordship. I have certain submissions to pray before this court as to the RFA should be allowed. A date may be fixed in that regard, your lordship.
Fix the date. ತೊಗೊಳ್ಳಿ. In remaining ಉಳಿದಿರೋದು ಯಾವ್ದಾದ್ರು ಮೇಡಮ್? ಎರಡೇ ಅಲ್ಲ?
61 plus
First CRP and RP. ತೊಗೊಳ್ಳಿ. Post of these two matters.
IA ಹಾಕಿದ್ವಿ.
ಏನ್ IA?
For withdrawal of the deposited rents ಅಂತ.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಎರಡಲ್ಲೂ ಹಾಕಿದ್ವಿ.
ಪೆಂಡಿಂಗ್ ಇರೋದ್ರಲ್ಲ?
ಪೆಂಡಿಂಗ್ ಇರೋದು.
Next week ನೋಡೋಣ ಅದನ್ನ.
ಸ್ವಲ್ಪ urgency ಇದೆ.
Because my client has to.
Other side ಯಾರು?
ಅಲ್ಲ, my client.
Other side ಯಾರು ಹೇಳಿ?
ಇವ್ರೆ.
I was having the interest in that deposited amount, my lord. In view of me withdrawing the RFA.
IA ಗೆ ಹಾಕಿದಾರಂತೆ withdrawal ಗೆ, ಅದಕ್ಕೇನಾದ್ರು ತಕರಾರು ಇದೆಯಾ?
Lord, it may be listed separately, my lord. I will get instructions. My client was a tenant. Not there was a dispute between two parties regarding ownership.
GKV Murthy ಯಾರು ನೀವಾ?
I am appearing.
Why you have not amended the cost title and non-filing of amended cost title?
Your lordship, in this matter, we are just seeking that the suit that there are connected.
Whatever it may be, madam, why you have not completed amendment and
I'll do the needful. Your lordship.
appellant counsel in RFA 2076 of 2012 is given 1 week time to amend the cost title and file amended cost title. ಆಯ್ತಾ? Counsel for the respondent. ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿರೋದು release of the amount?
ಎರಡಲ್ಲೂ ಹಾಕಿದೀವಿ, ಎರಡು ಪೆಂಡಿಂಗ್.
ಇಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಅಲ್ರಿ ಇಲ್ಲಿ? Permission to withdraw the amount ಅದ್ರಲ್ಲಿ ತಗೊಳ್ಳಿ. Respondent counsel filed IA 1 of 2024 for permission to withdraw the amount. And appellant counsel is given 1 week time to file objections if any on IA number 1 of 24. ಆಯ್ತಾ? Next, first matter ಅಷ್ಟೇ. ಇದು respondent counsel filed IA 1 of 24, CRP 234 of 2014. And counsel for appellant is given 1 week time to file objections if any on IA. And hence list these two matters on. ಒಂದು ವಾರ ಬಿಟ್ಕೊಡಿ.
Just one submission.
ಹೇಳಿ.
There is some urgency in this matter because
ಆಯ್ತು, ಒಂದು ವಾರ.
I have to pay 40 lakhs to the other person.
ಆಯ್ತು, ಇಷ್ಟು ವರ್ಷ.
Rival claims ಇತ್ತು,
ಹಾ.
80 and I am a son.
ಹಾ.
Therefore, between the two, there was a dispute now settled. In the settlement.
ಆಯ್ತು,
there-
26 ಹಾಕ್ತೀನಿ.
No, please.
List this
I'll-
matter on 26/11.
Please.
Please.
62 Tanveer Pasha. ಅಭಿನಯ್ ವೈಟಿ. ಹಾ, ನೀವಿದ್ದೀರಾ ಅಭಿನಯ್ ವೈಟಿನ?
I am there.
ಕೌನ್ಸಿಲ್ ಶಾಂತಿಭೂಷಣ್ ಹೆಸರು ಇದೆಯಲ್ಲ,
ಇದೆ.
ಅಭಿನಯ್ ವೈಟಿ ತೆಗೆದ್ಬಿಡೋಣ ಹಂಗಾರೆ.
Please.
The registry is directed to delete the name of Abhinay Vaiti and Irfana Nazir and associates since H. Shanti Bhushan appears for the respondent. Appellant counsel absent. List this matter for want of time on. Put the other date 10/12.
Wait.
63,
Praveen Kumar
Raipur.
Mahendra, Raikote. Both are absent. List this matter on 10/12.
64,
64 B.S. Raghu Prasad, M. Shiva Prakash. For want of time, list this matter on 10/12.
65,
65.
I'm appealing for the respondents, my lords, in 65.
Appellant counsel absent, respondent counsel present, list this matter on 10/12.
Much obliged.
66. Both counsels are absent, list this matter on 10/12.
67,
Yes, Chandraya, 10/12. For want of
Paper
time,
book may be served to me. I have filed NOC ಒಕ್ಕಲ.
paper book.
ಹಾ.
ನಿಮ್ಗೊಂದು ಕೊಡಕ್ಕಲ್ಲ, ಅಲ್ಲಿ ಇದ್ದ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು ನೀವಷ್ಟೇ. ನಿಮ್ಗೊಂದು ಮತ್ತೆ NOC earlier advocate ಗೆಲ್ಲ ಒಂದೊಂದು ಕಾಪಿ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ.
You have to collect it, 10/12.
Okay.
For want of time. B. Krishna Gowda, MJ Alwa. Both are absent, list this matter for want of time on 10/12.
69,
69. Sampath and Associate Janardana G. Both are absent, list this matter on 10/12.
Passover.
ಯಾವ್ದ್ರಿ ಪಾಸ್ ಓವರು?
50,
ಹಾ?
50.
ಯಾವಾಗ್ಲೂ ಒಂದು ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ ಅದ? ಹಾ.
Sorry,
50. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
Any date, my lords, your lordship.
Loksava and Order 9 Rule 13. Both counsels are present, list this matter on 10/12.
Please, my lords.
Sixty-five, my lord. So senior is not keeping well, it's in my lord Sadash Reddy. So date may fix,
ಡೇಟ್ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದೀವಿ ಅನ್ಸುತ್ತೆ ನೋಡಿ.
much of, sorry.
ಯಾರು ಫಸ್ಟ್ ಯಾರ? ಅದೇ ಅಪಲೆಂಟ್ ಬೇಕಾ ನಿಮ್ಗೆ?
AGF 6 to 6 8 ಅಂತಿದೆಯಲ್ಲ. ಗೋಪಾಲ್ ಕೃಷ್ಣ